may be seated. Let me just state for the record that it is the 29th of November, 2022. The defendant is present in court with Mr. Parker and Mr. Nash as lawyers, and the state's represented by the prosecuting attorney, Rob Junk, and by special prosecuting attorneys Angela Canepa and Andrew Wilson. Special Agent Scheider is also present. Good morning, ladies and gentlemen of the jury. It's good to see you all here. You recall that we're at the stage of closing argument of counsel. The state concluded their initial closing argument yesterday. The defense will have an equal opportunity to have closing argument today. As you were informed yesterday, and I'm sure are aware at this point, the closing argument of counsel are designed to persuade. The closing arguments are not of themselves evidence. However, they are expressions of the position of each side as to their argument as to what you should find from the evidence. And so the defense will be given an opportunity to argue. After that, the state has an opportunity to present rebuttal argument. Is the defense ready to proceed with closing argument?
Yes, sir.
All right. Is the state ready?
Yes, sir.
All right. Then you may proceed.
Please, the court. Thank you very much, Your Honor.
You're welcome.
Mr. Junk, County Prosecutor, Special Prosecutor Wilson, Special Prosecutor Canepa. Good morning, ladies and gentlemen. Thank you very much for all your patience and your sacrifice. It has not gone unnoticed. I'm not going to go as long as you might expect, but there are many points I do want to make. I know that each of you have paid very close attention throughout this case, and we rely upon your collective memories to determine what the facts are. You determine the facts, right? That's why you're here, if you can. And so I'm going to make several points here today, and if I've done anything to offend any of you or that you think was inappropriate, please hold that against me. Do not hold that against George. The same goes for Mr. Nash. You know, you folks are the best of Pike County. There's no question. And we rely upon you to do your job and to do it well, and we are confident you will do that. You folks stand between the power of the government and a man like George Wagner. The government's very powerful. You've seen that. You've seen how many people they have to work on a case. You've seen the resources they can gather. You can see the power they have to place listening devices wherever they want, pretty much. Okay? So you've seen the power of the government. And in this particular case, they've overreached when it comes to George. And it's people like you that stand between the government and George. All right? And you will determine whether the state has proven their case with evidence beyond a reasonable doubt. And that's what you're here to determine. Have they proven their case with evidence beyond a reasonable doubt? All right. You're not here to solve a mystery. You've seen such a tragedy, right? I mean, it's unspeakable. And there are many facts that we, the defense, have not disputed. All right. Many facts are not in dispute. But there are certainly some that are, and that's why you're here. All right. You know, there's a courtroom I've been in only once or twice, but it made an impression on me because the jury box doesn't set off to the side. This is what we call the jury box, all right? The jury box doesn't set off to the side like this. It sets over here, right in the middle, with the jurors looking at the judge for the law and looking at the witness stand to determine what the facts are and what it's back to the public. And that's really, I think, an important symbolism, right? You're the only people in the world that have sat through all this for weeks and months now, listening to the witnesses. You're going to get the law from the judge here in a little while. And just to reassure you, you will have copies of the judge's instructions with you, so you can reference those. A lot of legal terms, obviously, but you will have copies of the instructions. So don't freak out when he's giving you all these terms and everything, because you'll have that to study and look at if you need to. And I'm sure you will. But, you know, the power of the jury is awesome. And, you know, our country has this system that's been in place for over 200 years now, right? Our court system. And it's based on Great Britain's system, more or less. I mean, we've tweaked it a little bit, but that's where most, or many of our forefathers, founding fathers, came from. So they based our court system on that. And what I find interesting about that is in Scotland, they used to have 3 verdicts in criminal cases, 3 different verdicts. They would have guilty, not guilty, and not proven. But in America, we decided to combine not proven and not guilty. And sometimes I think that's a helpful reminder to us, because it's the state's burden to prove their case. The state in this case, as you have seen, with respect to George, paints with a very, very broad brush. All right? How many times have we heard they, them, you guys, the Wagners? All right? George is the one that's on trial here. All right? We are not here to defend Billy. We are not here to defend Angela. We're certainly not here to defend Jake. All right? And basically, I mean, there were days and days that went by when you didn't hear George's name. And that's significant. George wasn't even a suspect in this case, right? They went and interviewed Billy. They went and interviewed Jake and Angela several times. They never interviewed George till they stopped up the Montana border when he was in the car and they separated out everybody. Did they ever seize his phone? No. He wasn't a suspect because he didn't have a motive in this case. And you'll recall his testimony about when he was stopped at Montana. At the end of it, the agents told him, you're either a suspect or you're a witness. So what are the charges here? Obviously aggravated murder and the related charges. At times throughout this case, I thought I was in divorce court or domestic relations court talking about all this custody stuff. This case is not about custody, and we'll explain why. There was some mention yesterday about what motive would Angela or Jake have to lie. Well, they were facing the death penalty, folks. They had the biggest reason in the world, if they wanted to save their lives, to say something, to help themselves. I'm going to go through some exhibits with you. You'll have all these exhibits back in the jury room. And there may be some that are really important to you that I don't point out, and that's fine. But I do want to point out a few things that I think you should take note of. One is, you'll see the exhibit numbers up here, and the white ones are the defense exhibits, Wagner. The red ones are the state's. It doesn't matter which label's on it. What matters is you have the evidence to consider, right? So Wagner Exhibit 50 is this affidavit. I call it 77 pages. I think that's how many pages there are here. I often refer to it as the 77-page affidavit. BCI Agent Scheider went through some of this when I was questioning him, and I suggest you take a look at this if you find it to be appropriate. This was the investigation as of May 24th of 2018. Okay. So well into the investigation, just a few months, 6 months or so before they were arrested. And quite frankly, it lays out in great detail a lot of the investigation up to that point. And so what I find remarkable about this is that at various points, as I pointed out with the agent, and I can give you some page numbers later on, they say they don't have enough evidence to convict. All right, they don't have enough evidence to convict. And this was an application to get those listening devices placed into the R&L trucks that George and his brother drove cross country. All right, and so at that point, they don't have enough evidence to convict. And that's really important, right? And so I suggest you take a look at this at the appropriate time. Now, with respect to Jake, they want you to think that he had some sort of religious awakening that motivated his plea somehow. And I suggest otherwise. His lawyers went through all the evidence with him, right? That's what lawyers do with their clients. They go through the evidence. And they explain to him, Jake, you have no chance here. And I think it's really clear, right, from all the evidence, from the evidence concerning Jake, he really didn't have a chance. He was going to be convicted at trial. And he was going to be facing the death penalty. And, people have different opinions about the death penalty. If we're going to have a death penalty, it's for someone like Jake Wagner, who killed 8 people, who snuck through a window in the middle of the night and murdered people, one after another after another. He had great lawyers, no question. From his point of view, he had great lawyers. They did a great job for him. But why would the state make such a deal? Why would the state make such a deal with Jake Wagner? Why would they? That's a fair question you need to ask yourselves, and I think you should discuss. Why would they make such a deal with him? Because their case against George wasn't strong at all. And what did Jake tell you from the witness stand? He asked that the case against George be dismissed. Dismissed. Of course, the state, as we know, rejected that. But why would he ask for the case against his brother to be dismissed if he was truly involved like he said? Something for you to consider. And I'm going to get into this in just a moment. But with respect to both Jake and Angela, what they said about George cannot be proven or disproven. They said words, they didn't say anything that could be verified. And I'll get into that in a moment. So what I suggest you do, there's so much evidence here, so many things for you to look at, consider, talk about. What I suggest is that you make a list perhaps, or you, at least maybe a mental list. What is reliable? What is unreliable? Okay? And compare the reliable evidence to the unreliable evidence. I have a few suggestions. On the reliable side, you have a lot of phone records, right? Really important stuff these days. Everybody's got a cell phone. Everybody uses it all the time. Keeps very accurate records. We know that. So the phone records of the victims are obviously very important here. And the phone records I'm referencing are the last activities on the phones. So I'd just like to point out a few things. With respect to Ken, who was seen 4, the last activity on his phone was around 9:40 p.m. With respect to Chris Sr., which they call scene 1, the last activity is right around 11 p.m. With respect to scene 2, that's Frankie and Hannah Hazel Gilly, the last activity is right at 1 o'clock in the morning. And with respect to Dana and her family, scene 3, I think it's called, the last activity is at 3:30 in the morning when Dana is on her phone. Why is that important? Well, it's important for many reasons. One, we know those times reflect for sure what time somebody was alive. Okay? We don't know what time they died. There's no proof beyond a reasonable doubt as far as what time these people were killed. We do know, based on these phone records, the last time that they were alive, at least at this time. And so I'll just give you an example of how I think you should think about this. Hannah Hazel Gilly, I think it was at 1 o'clock in the morning or 12:59 a.m., sent a text out, I believe is what the records show. All right. So she's alive at that point. Now, these people, most of them at scene 2, 3, and 4, not Chris and Gary, but all the other ones, they were certainly asleep, except for Dana. Dana was still alive, but she was in bed. But everybody else was asleep, right? So, you have to account how long does it take someone to fall asleep. I don't know. Everybody's different on that. But for example, with Hannah Hazel Gilly, she's on the phone at 1 o'clock. So we know she and Frankie were killed well after 1 o'clock, whenever sometime after that. All right. Why is that important? Because Jake gives a timeline, a sequence of events that doesn't add up to these reliable records. It just doesn't. He's claiming that he and Billy left Peterson Road 9 o'clock-ish, I think was his testimony. All right? And that he's in the back of that truck, and I'll get to all that later. But 9 o'clock-ish, they leave Peterson Road to go up on Union Hill. 20, 30-minute ride, something like that. He's in the truck for a little while, and then everything starts off there at Union Hill Road, and he wants you to believe that the shooting started right around 11 o'clock when Chris Sr. Called Billy's phone, and that's what the record showed. There was a phone call around that time, all right? But he also explains how after those crimes there at scene 1, he and Billy, and he says, George, walk over to Frankie's, which is right nearby, you know where it is, all right? And Billy goes up and rattles the door to see if the door is unlocked, all right? Well, that would have been midnight-ish, all right, something like that. And that, you know, the dogs that are in the backyard, you have pictures of those, the dogs are wailing and everything else, and Billy's supposedly on the front door trying to get in. Well, we know Frankie and Hannah Hazel Gilly are still awake based on the phone records. They would have heard that, right? So we know that timeline is just way off. That's an example. All right. Now, the other thing is, Jake says that they took this truck, and you can see pictures of it. Here's one of them, Wagner Exhibit 23, the truck from Athens County, right? Katie came in and talked about that. Saying they took that truck up there, and then at some point, you know, they kill Chris. Jake, I believe it is, kills Chris. Very likely Gary, and I'll get into that in a moment. But he says at some point they take Chris's truck to drive up to Dana's and out to Ken's, right? What sense does that make? It doesn't make a lot of sense. Now, I know they have proposed a theory that, well, if Dana saw Chris's truck pull up, she wouldn't be surprised. Or if Ken saw Chris's truck pull up, he wouldn't be surprised. Well, I suppose so. But nonetheless, these people are supposed to be asleep when these murders go down, right? So what difference does it make whose truck you take, right? And with respect to Chris's truck, and you'll see pictures of it. I think this is a 40, I think it's this truck right here, this Ford, kind of a silverish color here, is the one they took. All right, there's no blood inside. Jake even testified that he hit a deer while driving the truck. Is there any damage from a deer striking this truck anywhere? No. I just suggest it doesn't make a lot of sense to take Chris's truck when they have this other one. And why, you know, think about it for a minute. They've got this truck, I'll call it the Athens County truck. They have the Athens County truck. They've just killed Gary. Jake has just killed Gary and Chris. They have scouted Frankie's, supposedly, all right? And then they take this and they leave behind this truck at the murder scene? What if Ken or somebody else came along? Like Ken takes a shower at 4 o'clock in the morning or whatever over there occasionally. What if Ken or somebody else came along, found the dead bodies, all right, and found this truck that's registered to a Wagner? That doesn't make any sense, to take Chris's truck like that. And this whole route that Jake talks about, this coming and going and backtracking and coming back and then circling back around, what sense does any of that make? If this is a pre-planned murder, which it was, all right, no question about it. If this was a pre-planned murder, why are you going back and forth and leaving a truck at a crime scene, taking another truck and going somewhere else? All right? Why would you do that? What makes more sense, I suggest, from the evidence you can rely on, the phone records, is that Ken was probably the first one killed. Ken, remember, was killed because they feared he would retaliate, right? He would retaliate if he knew the Wagners killed any of the Rhodens or anybody else. That was, you know, Ken wasn't about custody, right? Ken had nothing to do with custody here. Ken was, they feared that he would retaliate. So it would make more sense to take him out first so he doesn't drop in at Chris Sr.'s like he might, all right? And, you know, I think it's telling that the state thought the same thing. They put him in count 1, all right? And his phone records show the last activity at 9:40 p.m., so we know just that he was killed sometime after that. We don't know when, but sometime after that. So it makes more sense that you would start there, then go to Chris's, last activity 11 o'clock, then go to Frankie's next door, last activity 1 a.m., and then end up with Dana's last activity at 3:30 a.m., and then get right on Route 32, which is right where her house is, right? It's right by Route 32. So you start at the furthest point, work your way up the hill. Dana's is the last one. You get on Route 32 and you go wherever you're going to go. Rather than this back and forth and leaving a truck here and taking another truck there, that makes no sense. And the state has this theory that they've presented ad nauseum about this being about custody, right? You've heard about that. They're entitled to their theories, quite obviously. And, you know, it's somewhat understandable. They're investigating this complicated case. It takes 2.5-year investigation. They find this Facebook message, right? I don't have to repeat what it says. It's the one from Hannah May. You'll have to kill me first before I sign papers, words to that effect. That's alarming. You know, in a murder investigation, that's obviously alarming. All right? But it doesn't make sense for one family to kill another over custody. Have you ever heard of such a thing? No. No one's ever heard of such a thing. We have a whole court system set up to deal with custody issues and divorces and domestic relation issues and that type of thing. It doesn't make sense, and quite frankly, I don't think anybody ever believed it was about custody. All right? You know, there were thoughts, oh, it could have been a drug deal, it could have been this, it could have been that. No, nobody really thought it was about custody. And, you know, the Ohio Supreme Court one time had this very interesting opinion where...
Your Honor, I'm going to object to Mr. Parker testifying. This wasn't in evidence.
Let me just phrase it this way. Reason and experience teaches us. Reason and experience teaches us that this is not about custody. People don't kill over custody. They certainly don't kill a whole family over custody. But what would they kill over? A lot of things people kill over, all right? You think your little child's being sexually abused? That might be one of them, all right? A jealous boyfriend? For sure. That's human nature, unfortunately. Drug dealers, large amounts of money? Yeah, we know that. That's reason and experience, all right? Reason and experience teaches us that people don't kill each other over custody. So let's talk about this truck. I call it the Athens County truck. You've seen the pictures. Jake testified about altering the bed here, putting that piece of plywood in, throwing a dozen bales of hay or straw on top, supposedly. Let's talk for a minute what else Jake said. Well, let's back up even further. How did this murder come about? Where did the idea come from? Well, according to Jake and Angela, let's start there, right? Angela said very clearly that she suspected Sophie was being sexually abused. And she asked Sophie about it. And Sophie was under 2 years old at this time, so keep that in mind. A 2-year-old, just under 2. She asked Sophie, and she believes what Sophie's telling her about sexual abuse. And she goes to her husband, right? That's what Angela said. That's what she testified to. She goes to her husband and says, hey, I think something's going on. We got to do something about it. I think it's Chris Sr., I believe is what she said. Husband says, nah, that can't be. That can't be. I know Chris. That can't be. She's like, we got to turn him in for the drug deal. She knows about the drug dealing, right? We got to turn him in for the drug dealing. Billy says, no, we're not doing that. And of course, you know why. Because he's doing the drug dealing with Chris. That would hit a little too close to home, right? So she goes, well, you got to come up with something. You got to come up with something, is what she says. And so some time goes by. Billy comes back to her and says, we got to kill him. What? We got to kill him. But she goes along with it. And then Billy goes to Jake, right? Sophie's dad. Billy goes to Jake and says, we're going to have to kill Hannah and some other people in that family. And Jake, I'm no fan of Jake, believe me, but Jake says no and stomps out of the room, I think is what he testified to. But he confronts Hannah, according to Jake. I don't know whether to believe this or not. That's up to you folks what to believe, to decide what to believe. But he allegedly goes to Hannah and confronts her about some possible sexual abuse, because unfortunately there was some of that in her family, or with her at one point. And Jake is very much aware of this. He goes to her about this concern. And according to Jake, Hannah says, we'll deal with it. If it happens, we'll deal with it. And that sets Jake off. And he goes back to his dad at this point and says, I'm in. All right? And then it's Jake and Billy that make the plan to murder these people. Angela gets involved too. But it's Jake and Billy that make the plan. You hear George's name here anywhere? No. You hear anything about a family meeting to discuss killing these people? No. Something you have to consider when someone testifies is their demeanor, the truthfulness. When you determine whether someone's telling the truth or not, you need to look at their demeanor. You folks know all this, right? The judge will give you instructions on this. What about Jake when he was up here? Laughing and smiling and smirking as he's talking about these murders. He's cold-blooded. I think he's psychotic. He didn't seem to have a care in the world. It's like sitting around talking about a football game on Monday morning is the way he's talking about killing these people. It's disgusting. He's a sick man. You can't believe what that guy says. And Angela's not a lot better. All right? You know, Angela testified that Hannah was like a daughter to her, right? They lived together. Over there on Peterson Road, she would chit-chat with Hannah at night. The upstairs people, I think is what she was. Where they would be caring for the kids that might wake up in the middle of the night, and they'd sit at the top of the stairs and chit-chat. Maybe like people do in the middle of the night, right? That's her second daughter, and she plots to kill her. Which is exactly what she did. You don't think she'd throw George under the bus and she's plotting to kill Hannah? And then when she testifies, it's just amazing. When she testifies about this, she knows Billy and Jake are leaving to go kill these people up on Union Hill Road, right? She knows this. She sees them walk out the door. What does she do? Does she call 911 with the second thought? Does she get Hannah's phone and call her up and say, get out of there, run for your life? Does she call Dana? Does she call Chris Sr.? Does she call anybody? No. She goes upstairs and goes to bed. She goes to sleep. That's what she testified. That woman has problems too. First, she believed a 2-year-old. You know, if you have a 2-year-old, a granddaughter or son or daughter or whatever, if you suspect a 2-year-old that's in your family is being sexually abused, you take her to the doctor. You take her to the emergency room. You talk to her mother, the grandmother, somebody in the family. You share your concerns to see if they're true or not. She didn't do any of that. Angela and Jake. He's a mama's boy. You heard testimony about that. They're liars. They're con artists. They're thieves. You've heard the testimony about Angela and the way she conducted herself throughout her whole life. She's an arsonist. Burn one house down, then another, then another, then another. Get dogs from the pound and dye their hair and sell them as purebreds. This is calculated. This woman is manipulative. She's got problems. I've got a pretty good idea where her problems came from because she had a really unfortunate background. But that woman's got problems. And you can't believe a word that comes out of her mouth. Nor Jake's. That's unreliable evidence. How many times and how many people did they lie to? You could sit down and make a list. And the state of Ohio indicted Angela for the aggravated murders of these people, as they should have. They were seeking the death penalty against Angela. And what did they do? They dismissed every aggravated murder count against her. She's not being held responsible at all for these aggravated murders. She's getting out of prison with their permission. She sold her testimony. She's a con artist. She's a liar. And she pulled another one. Because nothing she said about George can be verified. Nothing. She says, oh, well, he had nightmares. How are you going to verify that? Oh, he told me he smudged out some footprints. How are you going to verify that? But what you can verify, and what you can see from the first crime scene, is a photograph. And Jake testified how he smudged out. He took that rug and smudged out footprints. That's where Angela's getting that from. Oh, George offered to take the fall for the family. Are you kidding me? That's the type of thing you're going to rely on from that woman? And let's talk about Jake again for a minute. Jake said George participated in building this piece of plywood, if you believe that even happened. He participated in that. Is that really the way Jake talks? Participated. Where did he get that word? He said George, after the murders, dug a hole in the barn, in the floor of the barn. How are you going to prove or disprove that? And what's really important also is that, there's a lot of evidence about these shoe prints. Obviously very important stuff, right? I'm not minimizing that evidence. It's really important stuff. And they did a good job investigating. They found the receipt, right, at Walmart. They went to Walmart. They got the photograph. There's Angela pushing the cart out. Okay, she bought the shoes. There's no doubt about that. All right. But how many did she buy? She bought 2 pairs of shoes. Billy and Jake were planning the murders. She bought 2 pairs of shoes. She didn't buy 3. She bought 2. And that's because Jake and Billy planned it. And I don't know what you're going to believe here as far as this testimony goes. You can believe some, you can believe none, you can believe a little bit. That's up to you folks, all right? But if you're going to believe anything from Jake, it's going to be, don't forget this part that he said. Don't forget this part he said, which I don't think was mentioned yesterday. He said, George tried to talk us out of it. George didn't think it was a good idea. George didn't want it to happen. George only went along at the last minute. He only went along to protect me, Jake, from my crazy father. He didn't have the intent to kill anybody. He was there to protect me. Now, George, of course, saying he didn't go along at all. But is there reasonable doubt here about whether he went? And if he went, what were his intentions? I mean, they only bought 2 pairs of shoes. You can't change that fact. You can't change the fact that it was Billy and Jake that talked about killing these people. Even Angela said that. And there was no family meeting here about this murder. I'm so sick of hearing about family meetings. Family meetings. It was Angela and Billy, Billy and Angela, Jake and Billy. Now, Angela, I think, did say something about, well, I saw the boys in the kitchen, and do you really want to do this? How can that be verified? Jake didn't say that. There's what I call a fatal flaw with the state's presentation here. And I say that with all due respect because these are excellent prosecutors, excellent investigators, no question about it. But there's a fatal flaw that you need to consider. They had a theory in the case, as you must, right? When you're investigating a case, you try to eliminate this, eliminate that, and you end up working wherever the evidence goes, right? And they had a theory, and their theory was this custody thing, but it's really not about custody. And the problem that sometimes happens is when you have a theory, when somebody or some organization gets a theory about something, they only look for the evidence or for the items that confirm their theory. They don't look for anything that contradicts what their theory is. There's a fancy phrase for that called confirmation bias. And I think there's evidence of that here. And I'll give you a couple examples. Jake and George allegedly dyed their hair, okay, before these events took place, before these murders took place. All right? Jake testified and said repeatedly, that had nothing to do with the murders. They can't give it up. Because that was part of their theory. They can't give it up. The tattoo that George got, you see pictures of it, the tattoo that George got to cover an old tattoo. We brought in the tattoo artist, you'll remember him. That was his idea. It has nothing to do with these murders. They can't give it up. They think this is all about custody. When Jake and Angela testified, it was about the sexual abuse. That's what they said. And that's what makes sense. But they want to persist on this custody issue. And you can't, I don't know what's going on with Billy, right? You heard a lot about Billy here. Billy was into the drug dealing, all right? Billy's a doomsdayer. Billy's a thief. Billy taught his kids all kinds of things you don't want your kids to learn, all right? He's not going to get Parent of the Year, that's for sure. But Billy, he was into drug dealing and into money. You heard at least about one trip to Mexico where he took a stolen truckload of goods and came home with a suitcase full of, what was it, 100,000 cash that the boys counted out or something. All right? He's into drug dealing. He's into making money quick. All right? Was that his motive here? I can't say. But there's no reliable evidence he ever saw this Facebook message. He's the one that came up with the idea to kill, according to Jake and Angela. I mean, if you believe that. And, there are a lot of differences between Jake and George. And I hope you understand that. They're brothers. Yes, they're brothers, but they are vastly different. Here are photographs of Jake. All right, these are in evidence. All right, wearing his little leather outfit. Here's George. All right. Described, I think, more than once as a country boy who likes to sit in a deer stand. That's where you'd rather be. Riding his four-wheeler, mudding, fishing, hunting. That's not really Jake. He's with his video games. You remember that? Resident Evil, right? He's into zombies. How do zombies get killed? By shooting them in the head. What knife does he have in that bucket? A green knife. No broken tip, by the way, like you said he broke it. None of that. But a green knife that says Zombie Apocalypse Knife. All right. From Jake's composition book, seized over at Route 41, which is in evidence, of him making these juvenile drawings. Secret spy case, CC-177. Secret spy case. 2 Colts, suppressors, toolkits. This is Jake. Jake's a disturbed young man. Way different than George. George is not perfect. We're not here to say he's perfect. But he is nothing like Jake. He spent as much time away from that home as he could, realistically. And you have to consider, right? You have to consider his upbringing up there on Bethel Hill. You've heard all about that. I'm not going to repeat everything. But let's talk about the murders for a minute. Every victim was shot in the head. Every victim. Poor Hannah Hazel Gilley was shot right in the eye. Frankie, who laid next to her, was shot just below the eye, but multiple times in the head, right? Ken, you'll remember Ken out on Left Fork Road, got shot only once, but right in the eye. Gary and Chris were covered up with a blanket. You'll remember that. Dana was covered up with a blanket. You'll remember that. Jake is the only one who went inside crime scene 1 at Chris's, crime scene 2, Frankie's, crime scene 3 over at Dana's. He went in crime scene 4 at Ken's and shot him in the eye, just like he did Hannah Hazel Gilley. The muzzle flash, are you kidding me? The only way he saw that muzzle flash was if he was standing there shooting Ken. You'll remember the testimony, he testified he was in the truck, parked behind other trucks, probably 100 feet from the camper, with his headlights up there, when he claims his dad went inside and shot Ken with a .40, right? That's what he testified to. But you have the video that our expert, Mr. Priest, testified to. You have this video. It's on this thumb drive. You can watch it if you want. I'm sure you remember it. About that flash. He would had to have been looking at the exact moment that flash happened. And I don't think even then he could have seen it, given the distance, the blinds there, the interior light on the floor inside, which you have photographs of. There's no way he saw that flash, unless he was standing there with a gun shooting Ken in the eye, just like he had shot the other victims in the head. Another thing was Jake testified, and this is strange, but Jake testified that he moved Hannah Mae's body after he killed her. You'll remember that. All right. But he denies moving the bodies of Gary and Chris over at scene 1, where they were obviously dragged back to that room. And I'd like to talk to you about scene 1 for a moment. Some things I want to point out about crime scene 1. I can find my notes here. Gary and Chris were covered with the blanket. You remember that. They were dragged there, right? No question about that. I thought it was interesting what Mr. Priest had to say. If there were 2 or more people there, you'd more likely carry the body from one position to another. If it's one person, they got to drag it, right? And I think you really need to look at the photos here. I just pulled a few. A167, you've seen these photos. This is inside crime scene 1, the easy chair that's inside the door. If you remember Jake's testimony, he said Gary was in that chair dead after having been shot. There's no blood. Gary's blood isn't near that chair. You may not remember the stipulations we entered into, but you'll have them in evidence. This blood on the floor near this chair, that's Chris's. Gary's is over by the kitchen. Gary wasn't in that chair, shot dead like Jake said. A168, this is looking towards the kitchen area, right? This bloody scene here, okay? This is the rug. This is the rug that Jake said he used to smudge out footprints. That's what he said. Whether you believe it or not is up to you. But this is where the bodies were drugged, right? And there are many other photos. But A228, this is that little narrow space. Okay? This little narrow space here where the bodies were drugged. And why is that important? Well, I believe when they did the scan, Farrell scan, I think it's called. They did the Farrell scan. We asked them to measure this distance, right? I don't know if you remember that or not. But it's about 27 inches is what my memory is. Right? 2 feet, just a little more than 2 feet. Very narrow. Right? It's very narrow, regardless of exactly the exact width. But what's important here is this old wooden chair with this bag of garbage on it, okay? This wasn't disturbed. You can tell from the photo. This wasn't disturbed. So whoever pulled the body, dragged the body through here, was able to fit in that area, right? Well, Billy, you've heard the testimony. Billy was a very large man, 6'6", whatever. He's a very large man. We've got some photos of him here. Here's a picture of Billy. Big guy, right? Big guy. And you heard Jake say that, that Billy was hysterical and had a meltdown during this. You think this big guy is going to drag bodies through that little narrow space to get back in that bedroom in that condition? No. And Jake doesn't even put George inside that trailer. He only has him outside. And most telling, is Jake said he went inside after the shooting, took the keys from Chris's pocket. You remember that? All right? Took the keys from Chris's pocket, went up to the grow room above the garage, right? Went in there to get the DVR because they knew there were cameras. They wanted to get that DVR, right? Here's the door to the grow room up there, right? Here's the door. Blood on the door. Whose blood? Gary's. Gary's blood. Jake pulled those bodies back there, Gary first. He pulled Chris's body next. He got Gary's blood on his hands. He put it up on that door. And there's even a little spot of blood on the grass between the trailer and on his path there as he walked up there. That exact path, there's a spot of Gary's blood. And that is from Jake pulling Gary's body back there. What else from scene one? There are no tire tracks anywhere. Like he said, this truck pulled up there in the grass and everything. You know, think about this blue truck. If this blue truck was used like he said, you know, if it's like he said, you've got this pickup truck, you've got Billy driving it, big guy, right? I don't know how much he weighs. 250, 300 pounds at least. 300, I'd say, most likely. Big guy. You have Jake, full-grown man. He's skinny, right? Jake is skinny. Jake is the skinny guy that can get through that little opening. All right? And he wasn't hysterical, according to his testimony. Jake's skinny little body could get through there without disturbing this chair and this bag of garbage or whatever this is sitting there. But that truck, you know, there's no tire tracks, there's no hay strewn out. If you're gonna drive a truck up there with a dozen bales of hay or straw on it, you're gonna lose some of that somewhere, right? There's nothing like that. More importantly, there's no tire tracks. And if you had Billy in there and Jake, two full-grown men, that's probably, 400 pounds minimum, plus the weight of the hay or the straw. A dozen bales, that's going to be a little bit of weight, right? That's going to press down. And Jake wants you to believe that he crawled out of the back of the gate, that his dad dropped the gate, and he crawled out and got underneath that truck with an SKS and with a Colt, whatever guns he had, all right? And that he was laying under there, and Chris didn't know about it. Chris is 30 feet away. He didn't know or see this. That's just not believable. It's not realistic. Now, did Jake fire that SKS from along those lines that you saw? Sure he did. That doesn't mean he was underneath the truck. What makes more sense? If they took this truck, all right, if it's Billy and Jake, and that's what they said, Billy and Jake planned this truck bed makes no sense. All right? And let's not forget, when Jake agreed to do these murders, his first idea, according to his own testimony, his first idea was to strangle pregnant Hannah, kill Corey, her boyfriend at the time, and make it look like a murder-suicide. That's crazy. And even Billy said that was crazy, and we're not doing that. I don't think this bed actually happened. That's up to you to decide whether that bed was there or not. He did things like he said. It doesn't make a lot of sense when you look at the evidence. It wasn't necessary. You know, Billy could have dropped off Jake at nighttime 50 yards up the road or whatever, and he could have walked in the dark to wherever he needed to be to do what he did. This is fantasy here. This is part of Jake's fantasy. And the other thing is, okay, let's talk about Jake a little bit more. They want you to believe him, quite obviously. And it is significant, without question. It's very significant that he led them to the murder weapons, right? They never would have been found otherwise in this bucket in the middle of this lake, right? I mean, nobody ever would have found this stuff. But that's his conduct. He verified his own conduct. And he did tell them about this truck that they found in Athens, and I can't say it wasn't used. I can't say it wasn't used. Very suspicious that Billy arrives at when he did with that truck. All right, but that's not George. All right, that's not George. And certainly there was no testimony from Katie that this plywood thing was on there or anything like that. What makes more sense is that if they used this truck, which they probably did, I got to concede that. All right, what makes sense is that Billy dropped off Jake nearby and he walked up to do whatever he had to do in the very dark, rural area that this was. All right. Crime scene 2, Frankie and Hannah's, there's really nothing implicating George there, right? Crime scene 3, which is over at Dana's, a few points. Jake never missed a shot, right? I don't think he missed a shot the whole night. He's right up on top of these people shooting and killing them. And he covered up Dana. He manipulated Hannah's body in a very gross and bizarre way. And there are some photos I think you should look at in considering crime scene 3. As you'll remember, BCI, they have a photographer that comes and takes pictures, a million pictures here, right? And that's the way you do things. That's a proper way to do it. So at crime scene 3, this is Dana's front door entrance area, right? As they find it. Nothing too remarkable here. That's the front door, but there is a welcome mat down here. Okay? You'll see from another angle, they're inside little Chris's bedroom pointing out. You can see the welcome mat there too. Here's another one a little closer from inside. You can see the welcome mat, right? Here's one when they're trying to put the fingerprint dust or whatever they're doing there to get tracks, find out if there's any evidence here. Where's the welcome mat, right? It's been moved. You've got this half moon type rug. Where'd that come from? And there are a couple different photos of that. And that doorway at scene 3. That's something I think you should look at and discuss. Crime scene 4. George isn't there, right? They're claiming he's sitting on a cutoff down the road there a little ways. How do you prove that? You know, how do you prove that? If you believe Jake, you believe Jake, but I don't think you can believe him on that. It makes no sense. What's he sitting down there for? Right? What's he sitting down there for? It's a considerable distance away. It makes no sense. And going back to crime scene 3, I couldn't believe when Jake testified that he said when he's inside Dana's place, he gets down on the floor and he looks under her door to see if she's in there. And he says he's in this little hallway between Dana's and Hannah's room. You'll remember the pictures. You'll have them. All right? And he fires from that position. And he hits Hannah in the forehead. But we know from the coroner's reports and everything, she's shot in the back of the head. The ear and right up here in the back of the head. All right? He was standing right next to her. Right? He killed her point blank range. And there's that shell casing that he didn't get from there. That's underneath the crib on the other side of her bed. He's standing right beside her when he shoots her in the back of the head that shell casing comes out, bounces off the wall most likely, and ends up underneath that crib. All right? He's a liar. He's a cold-blooded executioner. Motive, we've talked about motive a little bit. Jake allegedly had a motive. Angela allegedly had a motive. Billy, maybe a drug motive. Maybe he's taken advantage, okay, of his family's bizarre sexual beliefs here about Sophie. There's no evidence that poor girl was ever abused. George had absolutely no motive whatsoever, right? And let's talk about George for a minute. He didn't get along with his family like the state is portraying. He testified about that, right? When he turned 16, he got his license. He was out of there as much as he possibly could. He was arguing with his brother. He's arguing with his mom. He even got in fistfights with his dad, all right? He couldn't stand Jake's personality. He spent as much time away from them as he possibly could. Now, did they live together? Yes. Did they work together? Yes. That doesn't mean they liked each other or agreed with each other. And, you know, he was raised in this family that's really hard to even describe, right? It's a quagmire. He couldn't get out of it. Mr. Rhoden was an important person in his life. That's the gentleman from Virginia who used to hunt up on Bethel Hill, all right? He tried to talk to George about, you need to change your lifestyle so you're not looking over your shoulder all the time. That didn't sink in immediately, but it eventually did sink in. That and the birth of his son, all right, made a big difference in his life. He was a young man at that point. He didn't have any teachers as role models. He didn't have any coaches. He didn't have the parents of friends that he could look up to. He was pretty much socially isolated there. And you have to look at this evidence from George's point of view. He thought his family was being framed. That's what Angela told him. That's what Jake told him. Billy said it was Skid Montgomery, all right? But Jake and Angela said they were being framed. So you have to look at this evidence from his point of view. And especially, I think, when you listen to these recordings, okay? And I'm sure you will. You heard some of them. And listen, think about it from his point of view, that he doesn't know what his family did. He can't believe it. Yeah, they're thieves. They've got a weird lifestyle, no question about it, all right? But it's one thing to do that versus killing 8 people in the middle of the night that you know and love, or any other people. That's a large leap. So when you listen to those recordings, listen with an ear that he didn't know this had happened. And I think a lot of those conversations take on a different meaning. He thought they were being framed. And at the BCI, when BCI interviewed him at Montana, he told you, they said at the end of the interview, you're a suspect. We're your witness. Can you help us out? And he confronted Jake. I mean, yeah, okay, I've been stopped at the border. BCI is obviously after our family. He knows that. All right, now it's really sinking in. And he's like, Jake, do you have something to do with this?
Your Honor. This was not testified to.
He said he asked his brother if he had anything to do with this after the Montana interview.
Well, again, the jury will use its collective memories to determine what the evidence is. This is argument, so you may go ahead.
George testified that he confronted his brother after the Montana interview. Did you have anything to do with this? And Jake swore up and down he didn't. And George believed him. And, you know, with respect to Montana, there was a lot of really, you know, the prosecutor asked George a lot of questions about, didn't you say this in Montana? Didn't you say this in Montana? What about this in Montana? Did you hear the recording from Montana? No, they didn't play it. Did they bring in an agent from Montana to say, did George say this, this, and this? No, they didn't. Why? Ask yourself why they didn't. You heard Angela's, right? You know they're all being recorded. And another thing about, always back to Jake, right? Another thing about Jake, you know, they took this truck they got in Athens County, and they did this demonstration, I will call it. You saw the photos, right? When did they do that? After Jake got done testifying. Did they show those photos? Did they do it like after his proffer or anything? In the year and a half or so it's been since he turned state's evidence? Did they show him those pictures? Did they do that in a timely way and say, is this how you did it? Was it something like this? No, they didn't. And they want you to believe that he purchased this Colt 1911 that was used at this gun show and George was there, right? Did they ask Jake if George was there? No. They didn't ask Jake if George was there. Do they have photographs from that gun show? From security cameras or anything else? Showing them together like they did at Walmart? Do they have any other pictures of George's alleged activity here? They got nothing on George. Other than the word of his lying, watch my language, brother. And his mother, who dragged her own mother into this case. Talk about a piece of work. Angela drug her own mother into this case. This Boondock Saints video, it's comical. I'm sorry, it is. If they want you to convict based on some Boondock Saints video, it's a joke. They have this video you saw early on in the case. Early on in the case. You saw a video taken from somebody's house out near Left Fork, out that route. Video of two vehicles going closely in the night. I'm sure you remember that, right? They want you to believe that's related to the murders, right? Going back and forth. Did they show that video to Jake? Say, hey, is that you guys going down the road here? No. Do they have anybody to say it's either this truck from Athens County or Chris's truck in those videos? No, you can't tell what it is. It's two cars going down the road in the middle of the night. Something I ask you to consider when you listen to these recordings from the Arnell truck is that George was, and Jake both, but they were cross-country truck drivers. George was up all night, or up most of the time, I should say. He drove at night, right? He was a night driver. Lots of caffeine, very little sleep, very irritable. I think you understand how people's personality changes if you're up for 2, 3, 4 days, practically no sleep, and you're loading up on caffeine, all right? Your personality is going to be a little bit different, especially when you think BCI is framing your family for these murders. I ask you to take that into some context. There are some stipulations which you will have that we've entered into with the state. A lot of it has to do with blood evidence, all right? You'll remember that. There's also some concerning George's weight over the years, and there are medical records here which support these stipulations. George was a very large guy, right? He was a large guy his whole life. 280, 300 pounds was not unusual for him, all right? Take that into consideration when you consider who moved the bodies, all right? Take that into consideration. If you think he was in the back of that truck for an hour, I think is what Jake said, from the time they left Peterson Road until they got out, something like that, 20 minutes, 40 minutes, 60 minutes, something in that time frame. If you think George and Jake were in the back of that, if you think they were in the back of that, take this into consideration. Remember Jake's testimony. His dad, I don't know if you believe this or not, but Jake's testimony was, his dad stopped somewhere between Peterson and Union Hill Road, went to the back, and his dad asked me, this is what Jake testified to, Dad asked me whether I wanted to go through with this. He didn't ask me and George. He didn't ask us. He asked me. George and Tabby, they started off very young. It was set up by a family member. They were kids, literally kids, 12, 11 years old. All right, there's a year's difference between them. Not anymore. There was some testimony there was more. No, there was a year's difference between George and Tabby. All right, they started off as kids. She basically lived over there on Bethel Hill. They broke up at one point. They went their ways. They got back together. They got married. And there is a picture here of their wedding. Wedding day, I should say, right? Take a look at this. And the other. This is George over here to the right of the picture. All right? I think he said it was July 1st, 2012 or 2013. You'll remember. All right? So this is George. This is Tabby, his wife. All right? Who's he got his arm around here? Frankie. All right? And then these are the Rhodens and the Wagners. All right? This is Chris Sr. This is little Chris at the time. There's Billy. There's Hannah. Okay. Angela. This is the family of George's wedding. All right? To say George wasn't friends with Frankie is just really misstating the situation. They were friends when they were younger, before they started having kids. All right? They used to hang out together quite a bit, hunt, four-wheel, that type of thing. Now, Frankie started having kids. George got married and had kids. They weren't as tight as they used to be, but reason and experience teaches us that often happens, right? Doesn't mean you're not friends. I'm sure that Frankie had a lot of friends. George, not so many. Okay? He was pretty isolated. He didn't have so many friends. He socialized down at Big Bear Lake. You heard about that, right? As a teenager, set up a tent, drink, play drinking games around the bonfire, different things, all right? That was his social life. And I just want to point out how hard it was for George to get up on the witness stand, given his background. Homeschooled till the age of 14, right? And he quit. Right? A lot of us might have quit school at the age of 14 if we didn't have someone pushing us. But he quit the homeschooling. Didn't have many friends. Didn't have much of a social life. Would rather be alone out in the woods. Not surprising given the chaos that was going on within the house. The woods was his refuge. All right? He was an excellent hunter, an excellent woodsman. He wanted to do that, right? He wanted to be a forester or a game warden as a child. His dad wouldn't let him. But you have to understand how hard it was for him to be in public and talk about the things he talked about. He was brutally honest with you. You remember the lessons his father taught him, right? I don't have to go through all that. But he broke every rule his father taught him by getting up here and telling the truth. And he did it for himself, quite obviously, so the truth comes out. And he did it for his son. I mean, Jake and Angela have destroyed this man's life and his son's life. That son was all he had. You know, when he and Tabby had their problems, and they had problems, as young couples often do, when they had their problems and he decided he had to end the marriage, what did he do? He went and he got a lawyer, Barbara Moore. You heard her testify. He took Tabby too, right? He offered to pay for an attorney for Tabby, but she didn't want one. But she wasn't tricked into anything. You think that attorney would trick Tabby into something? You think the judge that handled that case would trick Tabby into something? No. George used the court system. And he was concerned about protecting Bullmine from her family, which is a mess. They allowed Tabby to be sexually abused as a child. George didn't want his son in that situation. Who would? Right? So he went to the court system and used it properly. Now, Beth comes into the picture up in Alaska, right? Beth comes into the picture. George didn't approve of Beth. He didn't think Jake should marry Beth. What kind of woman would come into a family that's under the suspicion that this family was under? That's what was going through George's mind at the time. All right? And then they come back to Ohio, and allegedly, according to Angela, and who knows if you can believe her, but once again, Sophie's saying that someone touched her inappropriately bad. There's no evidence to support that. That's what Angela's saying. Now, George is freaked out because he has this experience through Tabby's family. He's concerned about his son being around Beth. All right? Does he want to kill Beth? No. He wants her out of the house. It's not unreasonable. Did he want to kill Tabby or her family? No. He just didn't want Bullvine over there for obvious reasons. Why would he agree to kill Hannah and her family on similar baseless accusations? Hannah, you heard him testify, Hannah was like a little sister to him. They joked around. She was living there. And why would he kill Frankie? He wouldn't. He wouldn't kill anybody. And he didn't kill anybody. And he didn't go along. Because it makes no sense. I ask you to look at the evidence from George's point of view, right? We've all heard a saying at some point in our lives. You have to walk a mile in a man's shoes before you judge him. We've probably heard that, right? At some point. That actually comes from an old poem written by a woman who was a school teacher in the 1800s. I'm not going to read you the whole poem. But the name of the poem was Judge Softly. And the woman, the teacher that wrote it, was Mary Lathrop. I would like to recite just the very end of the poem. It says, "Brother, but for the grace of God go you and I. Just for a moment, slip into his mind and traditions and see the world through his spirit and eyes before you cast a stone or falsely judge his conditions. Remember to walk a mile in his moccasins. And remember the lessons of humanity taught to you by your elders. We will be known forever by the tracks we leave in other people's lives, our kindnesses and generosity. Take the time to walk a mile in his moccasins." And that's what we're asking you to do when you evaluate the evidence and the testimony of George. Now, I do want to go through just a few of these exhibits and point them out. I'm not going to spend a lot of time on them. Jealousy. Jake was a jealous man. Hannah had other boyfriends. These are pictures I think he identified that he'd seen on Facebook. One is Corey and Hannah kissing. Lovely picture. They're kind of cuddled up, taking a nap or sleeping. That would enrage Jake. These are some measurements from that truck just to show the small size that would be involved in getting in the back of that Athens County truck. Pictures of Billy. Pictures of Jake. Pictures of George, of course. And I can't forget, when you're judging credibility, right? The GoFundMe account. The GoFundMe account. Angela wrote it. Jake edited it. Is my recollection. Can you imagine that? They go kill these people. And they have the audacity to set up a GoFundMe account. Here's a picture of George. I think I showed this to you earlier when he got his feet measured, right? It shows you how big of a man he was. All right, big guy. He's lost a lot of weight. Judge, perhaps we could take our morning break. I'm almost done, but this might be a good time for a morning break.
Do that now. It's a good time. We'll take our morning break, ladies and gentlemen. We will be in recess until 10 after 10.
Your Honor, the only thing I'd ask you to consider is it's going to take me a second to clear this stuff out and to get my stuff ready for the rebuttal closings. I don't know if there's any time to do that, or we can do that over the break, but I want to be ready to go without having to.
Oh, I see what you're
See
saying.
what I'm saying?
It may take a
If
little
he
longer.
can finish now,
I'm done with the exhibits, we can remove those during the break.
All right, so we'll take, at 10 after 10, assemble at the jury room there. You'll be brought up here as soon as everything's ready for you to be brought up here. It should be about that time, not much longer than that. While you're at recess, ladies and gentlemen, do not discuss this case among yourselves or with anyone else. Do not permit this case to be discussed with you or in your presence. Do not express an opinion concerning this case. Do no research concerning this case, either as to the facts or as to the law from any source at all. Do not read, view, or listen to any reports or accounts of the case from any source at all. Have your contact with participants in the case, including parties, counsel, and witnesses. Does counsel for either side have anything further at this time before we take our recess? All right, we are in recess now until 10 after 10. may be seated. Defense counsel may resume closing argument.
Thank you very much. I just have a few more things I'd like to point out for your consideration. Obviously, you've paid really close attention throughout this entire case. You guys need to get this case and go start your deliberations. And that's going to happen. But I do want to point out a few things. When Angela testified, remember what she said? Billy told her to buy 2 pairs of shoes. It was Billy and Jake that planned this. Billy told her to buy 2 pairs of shoes. When Jake was testifying, he said he was the one that was supposed to shoot one time to make it a clean headshot to Chris Sr. When Angela was testifying, they were asking her about this truck that was seized at Athens County, whether she had seen it over on Peterson. She said it was a green Dodge. That's not what it is. When Jake was testifying about being over at Frankie's with this zombie apocalypse knife, he said that he was at the back door. He got in. He was at the back door. He opened the back door. His dad was behind him, but he didn't remember seeing George. I pointed out that big affidavit that you'll have. Page 17, no proof beyond a reasonable doubt is what they say at the top of page 17. Page 28, they thought the murders took place between 3 o'clock in the morning and 7:49, which of course is when the 911 calls were placed. You know, that's pretty significant, right? That timeline, it goes back to the timeline. That timeline that Jake describes is completely inaccurate. It's just completely inaccurate. Jake testified clearly that he burned all the clothing involved, right? Down to their boxers, I think he said. Burned all the clothing. So these ski masks and these distractions that the state has presented have nothing to do with this. He burned all the clothing. At scene 1 there, Chris Sr.'s, the bloody shoe prints. Very important, obviously. 2 left shoes. No right shoes whatsoever. Is it beyond the realm of thinking that Jake was wearing 2 left shoes? It's possible in this bizarre case. Why isn't there a right shoe print in there? And if Jake went back in, after he went up to the grow room, if he went back in to get the phones, like he testified, why aren't there prints going towards the bedroom? The only prints are coming out. They're like 1 stride apart. 2 left shoes. And if there was more than 1 person in that really bloody crime scene there at scene 1, you expect to see prints on top of each other, going different directions. You don't see that. George got nothing for his testimony, right? Nothing. Compare that to Jake and Angela. Gary's blood is on that door handle at the top of the grow room. Gary was not in the chair as Jake testified. It's just not possible. There's a lot of insinuations in this case that the state has made. Look for the hard evidence of George being involved here. It's just not here. There's a lot made about this goose box. Yeah, George helped build that goose box for his grandfather for his birthday, which is in February. And he described to you how he put it in the back of his truck, took it out to the pond, and placed it in there. All right? Prosecutors didn't even ask him a question about that. They didn't even really ask him any questions about the murders. Consider the witnesses that the defense presented, right? Talk about the Cinereskis for just a minute. You'll remember the 2 father-son combination from Alaska, the ministers or pastors. They knew the family a little bit. They were shocked by this, absolutely shocked. And I believe it was the elder Sidoreski, Kelly, I believe was his name. He described Jake as being a little bit slower than George. Why is that important? Because that's the type of person that can be pressured and persuaded to do something as crazy as this by his mother and father. George stood up to his mother and father. George got in fistfights with his father. How many young men do that? George and his mother would scream and yell at each other. They didn't get along at all. You think if his mother went to him and said, "You're going to go kill these 8 people," you think George Wagner is going to do that? Hannah, his little sister, Frankie, his friend, or anybody else? George stood up. He was, I think the prosecutor even described him as a rebel. I guess he was of some sorts within that family. He was 16, he got his license, he got the hell out of there. Or he'd go hang out in the woods to avoid the chaos. He ran away when he was 16. As soon as he got a truck, he couldn't take it anymore. He got in the truck and he drove. And he drove to Kentucky. And he finally realized he's 16, right? He realized, what am I doing? I don't have a job. I don't have any money. I'm almost out of gas. I better turn around and go home. But he did that twice with Tabby, too. But Tabby talked them into staying because they needed a roof over their head. He didn't have the fortitude to break away. Does he wish he did? You better believe he wish he did. But he didn't have the fortitude to break away. That doesn't mean he didn't want to get away and he didn't try to get away. Mike from Alaska, the guy that was kind of his supervisor or boss there at the garage, and then Bernie Brown, right? You heard from both of them. Good stand-up people. They would offer George a job right now, even knowing about all these allegations. That's got to count for something. You remember Sam, Samantha, his friend, who he would take when she was having hard times? He took her Christmas cards with cash and toys for her kids. That counts for something. That tells you what George is like. And Alex, her, I guess they're still together, but they're separated. I'm not sure what their marital status is, but you heard him. George befriended him, helped him with his truck or his car. He described George as just a good old country boy. And he wasn't the only one. Not at all like Jake. Not really. You've heard a lot about social media, right? All these Facebook's accounts, everything like that. It's clear Angela was into that. She was hacking away. You'll see in the exhibits, she kept a notebook with everybody's name and social security numbers and passwords and phone numbers. She was a little strange like that. She's the one that would hack into the Facebooks. She's the one that paid attention to social media and topics. She's the one that after the murders couldn't get her face out of that and was telling George and anybody that would listen that they're being framed, even though she knew what had really happened. Chris Newcomb, you heard from him, right? George's uncle, technically, more like a brother to him, about the same age. That was kind of George's role model, right? About a year or two older than George, kind of taught him how to smoke, how to cuss, how to chase women. That was like his buddy, his role model, all right? Was around, helped build that new barn. Traded guns, right? Chris Newcomb never saw the 1911 pistol. He never saw this truck from Athens County. And one thing I got to say about these guns, there's been a lot of talk about a lot of guns, quite obviously. It's a gun culture, right? A lot of people like guns. They're legal, all right? And in George and his circle of friends and family, these guns, I compare them to like a $20 bill or a $50 bill, right? They're almost like money. They trade them for this, trade them for that. I like this one. I'll have this for 2 weeks. I'll get another one. You heard about trade days. You heard about, I'll trade a guy has a junker in his yard. I'll give him 2-3 guns, get the junker, chop it up and sell it for money and make money. That's what was going on here. This SKS that they found, Jake testified about that SKS. That had been in the family, I think he said, for 10 years or more. It was just as much his as it was George's. And George testified, he's had more SKSs than he can count. I mean, he's a gun guy. He trades guns all the time. And they never asked him where his SKS was. He testified. He sold it to Ben McCann. You hear anything to the contrary on that? You'll get an instruction from the judge. You'll have a copy of it. And the law requires you to view Jake and Angela's testimony with grave suspicion. That's the phrase. Grave suspicion. And I'm sure you'll do that. And I think after viewing their testimony with grave suspicion as the law requires, there's not proof here beyond a reasonable doubt that George was even up there. And we could offer him nothing for his testimony. He was vigorously cross-examined. You saw his demeanor. Compare that to Jake's and his mother's. His mother wouldn't even look at him. His mother wouldn't even look at him. And Jake was laughing and smiling and smirking when he talked about the murders. You're going to believe those people? Proof beyond a reasonable doubt? The most important of your affairs? I don't know what you folks are going to believe. If you believe, and I don't see that the evidence warrants it, but if you believe that George was up there, don't forget that Jake said he had no intent to kill. All right. He went along at the last second. He was there to protect Jake from Crazy Billy. Jake was a jealous young man. I think he's a deeply disturbed young man. To commit these crimes, you have to be deeply disturbed, right? There's no testimony George is the shooter. There's no reliable testimony that he was even there. And I implore you to look at the timeline that Jake describes and compare it to the phone records. And what the phone records don't show when people were killed, but they do show when people were alive. And if you look at the timeline that Jake describes, they don't match up, and there's a large amount of time that's completely unaccounted for. He says they left 9 o'clock-ish from Peterson Road. They don't come back till daybreak, roughly. All right? What is that? 9 hours? Something like that? He's at Chris's, probably scene 1, probably the longest amount of time, but not a long time. Claims that his dad is jiggling on the doorknob over at Frankie's at midnight or so. But Frankie and Hannah Hazel Gillard were still alive based on a phone record. They would have heard something. The coonhounds were howling. They would have heard something. That didn't happen. Dana was texting at 3:30 in the morning. According to Jake, she was already dead. So I implore you to look at what is reliable evidence, what is not reliable evidence. Jake and Angela are not reliable by any stretch of the imagination. This has to be proof beyond a reasonable doubt. There's all kinds of reasons to doubt that George knew about this or was involved before or after or that he was even there. He got up here and testified. Compare his demeanor to Jake and Angela. I could go on forever on this case, right? There are a million things to talk about. I probably missed some things that you think are very important. That doesn't mean they're not, all right? The only thing that's important is what you think is important. And so look at the evidence. Take time to understand it. Look at it from George's point of view, all right? Look at it from his point of view. As soon as I sat down, I know there's going to be something I wish I would have said. But I think you understand the defense position here. And I ask you to take it seriously. I ask you to return a verdict of not guilty to all charges. All charges. George wasn't even up there. He told you that. There's nothing credible here to say otherwise. Now, the state will never believe that. I don't have to convince them, fortunately. All right. But you took an oath. You followed that oath. You people have been tremendous. Your dedication. You've persevered through our delays and through other circumstances. We appreciate that. Hold the state to their burden of proof. And remember what we talked about in Blood Year, right? Proof beyond a reasonable doubt. Jake is gone for the rest of his life, thank goodness. Angela, they made that deal with her. George didn't do this. He wasn't there. It's not in his nature. He is different from Jake. He is different from Angela. And he got up here and told you so. What more can a man do? Confident you'll come back with a not guilty verdict after discussing everything. Thank you very much.
All right, thank you. Does the state of Ohio have rebuttal argument?
Yes, Your Honor, thank you very much. Ladies and gentlemen, Mr. Parker said something in his closing argument that absolutely destroyed not only the credibility of his argument, but the entire defense in the case. He stood up before you and he said, my client didn't do anything. You can't believe a word that Jake's saying. He's completely innocent. He didn't go up there. But if you believe Jake, he didn't shoot anybody. He didn't have the intent to do it. You can't have it both ways. You can't have it both ways. It's either the truth is either one or the other. You can't argue both. There's a saying in football that if you have two quarterbacks, you have no quarterbacks. And what that saying means is if you're trying to play two quarterbacks as part of your offense, you don't have a credible offense. That you're desperately trying to do anything you can to make something work. And that same rule applies here. If you're trying to put forth two defenses, it shows that you have no credible defense. It shows that you're doing anything you can to throw something against the wall and make it stick. To plant something in your mind. No worry about the truth. To plant something in your mind, in one of your jurors' minds. That will make you think, I don't know what to think. Right? And the reason they do that, the reason that's done is because he is guilty. He's guilty. He's guilty of the aggravated murder of Chris Sr. He's guilty of the aggravated murder of Gary. He's guilty of the aggravated murder of Hannah, Hazel, and Frankie. He's guilty of the aggravated murder of little Chris, of Hannah, and of Dana. And he is guilty of the murder of Ken. Now look, there's been no direct testimony that he actually pulled the trigger in any one of those murders. But you better believe he's up to his eyeballs in it with his family. As they plot, as they prepare, as they execute, as they cover up those murders, he's in it up to his eyeballs. And when he put on those dark clothes the night of this murder, when he put on that ski mask, when he left that house with his brother and his father and his mom saw him walk out, you know that at that moment, the plan was for him to get in the back of that truck and for him, actually, to kill Chris. And how do you know that? Right? How do you know that? He had the SKS and Jake had the 22. And any of you sitting here in this jury box who knows anything about guns knows that if you're going to kill someone at distance, at night, possibly a moving target, you aren't using a little 22 pistol. You aren't using a little 22 pistol with iron sights. No. When you're going to snipe somebody like that, you're using a high-powered rifle. You're using a rifle. Right? You're using something that's going to put that target down, preferably with one shot. Because guess what? If you don't put them down with one shot, the plan goes awry at that point. Things can go bad really quick. And who had the SKS? And Jake tells us that when they were laying there on the ground outside of Chris's house, and everything up to this point is going according to plan, for one reason or another, he didn't shoot. He didn't squeeze that trigger. And again, we don't know. Jake doesn't know why he didn't squeeze the trigger. Was that silencer on the end of the barrel, was it too big? Could he not get a good shot? Was there a problem? They were walking back from that grow house. Was there a problem with him moving? Was Billy too close? Or did he just chicken out? Did he just go, I don't want to do this anymore. I don't want to squeeze the trigger. I don't want to be the one to squeeze the trigger. All right? We don't know. We don't know what happened. And Jake tells you that when that happened, again, eventually he takes that SKS from his brother. Dad comes back out like, hey, what the heck is going on? You know, we agreed to do this. He takes that SKS. Dad says, I'm going to try to get him, somewhere where you can shoot him. And under the guise of, hey, I can't find my phone. All right, under the guise of, I can't find my phone. Can you call my phone? They get Chris to the inside, right at that front door. And again, all the evidence at the scene tells us this is exactly what happened. And when Jake sees him inside that front door, Jake shoots. And do you remember? Can you hit that space bar? Oh, okay. Yeah, all right. Do you remember? Oh, there it is. Do you remember how Jake described how he shot? He said he took that first shot and he knew he missed. And then he said he closed his eyes and just started squeezing. Now, he said he didn't know how many times he shot, but ultimately, we know on that porch area, there's 6 ballistic events outside the house, and we recover 6 7.62 tool ammo shell casings in those concrete buckets. So he shot 6 times. And these are the holes in the front of the house. And look at those holes. All right? That's a pretty tight shot group. When you look at the way Jake described what he did, that's a pretty tight shot group. He hasn't really thrown any of those shots too far. I mean, there's nothing really over on the other side of the porch or up high or low. That one on the left, he threw that one a little bit. But again, that one tumbled. So it hit something on the porch when it came through. But that's a tight shot group. For a guy whose night vision is allegedly terrible, for a guy who told you that he closed his eyes and squeezed the trigger when he shot, that's a pretty tight shot group. That's the kind of shot group you'd see from somebody who's got good night vision. Somebody who sees well at night. Somebody who we know hunts all the time at night with a rifle. Somebody who prides himself on being a good shot with a rifle. But Jake, when he came in here, he took the stand and he told you, first thing out of his mouth, all right, I love my brother. I don't want him to be convicted of this. Jake wants you to find his brother not guilty. That's what he wants out of this. And Jake tells you, again, that he didn't pull the trigger. Now, you know from his testimony, that we pushed him on that. That when he was being interviewed, we didn't believe him. And if ever there was a chance, if he was really wanting to throw his brother under the bus, like they allege, that was it right there. I mean, he could, if he was lying about what his brother did, that's where you threw him under the bus, right there. But he didn't. He fully talked about how his brother had participated and all the things that you heard that his brother did with respect to helping prepare the back of the truck, going up there with the intent to shoot, carrying the SKS, all of that stuff. He talked about all of that stuff. But he said, my brother didn't pull the trigger. And again, when you're weighing whether or not he's trying to throw his brother under the bus, you have to look at that. So because Jake says that, we don't have any direct testimony that this defendant was a principal offender with respect to those murders, that he actually was the one that pulled the triggers. But guess what? Under Ohio law, it doesn't matter. We're going to get instructed on the law here in a second. And he didn't have to pull the trigger once to be guilty of any of these aggravated murders. You see, the way the concept of complicity works in Ohio is that if two or more people set out to achieve a criminal purpose, a criminal goal, with one doing one part and others doing the other part, then each one of them is individually guilty as if they were the principal offender. That's the law. That's how it works. Now, the judge is going to instruct you on complicity. And Ms. Canepa talked about this a little bit yesterday. And you'll see that mere presence alone at a scene is insufficient to constitute complicity. If I'm at a scene, if Mr. Junk calls me after work today and says, hey, my car's broke down, can you take me up to Walmart? Sure, no problem. I drive him up to Walmart. I go in with him. I'm in the aisles with him. And he goes the next aisle over and he starts shoving a bunch of stuff in his pants, all right? And we walk through and I don't know about it. I walk through, check out with him, driving home, and as we're driving home, he starts pulling the stuff out. Hey, look what I stole. Ha, ha, ha. You know, I'm not guilty. Even though I gave him a ride up there, even though I was with him up there, all right, I'm not guilty. But change that fact pattern just a little bit, all right? He calls me up and says, hey, look, I need a ride up there. I hop in the car with him. As we're driving up there, he's like, hey, I'm gonna boost some stuff. I'm gonna shoplift some stuff while I'm up there. I don't really have much money. I'm gonna see if I can't score some stuff. And I'm like, Rob, I don't think this is a good idea, but yeah, I'll give you a ride. And I go in with him, and I kind of stay at the edge. And if anybody's coming, I'm gonna be like, hey, Rob, someone's coming, all right? And then we walk out, and I give him a ride home, and he goes his way. Look, now I'm guilty. All right? Now it wasn't just my mere presence at the scene. I aided, assisted, and abetted. And if you aid, assist, abet in any way, well, you're on the hook. You're on the hook just like the principal. So while it's not enough just to be present at a scene of a murder, there are certain things that you can't do if you know someone's going to commit a murder. All right? Number one, you cannot allow your credit card to be used to purchase items that are going to be used in the murder. And again, if Mr. Junk and I have a joint account, and I know he's going to commit a murder, and I know he's got to buy stuff, and we got a credit card on that account, and I know he's going to buy stuff to commit that murder, I got to be like, hey, look, don't use my credit card. All right? You didn't see that here. You didn't see that here. Number two, if an item that is going to be used in the murder is purchased with your credit card and it sets off your fraud detection, you cannot authorize that purchase. And you saw that in this case with that phone jammer. We know that phone jammer was purchased solely for use in this homicide. Angela tells us that. That was one of the things that she was supposed to get. She buys it. It's from China. It's fairly expensive. I think the sticker was like $500. By the time you throw the fees on it, it ends up over $600. A significant purchase on his credit card. So much so that the fact that it was from China and the fact that it was a significant purchase sets off his fraud detection. And you all know how fraud detection works. If you have a credit card, you probably have had this experience. All right? They call you and they say, hey, Mr. Wilson, we've got suspicious activity on your credit card. You know, yesterday it was being used to purchase something from so-and-so company in China. Did you do that? Do you want to authorize this purchase? All right. And at that point, I have to authorize it. You heard from Mike Kazar, the financial guy from BCI? Well, actually, you heard from Juliet. You heard from Julie Edslage that a day or two after that the phone jammer was purchased, there was a call from Cabela's to him. And that call went to voicemail at first, but then he called it back. And we know from the financial records at that same time, that phone detector went through. Or not the phone detector, that phone jammer. The purchase of that phone jammer went through. Right? That shows you that he's enough. That one thing is enough to show aiding and abetting. 3, you cannot agree with the reason that a murder needs to be committed, and you cannot adopt that reasoning as justification for committing the murders. All right? You cannot engage in the collective intent for why a murder should be committed. 4, you cannot take a single dollar out of a safe, a drawer, or anywhere else you keep money. And you cannot give that dollar to somebody knowing that they're going to purchase a vehicle or anything else that's going to be used in the murder. 5, you cannot go along with somebody when you know that they're purchasing a vehicle that's going to be used in the murder. You cannot go along with them for the purpose of purchasing that vehicle and jumping title on that vehicle so you guys don't ever even show up in the chain. 6, you cannot hold one board. You cannot put in one screw. You cannot put in one nail into a false bed that you know is going into the back of a truck for the purpose of committing a murder. You cannot lift, move, or hold that false bed in any way, shape, or form, again, knowing that it's going in there for the purpose of facilitating a murder. And you cannot lift up, move, or handle one hay bale or one straw bale onto that truck or hand it to somebody to put on the truck, knowing that that truck is going to be used to commit a murder. 7, you cannot sign false custody documents so that if something happens to you, if you get shot by the people you're trying to murder, or you get arrested, that your kid will go to your mom. That's estate planning. Really, that's what that is. That's estate planning, custody planning. You cannot do that in anticipation of murder. Certainly, you cannot have those forms or backdate those forms. You cannot put on a mask, gloves, dark clothing, and stow away in the back of a truck with the purpose of going to a scene that's going to be a murder scene. Obviously, that one's pretty apparent. You cannot allow an SKS rifle that you own to be put in that truck, to be taken to a murder scene, and to be ultimately used in that murder. You cannot slide out of the back of that truck and take up a firing position for any reason, whether it's to kill somebody or whether it's to pull security and protect somebody so that they can kill somebody. You can't do that at all, or you're on the hook for murder. You cannot enter into a crime scene after people have been shot and remove or move any evidence from inside that crime scene. That includes moving bodies from one room to another. You cannot accompany people for any reason on a reconnaissance of residents or other houses, knowing that the purpose of that reconnaissance is ultimately to kill the people inside. You cannot stand by as a lookout, as an early warning system, as muscle, so that other people can look for a way into a residence, ultimately to kill the people inside. You cannot enter a house and stand guard by a door or in front of a bedroom so that your co-defendant can go down to the other side of the house and kill the people inside. Can't do that. You cannot drive an extra vehicle to the area where your co-defendant is going to kill somebody, your co-defendant is going to kill somebody, and then man that vehicle to act as an early warning system or as an escape route, escape option, if things go south. Now, I actually want to talk about this one for a minute. This is brilliant. When Mr. Parker stands up here and he talks about, well, why would they take that truck? You know, why would they take, there's no reason for them to take Chris's truck. Man, their use of those two trucks, and we didn't know that they had used that GMC truck. We didn't know that that was even part of the plan. We didn't know that's how it went down. But man, actually it was pretty brilliant. Because if you think about it, again, you don't need, the truck is parked at Chris's when they get there. They kill Chris. And you don't need to move that truck to go down to Frankie's. You can just walk down to Frankie's. But then they hop in that truck and they do that reconnaissance. And again, any driveway you have to pull into, any house you have to pull into with Chris's truck, the people, if they look out, if they're outside, someone's outside smoking a cigarette, all right, and that truck pulls up in the dark, they're just going to be like, oh, Chris is here. They're not going to take defensive action or get nervous or anything like that if a strange truck pulls up. So it was brilliant to actually use that truck. Now, when they went down to Dana's, they didn't need to drive that second truck. All right, they just took Chris's truck down to Dana's. Again, makes sense. Because if they have Chris's truck down at Dana's and something goes south while they're committing these murders and they got to bolt out of there, they're still close enough to where their GMC truck is parked. They can walk. I mean, what is it, a half mile, 3/4 of a mile? They can boogie back down to Chris's house and hop in that GMC truck. And now, again, they've left Chris's truck at Dana's, which again, isn't unusual, wouldn't be unusual, wouldn't draw any super suspicion. So it makes sense that they wouldn't have to drive that black truck. But when you look at going to Kenneth, all right, that's too far. We took you out there, that's too far. You've got to have an escape vehicle if something goes south. Again, they take Chris's truck right into the driveway, makes perfect sense. If Kenneth looks out, hey, my brother's here, again, he's not going to be on alert for whatever's going down. But if for one reason or other, while they're in Kenneth, something goes south, right? You need to have that other truck parked up the road. Because now it's too far to walk all the way back to Peterson. It's too far to walk back to that truck if you still have it parked at scene 1. You need to bring that truck as a potential escape. So if something goes south at Kenneth, you can beat feet, you can get in that truck with George, and you guys can go on home. Right? And that's what he did. That's what he did. He was down the road, and we see those two trucks leaving on that camera. You see them. Again, when you look at it, and when he asked you, well, why would you use that truck? When you step back and look at it, it makes perfect sense. You cannot, shortly after the murder, strip out of your clothes that you used, hand them to somebody knowing that they're going to be destroyed as evidence. You cannot help your co-defendant dig a hole, knowing that evidence from the murders is going to be buried in that hole. You cannot, shortly after the murders, buy a replacement pistol to take the place of one that you either destroyed or used in the homicide. You cannot come up with false explanations for evidence that investigators have against you and then feed those false explanations to your co-defendants. You saw him do that in this case. All right? When Ryan Scheider, Agent Scheider, shot them that picture, or texted them the picture back 1911, and said, hey, I want to talk to you. And when they were going around again, showing that 1911 to family members, knowing that ultimately the family members are going to call and be like, hey, FYI, they showed us a picture of this gun. All right? You cannot say things like, Jake, that's just a picture of that. That's been photoshopped into your hand, Jake. That's a picture of you catching a fish and holding the fish up in Alaska that they photoshopped that 1911 in. Or, again, when you're showing the list that shows that 1911 and the SKS under your name, you can't say things like, oh, Jake, that's just a wish list. Shouldn't make any more wish lists. Right? That's certainly indicative of a consciousness of guilt. Because if you're innocent, if you truly don't know anything about these homicides or your family's involvement in the homicide, the conversation goes a little more like this. Jake, that sure looks like that 22 that you bought when we were at that gun show. Or, Jake, come to think about it, I haven't seen that 22 of yours in quite some time. Or how about this? Hey, Jake, show them the 22. They're saying this is your 22. I know you got a 22. Show them the 22. That's how that conversation goes. It's not like, well, that's just been photoshopped into your hand. And while we're talking about what you would expect somebody who's innocent to say on a wire, or to say in a normal conversation, all right? What about at the border? Did you pick up on this? At the border. So if you're truly innocent, if you have no idea that your family is involved in this at all, and you sit through a 4-hour interview where they show you evidence, they show you bloody footprints in a crime scene, they show you shell casings and ballistic evidence that was found at your house, that matches shell casings found at the scene, showing that the gun that was used in the murders was fired at your house. And they show you pictures of your mom buying shoes, and they tell you, hey, oh, by the way, your mom just said she bought these for you. All right? You better believe that any one of you, when you get out to that car, and your mom and dad are sitting in that car, you're going to get in that car and you're going to be like, what the hell was that? What was that? Mom, they showed me pictures of you buying shoes, and they said that you bought them for me. I don't know what they're talking about, Mom. I didn't have any shoes. Mom, how in the world are shell casings from the murder scene matched to our house? Dad, how is this happening? You didn't hear one word of that. You know why? Because he knew. He knew. And guess what? Angie caught him in the lie. When he was on the stand, Angie caught him. What did he tell you? What did he try to explain his reason was for, well, I know that's not how people normally work, but I was worried about Bullvine. He was acting kind of funny. I thought BCI had poisoned him. But guess what? His reason for thinking that, he told you, was because Sophie said they gave us something red to drink. That was the first time they gave us some juice or something like that to drink. That was the first time, BCI might have planted something, or might have poisoned my kids. But what do we know? And again, Ms. Canepa pointed this out in cross-examination. Sophia didn't come out for an hour. He was in that car for an hour, sitting quietly, not saying anything, after he'd just gone through that interrogation. Now, you know what happened, all right? You know what happened. He gets out to that car, and his dad's like, he's giving him hand and arm signals. Hey, we've been bugged. All right? Again, if you are innocent, if you have no idea that your family is involved in this, and you just sat through that, and they're telling you the car's bugged, so what, Dad? We didn't do anything. What's the big deal? But they couldn't do it. They couldn't do it. They didn't have their story straight yet. Remember? Angela had been hit with something they weren't ready for, the shoes, the picture of her buying the shoes. They have got to separate themselves from an area where they think is recorded and have a family meeting so they can discuss, oh hell, how are we going to explain this one? How are we going to get our story straight on this one? All right? That's what happened. That's what happened. And it shows, again, it shows that he's guilty, that all of them participated in all phases of this homicide. And finally, again, this is number 20. I've just run through 20 reasons, or 20 things you can't do. The 20th thing is you cannot pressure witnesses to not talk to law enforcement, knowing that that witness has information that may implicate you or your co-defendants in the murders. All right? Again, I gave you a list of 20 things that these folks did as co-conspirators, as co-defendants, as co-complicitors. All right? Now, here's the kicker. That's not a cumulative list. And I'm sure as you sit there and you go back and deliberate, you'll think of other things. But that's not a cumulative list. You don't have to do all of those things. If you do any one of those things on that list, well, it shows that you have the purpose to aid and abet. It shows that you've accepted that group intent, the collective intent. And it shows that you're guilty under complicity theory of murder. Now, I want to talk to you real quick. You're going to get, these are the jury instructions. You're going to get, this is the stack of jury instructions you're going to get. All right? And in each count of this indictment, 22 counts, each count, you're going to see this defendant is charged as the principal offender. All right? And I want to talk specifically about count 1 through 8. And Ms. Kneva, she pointed out a couple where we believe that this defendant actually could be or is the principal offender, but the overwhelming majority of the charges in this case, we're claiming that he aided and abetted. That's our theory of the case. And the reason I want to talk to you about that is, again, let's talk about the murders. You'll see that he's charged as the principal offender in counts 1 through 8, which are the aggravated murder. And the language in that, I'll paraphrase for you, but it's set up as a principal offender. So on or about April 22nd, 2016, in Pike County, or in the course of conduct in Pike County, George Wagner did, with prior calculation and design, purposely cause the death of another. That's the way it'll be set up. All right? Now, it's important because it's written in the principal language, it can get confusing. When you look at that, you're like, well, he didn't pull the trigger. All right? So he didn't purposely cause the death of anybody. But if you go to the back, to the end of these instructions, one of the last things the judge is going to instruct you on is complicity. And you'll see that complicity applies to every count in this indictment. And ultimately, when you go back and deliberate how you do it, that's for you. But I'm going to give you a suggestion, all right? I would suggest that somebody, if not all of you, take the complicity language out of this stack, because it's a big stack. And as you go through each offense, or each count, have the complicity set aside and apply it to each offense. So when you read the count, read it along with complicity, and then say, hey, look, did he do the things in complicity as applied to this count? It's important. It's important because even though each of these counts is written as the defendant is the principal offender, if you apply the complicity language to the count, and you find beyond a reasonable doubt that he was complicit, that he aided and abetted, then he's guilty of that count. And if he's complicit, then anything the principal offender, if he aided and abetted, anything the principal offender did with respect to that count is imputed to him. That's the way the law works. And that's our theory of this case with respect to the murders. Now, I spent a long time talking to you about complicity and the law of complicity. I want to talk for a second about the theme or theory of this case. Can you hit that button for me? All right. I want to talk to you about the theme of theory. Because Mr. Parker spent some time talking about the theme of theory of the case. And I want to put a picture up for you. There it is right there. Now look, when you first heard about these murders, all right, even before you were a potential jury member, when you heard about these murders out in the community, I'm sure, just like Mr. Parker argued, in your head, somewhere along the way, you're like, nah, there's no way this could be about custody. Nah, there's no way you'd murder 8 people over the custody of a child. Nah, surely you would do something else if you really wanted to have custody of a child. I want you to look at this picture. Man, this picture speaks volumes. It speaks volumes. Now, that picture was taken after the murders. How do we know? Well, Jake looked at it, and he told us it was after the murders. But look at Billy's hand. He's holding a little one there. So if you look at his hand, he's got the scorpion tattoo. And we know he got that tattoo on his trigger finger after the murders. Now, the defense, Mr. Parker stood up here in front of you, and even Angela and Jake, they don't want you to believe that this case is about custody, that these murders had anything to do about custody. But make no mistake about it. Those 2 children in that picture were never going to be raised anything other than Wagner. It wasn't going to happen. And while custody may mean different things to different people, the bottom line is, after these murders, these 2 children lived in the full-time custody and control of the Wagners. Now, to achieve that goal, the goal of raising these 2 children as Wagners, they basically stole Bullvine. All right? Now, again, you heard Tabby sign those papers. She didn't have a safe place for him when she first left. She wasn't in a good position to take care of him when she first left. But she signed those papers, again, understanding that one day she would be reunited with her kid. That one day she would be able to see her kid under her terms. And when it became apparent that she wasn't going to be able to do that, she tried to get him back. But that was never going to happen. It didn't matter if she got a job. It didn't matter if she lived in a nice, clean house. It didn't matter if she was away from her family. She was never going to have the kind of custody and control of her child that she wanted. And if you look at that picture again, while they stole Bullvine, they wiped out an entire family to get to Sophia. To achieve that goal, they went to those ends. And the defense wants you, as we look at the theme or theory in this case, the defense wants you to mistake motive with justification. All right, think about that. The way the Wagners justified these killings in their head and amongst themselves is to protect Sophia from being abused by the Rhodens. But let's be honest. Let's be honest. You know why the Wagners never called Children's Services? You know why the Wagners never took her to the doctor to look into these sex abuse claims? You know why they never called Children's Services? Because it wasn't true. It wasn't true. It wasn't true. They made terrible allegations about this family amongst themselves. They couldn't do it out in public because it wasn't true. And how do we know it didn't happen? Because it's the same type of abuse claim they made against Tabby and Pat. It's their playbook. And in the law, we call that common plan or scheme. All right? And you can use common plan or scheme to show intent or motive. And with the Wagners, the common plan or scheme that they use to try to get sole possession of, to get sole control over these kids, is they fabricate claims of abuse against moms or potential moms to push them out of the picture. Now look, it worked. It worked with Tabby. It worked with Beth, but they weren't as strong as Hannah. Hannah wasn't playing that game. Tabby and Beth, they didn't have a support network. Guess who did? Guess who had a whole family behind them? Hannah. And you know what? Her family was never letting his brother, letting his mom take Sophia the way they had taken Bullvine. It wasn't happening. And they knew this. The Wagners knew it. As a matter of fact, they were scared of the Rhodens. Remember in Billy's first interview back in September? You heard it. You heard it really early in the trial. In his first interview back in September 2016, he tells the investigator something about Chris, something like, hey, look, if you're going to fight him, you better put him down because he's going to just keep coming at you. He also said something in that same interview, you fight one of the Rhodens, you fight them all. All right? That was in their head. They knew what was up. You also heard the recording from Jake's truck. When they were up there doing a custody pickup and he's in the car, he's freaking out. Get out of here. Get out of here before Chris and them get out. No, don't go by the house. Don't go. He's scared. They are scared of the Rhodens. And they knew they were never prying Sophie from her family. So what do? They go to their go-to, their fallback, their collective motive of sex abuse. And they use that to justify the claim to protect Sophie. They use that to justify the need to commit murder. And even though protecting Sophie was how they justified their head, man, make no mistake about it. Their desire to have Sophie and to raise her 100% Wagner was why they did this. Think about that for a second. If you look at that desire, at their need to raise these children the way they wanted to raise them, to raise these children 100% as Wagners, and you peel back the idea, the layer, the theme or theory of this case, just one more past custody, you'll see what this case is really about. It's about power and control. It's about control. And think about it in your lives. If you know anyone in your life who has a control issue, struggles with control, it could be, again, a family member, boss, ex-boyfriend, girlfriend, ex-spouse. Man, the playbook is the same, almost the same every time. And you see it play out in this case, almost textbook. Almost textbook. Often the need to control someone comes from a place of fear. Fear that you're going to lose the person. Fear that you're the only one who can protect the person. Fear that other people will negatively impact your relationship with that person. Fear that the person you're trying to control will like other people more than they like you. And you see that in this case. Again, if you think about it, the need to control someone follows a fairly common pattern. What do you see in these situations? Well, the person being controlled is cut off from outside influences. They're cut off from family members, friends, co-workers. The person being controlled is indoctrinated with the controller's beliefs, their values, their norms. The person being controlled is unable to establish their own identity, their own belief system. And the person being controlled is under almost near surveillance or observation. And another trait that you see in these situations, again, with controlling people who are starting to lose control, are scared that they're not going to be able to control the person anymore, is all of a sudden you see them resort to desperate measures. The Wagners need to control how these children, how the grandchildren are going to be raised. That's a group trait. That's a group characteristic. They all subscribe to this idea. And clearly from the evidence, the primary control freak in this family is Angela. There's no doubt about it. She's the one, you heard her on it. There's no doubt about it. She's the one who's the control freak. But you listened to those recordings from the summer of 2018. You actually had the aids that allowed you to kind of follow along. When it comes to the need to control the situation with Beth, the need to protect the children, the need to say how the household's going to be run, right down to who can and can't use the front door. Who's running the show? It's him. Man, on those recordings, it's him. He sounds just like Angela. Just like her. He wants everyone to know that he's calling the shot. He wants everyone to know that he's making the rules with respect to things, how things are going to be with the kids, and how they're going to be with the household. He even threatens Jake. He says, Jake, look, if you're not going to do what you need to do to protect your kid, I'm going to take her. He's the one that has the control issues, just like Angela. Did you hear, it was hard to hear, but did you hear on that recording him manipulating Bullvine after they crossed the border? Did you hear that? Bullvine, those people are bad people. They want to kill your daddy. They want to kill your uncle. They want to kill your grandpa. That's what manipulation looks like. That's what control looks like. And he's just like Angela when it comes to that. I'm telling you, it's the same intent. It's a collective thought amongst them. And you heard those calls. There's no way if Angela thought or was claiming that Sophie was being sexually abused back in the beginning of 2016, no way he's not involved. There's no way he's not putting his 2 cents in. No way. If Jake and Billy are going up the hill to kill the Rhodens, there's no way George is sitting on the sidelines and letting that happen without him. Jake's apparently nearly blind at dark at night. He can't drive at night. He drives at night. Billy's got a broken back and strung out on drugs. Through Billy's own words, again, we know Chris and Kenneth aren't people to be taken lightly. George's the protector. George is the strong one. George is the good shot. George is the fighter. What were Angela's words? George loves Sophia. He wouldn't let anything happen to Sophia. We all wanted to protect Sophia. Do you think for 1 second the guy you heard on that recording is sitting this out? No way. No way. Let's use his words. Let's use his own words. He was coming, and he was bringing hell with him. This isn't the guy who sits on the sidelines. And we can call it custody, we can call it protection, but the bottom line is it was always about control. And guess what? For a year and a half after they slaughtered the Rhodens, they had it. They had exactly what they wanted. These children were being raised 100% Wagner. And now, he wants to control the outcome of this case through his bogus stories. I want to take a few minutes and I want to talk to you about the why behind the deals with Jake and Angela. We talked about the deals, we talked about how we gave them, but I want to talk about the why. Mr. Parker brought it up. All right? The defendant wants you to believe that Jake's our star witness. That the whole case rises or falls on Jake. Let me remind you, I don't need to remind you, let me remind you, we laid out about 6 weeks of testimony before we ever put Jake on the stand. And I know it was long. I know it was tedious. I know there had to be times where you were sitting there like, okay, just put Jake on the stand. We want to hear from Jake. But we did it this way on purpose. We wanted to show you the depth and the complexity of BCI's investigation. We wanted to show you that BCI, they didn't just lock in to the Wagners. They didn't just lock into the Wagners to the exclusion of everybody else. And if you remember, it wasn't even until about September of 2016 that the Wagners really even popped up on the radar screen. that we really started to act like, hey, we're going to have to rule these guys out. And there were a couple things that happened in September of 2016 that were like, uh-oh, this is kind of a red flag. The first was Jeff Tackett and Charlie Gilley both independently told BCI that Billy was telling them stories about why the Rhodens got killed. And do you remember? He told, both of them independently said, Billy told me that he and Chris were involved in a drug deal with Skid Montgomery. And we cut him out, and that's why Chris got murdered. Now, again, you heard investigators, well, this is kind of interesting, right? For a couple reasons. First of all, because they independently told the same story. And second of all, they're like, if he's telling people that he and Chris were involved in a deal where they cut Skid Montgomery out, and Chris's entire family ends up slaughtered, but Billy's doesn't have a scratch on it? Well, that's kind of interesting. And it was interesting enough that, again, we're like, let's talk to Billy. And again, September 2016, you heard the recording of when they talked to Billy. They talked to him out in the parking lot up there, and a couple interesting things stand out in that interview. Number one, he lied about his phone activity. Point blank lie. All right. He told you when they were trying to get his phone. They wanted to get the phone that he had after the homicide. He said, "Oh, I don't have that anymore. I broke it." And do you remember why he said he broke it? I broke it because Chris and I are best friends. And after the murder, I just kept accidentally calling him. And I just got mad one day because he was dead, and I kept calling him, and I smashed that phone. Well, we go and look at the phone records. And guess what? There's not a single call from Billy to Chris after the homicides. So we're like, that's interesting. The next thing is, we look at phone records. Our analysts look at the phone records. And you can see those couple of calls to Billy, from Chris to Billy the night of the homicides. And they go unanswered. But the next morning, Billy gets up and right away, he calls his voicemail. And after he calls his voicemail, again, even though Chris's calls went to voicemail, there's no calls to Chris. And we know he wouldn't have known about the murders, at least for a couple hours in the morning. So your best friend in the world is calling you rapid fire the night before. It's going to voicemail. You pick up the phone and you don't call it? Why? Well, because you know he's dead. You know he's dead. Another interesting thing he said in that first interview is he gave the investigators really the first look at why all 8 of the Rhodens might have been killed. And you heard Agent Scheider talk a little bit about their investigation. They just couldn't, one of the things they couldn't figure out is why all 8? I mean, you could see, okay, if Chris and Kenneth get killed, they're both growing marijuana. Maybe it has something to do with that. If, for one reason or other, somebody's targeted down at Dana's, well, why go all the way out to Kenneth's? And it just wasn't adding up as to why all 8 were wiped out in one night. But during that interview, Billy tells the investigators, hey, look, you're going to fight one Rhoden, you're fighting them all. And all of a sudden it's like, well, wait a second. Maybe I had to wipe them out to prevent retribution or retaliation. And that's the first time that really kind of started to play into the picture. The other thing he did is he gives the same basic story that Charlie Gilley and Jeff Tackett told about the Skid Montgomery deal, except for he leaves himself out this time. He leaves himself out of the story. He didn't say anything about him being involved in or being in danger. And what you saw, again, based on that interview, the way we do things, or the way they do things, is they rule people out. They look for ways to rule people out so they're not suspects anymore. And after that interview, like, we can't rule him out. As a matter of fact, we probably ought to keep looking at him. So through the fall of 16 and winter of 17, you heard testimony about the investigators, the analysts looking into the Wagners. and trying to find something, anything, that will allow them to rule them out as suspects. And again, through that time, they weren't necessarily classified as targets or suspects at that point, but they certainly weren't ruled out either. And some of the things that you heard that they looked at, Facebook records, and they saw, hey, the way the Wagners are telling us everything's just rosy with custody doesn't play out. It's not the same thing we're seeing in these Facebook records. And you heard about the tower dump. Again, Ms. Canepa talked about it, but the first time in 2016 that Billy spends the night at Peterson Road was the night of the murder. Oh, which reminds me, in opening statement, they said, hey, he didn't know anything about these murders. He wakes up the next morning and everything's just normal. Everything's just normal, everything's fine. Guess what? It wasn't normal. His dad was there. His dad had spent the night. And that stands out to investigators. They're like, that's suspicious. And again, you hear that this type of evidence causes these investigators to continue to look at the Wagners. And eventually you heard about them getting the search warrants. And eventually you heard about them downloading the phones. And what you see is, as a result of that, they recovered the shell casings from Peterson Road that were fired from the same gun that killed the Rhodens. And at that point, now they're in the crosshairs. At that point, when you find shell casings that match shell casings from the scene, you better believe you're a suspect at that point. And that's when, again, I'm not going to go, Ms. Canepa covered this yesterday, I'm not going to go through all the other evidence that they recovered at about that time. But, again, it was clear at that point that they were suspects and the investigation turned towards the Wagners. Now, the reason I wanted to recap all of that with you was to show you that BCI had the Wagners. They had them long before Jake ever comes forward. The evidence that BCI recovered had all of them as complicitors. It did. It had each and every one of them. Angela says, I bought the shoes for my boys. There's 2 different shoe prints in the scene. Right? That type of evidence had all of them participating, or at least complicit, in these homicides. And again, 99% of the evidence that you've heard in the course of this trial, that you've heard over the last couple of months, 99% of that evidence was recovered from the hard work, the dedication, the tenacity of BCI investigators, BCI analysts, BCI scientists. It was good old-fashioned police work, not the cooperation of Jake and Angela. Jake Wagner is not the state's, he's not our star witness. He's a terrible, terrible human being. He's evil. And he's going to spend the rest of his miserable existence locked in a cage. He's going to spend the rest of his life separated from what means most to him, his family. He will never be free again. And as incredibly distasteful as it was, the state entered into an agreement with Jake for one reason. We needed one thing from him. Guns. That's what we needed from him. Him leading us to those guns was incredibly important. Do you know why? You actually saw it. When this trial first started, you saw some of it in the questions that they were asking about the drugs. And there was a lot of emphasis early on when we were doing the scenes about the drugs at the scene. And you heard about it again when Billy talked about Skid Montgomery. The reason we needed those guns was because of the drugs. The Wagner's defense, from the moment they planned this homicide, the Wagner's defense was going to be that the Rhodens were killed because of Chris's drug activity. It's the reason he lied to the investigators at the border. They couldn't put Billy in it because that question would be asked. Well, why wasn't Billy killed too? Again, the reason Billy was running around town telling people about this drug deal. Their defense in this case was going to be, look, as a family, we didn't have any problem with the Rhodens. Everything was fine with Jake and Hannah over Sophia. Custody, there was no custody problem here at all. We loved Hannah. We loved her like a daughter. We loved her like a sister. Chris was Dad's best friend. Frankie was my best friend. We went to their 4th of July parties. Our family would never hurt theirs. Chris had to be murdered the family had to be murdered because of Chris's drug deal. That had to be what happened. That was going to be their defense in this case. But when Jake led us to the guns, it flipped that defense 180 degrees. No longer could they come in and use that defense. Not only did it destroy their defense, it destroyed all of the rumors that you had heard out in the community before you became part of the jury. All right? No more arguing. No more arguing. It was the cartel. No more arguing that, hey, Chris Jr. got in this fight. He did. Chris Jr. got in a fight a couple weeks before these murders happened where somebody in the fight actually threatened the entire family. You don't think we would have heard that as a defense? You don't think we would have had to play defense against that? Gone. No more arguing it was the dirty sheriff who's now in prison. All of those arguments could have been and would have been used to try to plant seeds of reasonable doubt in your mind. Guaranteed. Guaranteed. Can you imagine how much longer we would have been here if, in addition to proving that the defendant was complicit with his family in committing these murders, we would have had to actually rule out all of these other defenses? It would have been astronomical. All of those arguments were gone the second Jake led us to those guns. And as a result, the defense changes now to, I'm the black sheep of my family. My brother hated me. I hated him. He's making this whole thing up just to get a deal for himself. But guess what? That doesn't match. Doesn't match the evidence. Doesn't match what you've heard. There's a couple problems with that defense. First of all, you heard from the stand, if he's trying to claim, oh, Jake's only doing this to get rid of the death penalty for himself. All right? You heard Jake testify that he originally told his defense attorneys about his brother's involvement in what happened a year before he authorized them to try to get a deal. A year before. He didn't make this up to get a deal. As a matter of fact, when he originally told his defense attorneys, he still wanted to go to trial. He was still going to have a trial. It wasn't until a year later that his defense attorneys came forward and tried to get a deal. And guess what? That deal wasn't just for him. It was for the defendant. He didn't just get the death penalty off himself. He got the death penalty off of the defendant. There is no more death penalty in this case. You are not going back to vote on the death penalty because of Jake. Not because of the defendant. You heard the 2018 recorded conversations. Again, those gave you a pretty good sneak peek at how the family interacted with each other. And again, what the defendant is trying to sell you with respect to the family dynamic is just not true. Just not true. And finally, Angela independently verified what Jake said about George's involvement. And I want to talk to you for a few minutes about Angela and about her deal. You heard that she gave us her statement in August of 2021. It's about 4 months after Jake talked to us. And it was important for us to independently verify some of the things that Jake had said, especially about, now, we had the guns, obviously that was good, but now we wanted to independently verify some of the things that he had said with respect to other family members' involvement. We needed to do that. So in August of 2021, 4 months later, we sat down with Angela to talk about her version of what happened. And you heard that we had not given that statement to anyone. We had not given Jake's statement to anyone. We purposely held it so that nobody else would know what Jake said. At the time that we met with Angela, she had no idea. Now look, she's a terrible human being. There's no doubt about it. She's evil, and what she did with respect to instigating and manipulating this led to these homicides. And even though she didn't go up to Union Hill Road, you better believe she's complicit in what happened here. She's not the state's star witness, but what she does do is she independently verified what Jake told us. And let me tell you, especially, again, with each and every family member's participation. And let me give you an example of how it helps. All right? So, let's say we sit down with Angela in August of 2021, and she tells us the defendant's version of the story. George didn't know anything about this. He didn't know anything about this. We kept it from him, and he didn't participate in any way, shape, or form. Well, if she tells us that, then now we know we have a problem with Jake's statement. All right? That for one reason or other, he's trying to sell his brother out. But obviously, that didn't happen. So let's look at it another way. Let's say that she tells us when we sit down with her, hypothetically, that she tells us, when George got home from the murders, we all talked about it. And he told me that he actually killed 3 of the people. He actually pulled the trigger on three of the homicides. Again, if she tells us that, we know we got a problem with what she said, or with what Jake said. Either Jake is downplaying his brother's involvement, or she's overplaying his involvement. But obviously, that didn't happen. What did happen was her cooperation allowed us to overlay her statement with what Jake had said 4 months earlier. And guess what? They matched. They matched. The only way that happens without her knowing what he said is if they're telling the truth about what they observed, what they knew. That's the only way that happens. As distasteful as it was to deal with both Jake and Angela, man, their testimony corroborated what the investigation had uncovered. Their testimony and their statements corroborated each other. And their testimony and their assistance helped remove all of the white noise, all of those other defenses that we would have had to deal with. And their statements and their testimony show that everybody in the family was acting under the same collective intent, and that everybody participated in the murders, and that everybody is guilty. I'm going to do some rapid fire now with you. All right? Mr. Parker, in his closing argument, specifically talked to you about the phone records. He wanted you to pay attention to the phone records. The phone records in this case do corroborate Jake's statement. They do. Specifically, I want to point out an anomaly in Dana's records. All right? You're going to have this document back there. It's going to be one exhibit. This is Dana's phone records from the last night. And you'll see I highlighted actually the last 7 texts are highlighted. What you'll see if you look at this record is that Dana was engaging in pretty good texting back and forth until just after midnight. Just about midnight. And then there's almost a 3.5 hour gap before there's any other activity that's recorded by the records. And then at 3:31:38 to 3:32:08, you have a series of 7 texts, all to the same number within 30 seconds of each other. All right? And I say that's an anomaly because it doesn't make sense that you'd have a 3-hour gap and then all of a sudden you'd have these 7 texts, all the same number, bam, 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 just like that. All right? And you heard testimony here that phone reception's terrible out there. All right? You also heard testimony that they used a phone jammer that night. You also heard testimony that at some point during the night, Jake popped on and powered up one of those phones to see what time it was. Because again, they didn't have a clock with them, or they didn't have their own phones. So he powered up one of those phones to see what time it was. Have you ever, again, you're allowed to use your own experiences. Have you ever had one of those experiences where you're out of service or don't have service, and all of a sudden you pop back into service or something happens, and all of a sudden you get bing, 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 a bunch of texts that all of a sudden pop up, and it's clear from the context of the text that they were sent earlier? I'm telling you, as you look at these messages, it doesn't make any sense other than that explanation as to why you'd have that gap. She shuts down. I mean, she's going, again, pretty regularly, right up until a little bit after midnight, and then nothing. Nothing until that series of texts. Look, she wasn't alive at 3 o'clock. She wasn't alive at 3 o'clock. All right? She's killed sometime after that midnight, before those texts were released or showed up on her records. That's what that shows. And when you look at that, again, it's consistent with the security camera where they pick up the vehicles. It's consistent with Jake's testimony about what he saw. Or excuse me, what they did. When Mr. Parker was talking to you, and he was talking about Angela's testimony, one of the things he said to you as he was talking is he said, hey, look, she watched Billy and Jake walk out the door, and then she just went to bed. She didn't call 911. She didn't call Hannah. Do you remember him saying that? And he said she watched Billy and Jake walk out the door. That wasn't her testimony. Her testimony was all 3 boys walked out the door. And that intentional misstatement, again, shows you the desperation of this defense. Because they know he's guilty. They know he did it.
Basically. Well, again, this is argument, but we do need to watch what, trying to say what Mr. Parker knows.
Okay.
The jury, of course, understands that this is argument, and the jury will rely on its collective memories as to what the evidence is. So I'm going to let you continue with your argument.
Thank you, Your Honor. I want to talk about the shoes. He's talked about the shoes a little bit. She testified that she bought those 2 pair of shoes. And he wants you to believe that she bought those shoes for Billy and Jake. That's what he said when he got up there. 2 things about that, all right? Number 1, we surprised her at the border. She was not ready at the border to be confronted with those shoes. And what did she say at the border? She said, I bought them for my boys. All right? And she, again, confirms it a little bit more by saying they didn't like it. They thought they were old man shoes, like your papaw shoes. It's clear. Again, when she's surprised, out of her mouth is coming what happened. She's trying to explain what happened. She bought those shoes for Jake and George. No doubt about it. Take it a step further. Knowing what you know about how this murder was committed, all right? There's no way Billy's wearing those Walmart athletic shoes the night of the murder. Because he's got to interact with Chris and Gary. Remember, he's the one that's doing, like looking at the weed or setting up this deal or whatever the cover story is. What do you think Chris and Gary would have said if Billy comes rolling up in those Walmart shoes? You know, Billy wears boots. Billy wears... Come on, man. He can't walk up there in those Walmart shoes without them being like, what is going on? He was dressed just like he was normally dressed when he was interacting with them because he couldn't draw any suspicion to them. They were in the back because they were the ones actually who were supposed to do the killing. They were the ones who had the mask on. They were the ones who were suited up. They didn't have their shoes on. Mr. Parker said that Jake was the only one in crime scene 1. And he talked about the inside of that scene a little bit. I don't want to bog down in this, but I'll tell you, just talk about it a little bit. Look, the evidence, their expert actually told you, the evidence in the scene actually can tell the story better a lot of times than a witness can. And there's no doubt that when Chris was shot, when he was initially shot at that SKS, he was standing inside that door. Those bullet holes are through that door. He wasn't on that porch. There's not a shred of evidence that he's on that porch. There's not a drop of blood on that porch. He got his arm nearly severed off by that SKS round, and there's not a drop of blood, not a smear of blood on the outside of that house. He was inside the house. Why is that important? That's important because the story of only one person, or one shooter, doesn't work if Chris is shot inside the house. It doesn't work. Because there's no evidence at all that he tried to flee, tried to move. He shot through that door with that SKS. And I don't know if you remember when I was cross-examining the expert, he never gave it up. But you could see the moment when he realized, oh, I might have made a mistake. Right? He based his assessment on, remember those wood chips in Chris's head? He talked about, well, those came from that wood out front. That's not wood. That's pressed like laminate. It's sawdust and glue is what it is. There's not splinters in that. What is in Chris's head are actual splinters. And then I took him inside the house, right inside that door. And inside that door frame, we showed him the fresh wood where it had been chipped off. And you could almost see it click. He didn't give it up, but you could almost see it click in his eyes, like, oh, I see it. I see now. All right? And again, when you look at what happened, it matches, that scene in Chris's body matches perfectly. All right? He gets shot in the arm. He gets shot in the stomach. He bends over. Those bullets are coming through. He takes those wood chips to the head. And then he turns. And another incredibly important piece of evidence with respect to Chris's shooting is that chest shot. That shot that he took in the chest is a contact shot. All right? It charred his sweatshirt. You know what that means? That means that somebody inside that house was right there with that .40 and shot him in the chest. When he spun around, again, you saw that blood right there in front of the house. It's clear that at that point, he spins around, and Billy's standing right there, and Billy puts that gun in his chest and shoots him. And he falls over to where eventually that rocker recliner ends up. Now, that rocker recliner was moved. That rocker recliner actually was kind of over more by the door. You can see from the pictures. And Gary was sitting in that rocker recliner. And Jake saw it. You know, when Jake's laying there, remember Chris comes back out. George doesn't shoot, not Chris. George doesn't shoot. Billy comes back out and he's like, hey, what's up? You know, why didn't that happen? Gary's sitting in that rocker recliner and Jake sees him. All right? When the shooting starts, again, you can see this from the scene. When the shooting starts, at that point, Gary flips up that rocker recliner and makes a move. How do you know that? Because he's got that bullet hole, he's got that .40 in the back of his hat. He's got that bruise on the back of his cap where he popped that rocker recliner up real quick. And he rolls out, and he gets dropped by Billy in the back of the head, and he falls right there at the back where his blood's found, at the back of the trailer. And Billy comes back over, and boom, 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 shoots him. Then Billy comes over to Chris, as Chris lays ultimately over by where that rocker recliner, his pool of blood, is found. And Billy stitches him with that .40. Boom, 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 boom. And you can see it, man. When you look at those autopsy pictures, you literally can see that straight line where he, boom, 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 shoots him. He misses one. And it goes down through the floor and is recovered underneath the trailer. Now, that has to happen fast. The only way they're killed in that position is if that happens fast. Otherwise, Chris is running to the back of the trailer. Gary's running to the back of the trailer. They're killed somewhere else. You don't have time for somebody to shoot from out in those cars, down on the ground, and end up in that house, killing them right where they are, with no sign of retreat or anything like that. Billy was inside that house, just like Jake said. Billy comes out. He's freaking out. Jake goes in, and he pulls the keys out of Chris's pocket. And again, how do we know that Chris was laying there? How do we know he pulled those keys out of his pocket right there? That little wrench. There's a little wrench, I think a little knife, that in addition to the keys, he got out. And he goes straight up with the keys to the upstairs and goes in and pulls that DVR. When he comes down from pulling the DVR, those bodies are moved. Those bodies are in the back at this point. And any argument that this defendant was too big, too clumsy, whatever it was, to move those bodies to that back bedroom is bunk. All right? Because Todd Fortner, who's, he was 6 foot, our BCI guy that did that scene, or did the Pharaoh scan, he was like 6 foot something, north of 300 pounds, big guy. He had no problem getting back, carrying the Pharaoh scan, carrying all of his equipment. He didn't knock anything over. He didn't knock that trash bag off that chair. He didn't knock that chair over. He was able to carry his equipment back there, no problem at all. And let's be real. Who moved those bodies in that trailer while Jake was upstairs getting that DVR stuff? It was the defendant. Chris Newcomb tells us how strong he is. Have you ever tried to carry dead weight? It's heavy. It's heavy. Billy's got a bad back. Billy's got a broken back. Who can? I think Chris Newcomb's words were, man, you should see him. You should see him drag a deer. You should see him drag a deer. Who's dragging those bodies? It's this guy. And when Jake comes back down, again, he goes in, probably says, hey, did you guys get the phones? Hey, we got to get the phones. Goes back in to look for evidence. While he's in there, actually on his way to the back, that's when he steps in the blood. Defendant at this point has already stepped in the blood and left his size 11s in there. Jake goes in, goes to the back, grabs those phones. He says the bodies were covered at that point. All right? You know you're covering the bodies at that point to hide them. All right? Just in case anybody kind of looks in, or you're covering those bodies to hide them. It's not a pattern of behavior. This is about covering up what you've done. So those bodies are covered up. He goes through. He pulls the phones. All right? While he does that, all right, he doesn't know what's going on outside. And again, you heard the testimony about in these situations, time can either run slower or faster. You don't know how long he was in there. All right? His recall of how long all this takes wouldn't be accurate based on what we know about the science of these traumatic situations. But what we do know is that while he was in there, either Billy or George went up to the grow room. All right? At this point, they're probably looking for the marijuana. Hey, is there marijuana? Is there money? Is something else up there that I can get? They'd already got the DVR. But how do we know there was one of those two? Again, Mr. Parker's right. It's Gary's blood on the door. But how do we know it was one of those two? The door handles broke off. They broke the door handle off to get in. They actually forced their way into that one. Jake didn't have to force his way in. He had the keys. He had the keys. One of those two goes up to that room to grab whatever else they were interested in going up there while Jake's inside grabbing those phones, and they leave the smudge of Gary's blood on the door. And again, the way you know that is because they broke the door to get in there. So, again, that's scene one. Oh, one of the things he said about scene 3, about hands. He said the handle looked at him, and he pulled the trigger, and he shot. And again, their expert testified about recall and memory and tunnel vision, all that kind of stuff. He thought he shot her in the front, in the face area. Did you hear when he testified? He was kind of surprised. He said a couple times, when I got to her, I noticed there wasn't any blood like in her hairline. That he acted surprised because he literally thought he had shot her in the face. I'm telling you, when she gasped, she sees that, she does one of these numbers, and she takes that shot right in the back of the first shot in the back of the head. That's what happened with respect to Hannah May. One of the other things he talked about, when I say he, I'm talking about Mr. Parker, he talked about George's interview in Montana. And asked, well, why didn't we hear that? Why didn't we play that? Look, it's a strategic move on our part. If we play that interview for you, he never has to take the stand to explain himself. All right? He's never subject to cross-examination. We never get a shot at asking him questions. He gets to sit back and listen to the interview. We don't play that And the only way he can get his story or what he's trying to say in front of you is by taking that stand and subjecting himself to cross-examination. That's why you do stuff like that. It's a strategic move. But again, when he was on the stand and he talked about the interview in Montana, he admitted that he said the things that Ms. Canepa was acting in. He admitted it. He admitted that he said that he went to bed at 12 or 12:30. He admitted, again, that he lied when they asked him about what kind of truck that he had. He admitted that he said, probably 15 times, no way anybody's leaving that house without me knowing. So he admitted to the things that he said in Montana. He was just subject to cross-examination in doing it. Oh, here's another one, real quick. Mr. Parker asked you about the truck and the bed of the truck, the fact that we rebuilt the bed of that truck. And he asked why we didn't ask, or why we waited so late to do that, is basically what it was. And again, that's what he asked. He asked why we didn't do that before the trial. You know, we had the proper for a year and a half. Why didn't we do it before the trial? Again, we get in a trial, and all of a sudden they start asking questions that make it pretty clear that they're going to argue that he was too big to fit in the back of that truck. All right? Out of the blue, that's where that came from. So again, real easy, what do? We want to cut that argument off. We just go and rebuild it, exactly like Jake said. Only we actually got people who were bigger. Because we didn't want any wiggle room. We didn't want them to dispute the size of the people that we used. And what did it show you? No problem at all. And did you note that these guys got in there? No problem at all. They got in, got out. There was no problem at all. And did you notice that after we did that, after we put that evidence in, they kind of backed off asking those types of questions. They kind of backed off the impossibility. He would have never been able to fit into that truck. They backed off that line of attack. He talked about the goose box. And he told you that that goose box was put in that lake for their grandfather's birthday, which is in February. You heard both Jake and Angela testify that it was either for Father's Day or for Grandpa's birthday. But what they both said was that somebody went in the water. Jake said, I got in the water. Mom said somebody went in the water. All right? So we know it wasn't February. All right? You're not going to sit in the water in February and put that goose box in. So we know it was in warm weather. But what's even more interesting, it's proof again of the independent corroboration that Angela gave to Jake's statement. Because she wouldn't have known. How would she have known that Jake said that? Unless it was true. So that shows you that that box was actually put in that lake when it was warm. Mr. Parker talked about demeanor. And he talked about judging Jake's demeanor. He talked about the fact that, about his idiosyncrasies when he testified. And you can, certainly, when you're judging credibility, one of the things you look at is the appearance and demeanor of a witness when they testify. You also look at what they said, the substance of what they said. Now, Ms. Canepa, she talked a long time yesterday about what George said when he testified and the lies that he told when he testified. I want to talk to you very briefly about his appearance and demeanor. Right? Look, the truth is the truth. And when you're telling the truth, there's no reason to practice or to be coached on what you're saying or what your answer should be. It should just flow out of your mouth. When the defendant testified, he gave you a couple obvious clues that he had practiced his answers, that he'd been coached on his answers. And think about his testimony. Right? Think about what you saw when he was testifying. And think about whether or not anything stood out to you. And as I ask questions, don't answer them. Just think about it. Just think about it rhetorically. First of all, Did any of you notice that when George was testifying, he literally was answering the questions before Mr. Parker was done asking them? Now, not only was he answering them, but he was putting the answers in the correct context before Mr. Parker had even finished framing the context of the question. Now, how do you do that? How do you do that unless you've practiced on what your answer is going to be? And the better question is, why do you do that unless your answer is something other than the truth? The second thing that I want to ask is, did any of you notice that the defendant was giving very specific answers to very vague questions? Mr. Parker would ask a question, something like, well, tell me about that one time with Tabby at Peterson Road. Or tell me about that one time at Bethel Hill. Now look, that's the type of question that provides very little contextual clues about exactly what's being asked. But the defendant was always able to give incredibly specific answers that actually were right in line with whatever point Mr. Parker was trying to make. Same two questions. How do you do that unless you've rehearsed? And why do you need to rehearse or practice unless your answer is something other than the truth? And finally, did anyone notice that the defendant's body language, or did anyone notice the defendant's body language when he would make denials about his participation in crime? Right. Now, Chris Newcomb said that George wasn't much of a gambler. And Juliet Slade, she went through all of his records, and she couldn't find anything that showed that he was a gambler, that he played cards or anything like that. And it's a good thing, because he's got a terrible tell when he's bluffing or he's not being truthful. And I'm insanely curious as to whether or not you noticed it. It was pronounced on the first day. It was really pronounced on the first day. When Mr. Parker would ask him softball-type questions, questions about hunting, questions about deer stands, questions about cars, questions about, fixing diesel engines, the defendant, eye contact the whole time, answering the question. Yes, 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 no, 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 right eye contact, nonstop. But when Mr. Parker would ask him something about his knowledge or participation in the murders, he would look straight down before he answered the question. Every time. Like clockwork. That's his body movement betraying what he's trying to make the answer to be. Look, in judging a person's credibility, you'll get an instruction that allows you to apply the normal test. The normal test that you apply everywhere in your life when you're judging a person's credibility. For some of you who have children, when you catch a kid doing something they're not supposed to do and you press them on it, man, if they're looking up, down, everywhere else, you know what they're saying isn't the truth. You certainly should apply this same standard to the defendant. And when you judge the defendant's credibility using those types of standards, it's pretty easy to see that he's lying to you. And why is he lying to you? He's lying to you because he's guilty. He knows what he's done. Look, I just passed over about 10 pages of notes. All right, I just went past about 10 pages of notes. I've been talking to you for a long time. We've all been talking to you for a long time. We've had you here for a long time. It's been a long case. Like Mr. Parker, I could probably go on for another couple hours talking to you about how this defendant's guilty and how their defense is just not credible. I'm not going to do that. I'm not going to do it. All right? There comes a time when there's nothing that I can say that you don't already know. There's no argument that I can make at this point that you aren't already aware of. It's time to let you do your job. And the final concept I want to leave you with is the idea of doubt. And you'll get a couple definitions with respect to doubt. One of the definitions you're going to get talks about all possible doubt. Right? The state does not have to prove its case beyond all possible doubt. We have to prove our case beyond a reasonable doubt. And that means, after you look at all the evidence, if you're firmly convinced that he aided, abetted, assisted his family in these crimes, participated in these crimes, then he's guilty. And there's an analogy I use with juries when we talk about all possible doubt versus reasonable doubt. And the analogy is of a puzzle. So say in August, when we brought you in here, instead of asking you to do a case, we asked you to put a puzzle together. And for a couple months, we've just been handing you pieces of the puzzle. And you are getting ready to go back and put those pieces together. Now the defense, they don't have an obligation, they don't have a burden at all to participate in this puzzle-making experiment. They don't. It's not their job, it's ours. But they may take some puzzle pieces and they may move them where they think they need to go, or they may try to give you some pieces that they think fit. But at the end of the day, you put that puzzle together, and you look at that puzzle, and you see the New York City skyline, the Manhattan skyline in the background. Now, not all of the pieces are there. Not all the pieces may be there. There may be some buildings missing here or there. And then in the front of the picture, or the front of the puzzle, you see that there's a statue. All right, a gray statue. And again, as you work your way up the statue, you see in one hand, there's a book. Although you might not be able, maybe the elbow's missing. All right? And the other hand's up, and you can see, again, you can see what it is, but maybe the whole torch isn't there. You see a lady's face, maybe an eye's missing. But when you look at that puzzle, and you see the pieces that are there, you're firmly convinced that that's a puzzle of the Statue of Liberty. You know it. Even though every piece that you might want to see isn't there. Requiring us to give you every piece of the puzzle to be firmly convinced would be requiring proof beyond all possible doubt. That's not our burden. Over the last couple months, we have given you the evidence you need to go back and find this defendant guilty. When you look at the evidence that you've seen, you should be firmly convinced that this defendant knew about and participated in these murders with his family. And when you make that finding, when you look at all that evidence, he's guilty. At that point, by law, you're required to find him guilty. And that's what you'll do, because that's what he is. Thank you.
Thank you. The next step, ladies and gentlemen, is for the court to instruct you as to the law. That will take a little bit of time. It's about 12:13 or so right now. Is 45 minutes enough time for everybody to have lunch? Is that sufficient? If not, if anybody feels it's not sufficient, would you let me know by a hand raise here? All right. So we're going to take a 45-minute recess, lunch recess, until 1 o'clock. At that point, you'll be coming back, you'll be assembling at the jury room downstairs, where you'll be brought up here, and then the court will instruct you as to the law that applies to the case. While you're at this recess, you're not to discuss this case among yourselves or with anyone else. You're not to permit this case to be discussed with you or in your presence. You're not to express an opinion concerning the case. You're to do no research at all concerning the case, either as to the facts or as to the law from any source at all. You're not to read, view, or listen to any reports or accounts of the case from any source at all, and you're to have no contact with participants in the case, including parties, counsel, or witnesses. Does counsel for either side have anything further at this time before we recess for lunch? No. All right. And we are in recess until 1 o'clock. At that time, assemble at the jury room. jury instructions too, or jury, verdict forms too. Have you had a chance to look at those or not?
I am on count 10 right now, Your Honor, so I will continue to
All
look
right,
at those
well,
before they go back.
Continue to look at those and make sure they're in appropriate form before we send those to the jury. I've put the jury's verdict forms in separate file folders labeled just as to the counts, which I thought might help them to keep them straight, but I'll go over all that with the jury. And then counsel has received copies of the jury instructions. Defense counsel's made some previous objections to them, and I'm sure we'd want to preserve those objections, so.
Yes, we'll preserve our previous objections, and I think the rules require us to object at the end of the instructions.
Oh, okay. You can
So-
do that, just to incorporate those and all, that'd be
But we'll
fine.
just maintaining our previous objections.
In addition, Judge, in addition to maintaining the previous objections, I understand the court has amended this latest version to include, I think it's motive on the 404B, and we would again, just keeping consistent with our objection to 404B, object to the addition of that language.
I understand. That will be preserved for the record. Is counsel for each side ready to have the jury brought up then?
Yes, Your Honor.
Yes,
Let's bring them up. I'm going to read these when the jury gets here, of course, I'm inviting counsel, in fact, I'm directing counsel to follow along with me. I'll try to incorporate as much as possible by reference so that it takes a little bit less time without, to the extent I feel like I can do that without being confusing. But if I misread something, in a material way especially, stop me, and I will go back and correct that. Don't be bashful about that. I'm sure you won't be. I had asked that this. I'm not sure if that does anything or not. Does it help to have that?
Sounds a little louder to me, actually.
Fine.
It sounds a little louder out there to me.
It's what?
It sounded a little louder.
Okay, all right.
Yeah. Yeah, exactly.
You may be seated. Jason, able to use this. Ladies and gentlemen of the jury, you've heard the evidence and the arguments of counsel. It's now time for the court to instruct you as to the law. Now, as counsel's already pointed out, the instructions are several pages long. I'm going to try, in instructing you, I will try to incorporate, they're repetitious in a sense too, in that some of the counts are the same, so that makes the instructions very similar. Where there's repetition and where I think it will not be confusing, I'm going to incorporate by reference rather than read verbatim every time the same definitions and the same basic instructions. You will have several copies of these instructions with you in the jury room to refer to. Before I forget to say it, if questions arise concerning the instructions or concerning the verdict forms that I give you, you may put those, any questions in writing and give it to the court officer who will be supervising the jury, and those questions will be answered if they can be. If they can't be, they won't be, and don't take offense at that. Some questions cannot be answered, but any question that can be answered fairly will be answered for you. I also want to point out before I begin the formal instructions here that, as you're aware, there are 22 counts in this case, 22 separate counts, and those need to be dealt with separately, as I will advise you. In order to assist you in organizing a little bit, the court has put together 22 separate file folders. Each file folder, each one of these file folders is labeled as to count 1, count 2, whatever the count is. Each of these file folders will have 2 verdict forms in it. One is a verdict of not guilty, one is a verdict of guilty. Some of the charges require, if a verdict is guilty, that there be separate findings. And I will go over that in a little bit more detail with you here in a moment. But and some do not. Some do not require those findings. You won't be filling out, of course, 2 verdict forms for any one count. You will be, in every single count has to be either a not guilty verdict or a guilty verdict. And so each of these folders has one of each in it. I just want to point that out. That might help you organize your thought processes a little bit as we go along today. Again, if there are questions concerning the verdict forms or concerning the instructions, you may put those, after you get to the jury room, you may put those in writing, and the court will answer what the court can answer about that. Now, the court and the jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and to apply the law as I give it to you. You are not permitted to change the law or to apply your own idea of what you think the law should be. The case before you began with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime, as to each of the counts here. You may not consider the fact that it was filed for any purpose. A plea of not guilty is a denial of the charge and puts at issue all of the essential elements charged in that indictment. That would be, puts at issue all of the essential elements as to each count charged in the indictment. As to each offense charged in the indictment, the defendant is presumed innocent until and unless his guilt is established beyond a reasonable doubt. As to each offense charged in the indictment, the defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of each such offense charged. Now, I have used the term reasonable doubt. At this time, I will define that term for you. Reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts that the court requires you to accept as true. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements of each of the charged offenses beyond a reasonable doubt. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes exhibits admitted into evidence during the trial and stipulations that you were instructed to accept as fact. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically follow according to the common experience of people. To infer or to make an inference is to reach a reasonable conclusion or deduction of fact that you may, but are not required to make, from other facts that you find have been established by direct evidence. You may infer a fact or facts only from other facts or circumstances that have been proven or proved by the greater weight of the evidence. Whether an inference is made rests entirely with you. The evidence does not include any statement made by counsel during the trial unless such statement was an admission or agreement as to certain facts. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements and answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. As previously instructed, the locations and items that you saw during the jury view are not evidence, but such jury view may help you understand the evidence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of witnesses. You will use the tests of truthfulness which you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, and the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. You have heard the testimony of Edward Jacob Wagner, another person who pleaded guilty to the same crimes charged in this case, and have also heard testimony from Angela Jo Wagner, another person who was accused of the same crimes charged in this case and who pleaded guilty to some of the same crimes charged in this case. Edward Jacob Wagner and Angela Jo Wagner are said to be accomplices. An accomplice is one who purposely assists or joins another in the commission of a crime. Whether Edward Jacob Wagner was an accomplice and the weight to give his testimony are matters for you to determine from all the facts and circumstances and evidence. Whether Angela Jo Wagner was an accomplice and the weight to give her testimony are also matters for you to determine from all the facts and circumstances in evidence. The testimony of an accomplice that is supported by other evidence does not become inadmissible because of the accomplice's complicity, moral turpitude, or self-interest, but the admitted or claimed complicity of a witness may affect the witness's credibility and make the witness's testimony subject to grave suspicion and require it to be weighed with great caution. It is for you, the jurors, in the light of all the facts presented to you from the witness stand, to evaluate such testimony and to determine its quality and worth, or its lack of quality and worth. An accomplice may have special motives for testifying, and you should carefully examine an accomplice's testimony and use it with great caution and view it with grave suspicion. A number of exhibits and the testimony relating to the exhibits have been introduced throughout the trial. You will decide what weight, if any, the exhibits should be given in light of all the evidence. These exhibits may include, but are not limited to, photographs, documents, reports, video and audio exhibits, and other physical items. The numbering or lettering of the exhibits that you take to the jury room may not follow consecutively. There are several reasons for this. An exhibit may not have been submitted by the party who produced it during the trial, or the court may not have admitted an exhibit because of a legal or procedural reason. Do not draw any inference because you do not have a particular exhibit. You will have in the jury room or otherwise available to you while you are deliberating all of the exhibits that were received into the evidence. You will not be given any other exhibits during your deliberations. Now, due to the number of the exhibits admitted into evidence, it is not possible to have all exhibits in the jury room at one time. If you desire to see or listen to any exhibit and it is not in the jury room, you are instructed to let the court's bailiff or other court employee that will be supervising you know in writing what your request is, and the exhibit will be provided to you if it is a part of the evidence. The bailiff or court employee will contact the judge and counsel for each party concerning your request if necessary. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to you to arrive at a just verdict. Questions have been asked in which an expert was permitted to assume that certain facts were true and to give an opinion based upon such assumption. Concerning any such questions, you must determine whether the assumed facts upon which the expert opinion was based are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of experts. In determining its weight, you may take into consideration their skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing the credibility and determining the weight to be given to testimony. It is not necessary that the state prove that the offense was committed as charged in any of the counts, was committed on the exact day as charged in the indictment. It is sufficient to prove that the offense took place on a date reasonably near to the date claimed. Evidence was admitted about the commission of crimes or wrongs or acts other than the offenses with which the defendant is charged in this trial. That evidence was received only for the limited purpose of proving motive, preparation, plan, or identity. You may consider the evidence of other acts that show motive or other act evidence that establishes that the accused had a specific reason to commit the offenses charged in this case. You may consider the evidence of other acts to determine whether it shows that the defendant prepared to commit the offenses in which he is charged in this case. Before you can consider the evidence of other acts for purposes of showing the defendant prepared to commit the offenses charged, the evidence must show the defendant's prior preparatory acts were either part of the same transaction as the offenses for which the defendant is on trial, or that the other acts were part of a sequence of events leading up to the commission of the offenses in question. You may also consider evidence of the other acts to determine whether it is linked to the present offenses because the acts were carried out in furtherance of the same overall plan. Evidence of a plan or common design refers to a larger criminal scheme of which the crime charged is only a portion. You may consider evidence of a plan if it supports one of the following possible conclusions. 1, the occurrence of the act in issue, or 2, the identity of the person who committed the act, or 3, the existence of the required mental state of the actor. You may also consider evidence of the other acts to determine whether such evidence proves the defendant's identity. You may also consider the evidence of modus operandi to determine whether the evidence proves identity. Modus operandi means method of working or behavioral fingerprint. It is evidence of signature fingerprint-like characteristics unique enough to show that the other acts and the charged offenses were committed by the same person or persons. Evidence of modus operandi is relevant to prove identity of the perpetrator or perpetrators of the charged crime. The evidence about the commission of crimes or wrongs or acts other than the offenses with which the defendant is charged in this trial cannot be considered for any other purpose than the purposes identified. It was not received. Such evidence was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity to that character. It does not follow from the defendant's past acts that he committed the particular crimes charged in this case. The state has the burden of proving each element of the particular crimes currently at trial beyond a reasonable doubt. The state cannot satisfy its burden merely by implying that the defendant committed any of these crimes because his other acts suggest a propensity to commit crimes. I will now describe the offenses with which the defendant, George Washington Wagner IV, has been charged. Before you can decide whether the state of Ohio has proved beyond a reasonable doubt all of the essential elements of each of the offenses with which the defendant is charged, you must first decide whether Pike County, Ohio, is the correct county in which this trial should be held. The state of Ohio must prove beyond a reasonable doubt with respect to each of the offenses charged that all or any part of such offense was committed in Pike County, Ohio, or that the state must prove beyond a reasonable doubt that all or any part of the offenses involved in a course of conduct of the defendant, any part of which occurred in Pike County, Ohio. In order for you to find that a course of conduct existed, you must find beyond a reasonable doubt any of the following. 1, the offenses involved the same victim or victims of the same type. Let me say it again. 1, the offenses involved the same victim or victims of the same type or from the same group. 2, the offenses were committed by the defendant in his same employment or capacity or relationship to another. 3, the offenses were committed as part of the same transaction or chain of events or in furtherance of the same purpose or objective. 4, the offenses were committed in furtherance of the same conspiracy. 5, the offenses involved the same or similar modus operandi or scheme, plan, system, or method. Or 6, the offenses were committed along the defendant's line of travel in this state, regardless of his point of origin or destination. The court has taken judicial notice of the fact that 3122 Union Hill Road is in Scioto County, Ohio. You are further instructed that you may but are not required to accept as conclusive any fact judicially noticed by the court, including that 3122 Union Hill Road is in Scioto County, Ohio. Now, the instruction as to count one is the charge of aggravated murder of Kenneth Rhoden. The defendant is charged in count one of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count one, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016 in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Kenneth Rhoden. Now, there are several definitions here, and I'm going to be reading these to you. Purpose is an essential element of the offense of aggravated murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established with respect to count one in this case, that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Kenneth Rhoden. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances in evidence. If a wound is inflicted upon a person with a deadly weapon in a manner calculated to destroy life, the purpose to cause the death may be, but is not required to be, inferred from the use of the weapon. The inference, if made, is not conclusive. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Prior calculation and design means that the purpose to cause the death was reached by a definite process of reasoning in advance of the homicide, which process of reasoning must have included a mental plan involving studied consideration of the method and the means or instrument with which to cause the death. To constitute prior calculation and design, there must have been sufficient time and opportunity for the planning of the act of homicide, and the circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause the death. No definite period of time must elapse, and no particular amount of consideration must be given, but acting on the spur of the moment or under momentary consideration of the purpose to cause the death is not sufficient. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another and without which it would not have occurred. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Kenneth Rhoden as charged in count one of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count one, then your verdict must be not guilty according to your findings. Now, there are three specifications with respect to count one, and you will also find that the first 8 counts each have the same 3 specifications. And these are special findings that you will have to make if your verdict is guilty to any one of the first 8 counts. If the verdict is not guilty, you do not go to those special findings. That won't be on your verdict form. If your verdict is guilty of aggravated murder of Kenneth Rhoden as charged in count 1 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the first count. If you find the defendant not guilty of aggravated murder of Kenneth Rhoden as charged in count 1, then you will not consider this issue. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable but that can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosive or combustible propellant, you may rely upon circumstantial evidence, including but not limited to the representations and actions of the individual exercising control over the firearm. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or especially adapted for use as a weapon or possessed, carried, or used as a weapon. On or about his person or control means that the firearm was on the defendant's person or so close to the defendant, let me just start that again. On or about a person, on or about his person or under his control means that the firearm was on the defendant's person or so near the defendant as to be conveniently accessible and within the defendant's immediate physical reach. Possession is a voluntary act if the possessor knowingly procured or received the firearm or was aware of his control thereof for a sufficient period of time to have ended his possession. A person has possession when he knows that he has the object on or about his person or places it where it is accessible to his use or direction, and he has the ability to direct or control its use. Now, ownership is not necessary. A person may possess or control property belonging to another. So that is specification 1 to the first count of aggravated murder. Now, this is specification 2. If your verdict is guilty of aggravated murder of Kenneth Rhoden as charged in count 1 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the first count, and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Kenneth Rhoden as charged in count 1, then you will not consider this issue. There are several definitions that apply to the specification 2 to count 1 that are repetitious of the ones that in specification 1 to count 1. For example, firearm was previously defined. That definition is the same, so I won't read that. The capability of expelling or propelling, how you determine the capability of, what that means, the capability of expelling or propelling one or more projectiles by an action of an explosive or combustible propellant, how you consider that. That's the same for this specification too, so I won't be reading that verbatim. The definition of deadly weapon, the definition of on or about his person or under his control, the definition of possession, all of those are the same for specification 2 as in specification 1. I'll just refer you to those definitions previously given to you. Again, ownership is not necessary in specification 2 to count 1 either. A person may possess or control property belonging to another. Now, this is the third specification then to the first count. So it's count 1, if the verdict is guilty, specification 1, specification 2, specification 3. If your verdict is guilty of aggravated murder of Kenneth Rhoden as charged in count 1 of the indictment, you will separately consider whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or suppressor on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 3 to the first count. If you find the defendant not guilty of aggravated murder of Kenneth Rhoden as charged in count 1, you will not consider this issue. The definition of firearm for this specification is the same one previously given to you. Determining whether a firearm is capable of expelling or propelling one or more projectiles by an action of explosive or combustible propellant, that determination is made in the same manner with respect to this specification as you've been previously instructed. Deadly weapon, that definition of that is the same as you were previously instructed. On or about his person or under his control is the same definition there, and the definition of possession is the same as you've previously been given. With respect to specification 3, ownership is not necessary. A person may possess or control property belonging to another. Now, this is the first time I've defined this next term, so I am going to read it. Firearm muffler or firearm suppressor means any device for silencing, muffling, or diminishing the report of a portable firearm, including any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer or firearm muffler, and any part intended only for use in such assembly or fabrication. We're now going to count 2, but it may help you understand the process of this and therefore be able to understand my instructions if I show you this. For example, this is count 1 is written at the top. These are the verdict forms, 2 verdict forms for count 1. One verdict form says it's a verdict of not guilty as to count 1. We, the jury, find the defendant, George Washington Wagner IV, is not guilty of aggravated murder as charged in count 1. If that is your verdict, all 12 jurors would sign that. The foreman the foreman signs on the foreman line only, but everybody else signs on whatever line they choose to sign on. But it does take 12 jurors agreeing on a verdict to render a verdict. But that's the not guilty verdict form. There are no findings to that. You would stop there. You don't fill out 2 verdict forms for the same count. The second verdict form says verdict of guilty as to count 1, and it says we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count 1 of the indictment. If that verdict form conforms to your verdict, then you must go on down to the special findings, and it's got verdict on specifications as to count 1. And the first specification, which I've read to you, says the first choice here is, we, the jury, further find that the state of Ohio, and there's a blank place there for filling in, and you'll see the instructions when you see the form, but you must fill in did or did not. So the state of Ohio did prove beyond a reasonable doubt that the defendant, while committing aggravated murder as charged in count 1 of the indictment, had a firearm on or about his person or under his control as alleged in specification 1 to count 1, or did not prove beyond a reasonable doubt. If you choose do not there, then you stop. If you choose did prove beyond a reasonable doubt, then you must go down to the next 2 findings. And those conform to the specification 2 and specification 3 to count 1. The first one says, we, the jury, find that the state of Ohio, and again, did or did not prove beyond a reasonable doubt that the defendant displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate the offense of aggravated murder as charged in count 1 of the indictment, as alleged in specification 2 to count 1. The third finding is that we, the jury, find that the state of Ohio did, or the state of Ohio did not, prove beyond a reasonable doubt that the firearm the defendant had on or about his person or under his control while committing the offense of aggravated murder as charged in count 1 of the indictment was equipped with a firearm muffler or suppressor as alleged in specification 3 to count 1. So you can see that if the verdict is guilty, then you go down to the findings. If the finding is the state did prove, you go down to the next two findings. If you find the state did not prove, then you stop there. So hopefully that will help you understand the process, because the first 8 counts are similar in regard to the fact that each have the 3 specifications and each have the 2 verdict forms very similar to the one I've just gone over with you. Now, count 2 is the charge of aggravated murder of Chris Rhoden Sr. The defendant is charged in count 2 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 2, you must find beyond a reasonable doubt that on or about the 22nd day of April, 2016, in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Chris Rhoden Sr. Now, purposely is defined the same in count 2 as it was in count 1, with one exception, and that is that it must be established with respect to count 2 of this case that at the time in question there was present in the mind, and this must be established beyond a reasonable doubt with respect to count 2, that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Chris Rhoden Sr., whereas you'll recall that in count 1 it was Kenneth Rhoden. So that's the only difference. Other than that, the definition of purposely is the same. How purpose is to be determined is the same instruction with respect to count 2 as it was with count 1. Deadly weapon is defined the same way. Proof of motive is not required. The purpose or absence of motive is one of the circumstances bearing upon purpose. Prior calculation and design is defined the same way in count 2 as it was in count 1. Causation, cause is an essential element of the offense in count 2 as well, and it's defined the same way. So the conclusion is, if you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Chris Rhoden Sr. as charged in count 2 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 2, then your verdict must be not guilty according to your findings. Now we're going to go through these specifications, but again, I just remind you that the form of the charge in count 2 is very similar to the form in count 1. These have to be separately considered, though, because they involve separate alleged victims and separate circumstances, perhaps. So you need to determine each of these separately. As to if your verdict is guilty of aggravated murder of Chris Rhoden Sr. as charged in count 2 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the second count. If you find the defendant is not guilty of aggravated murder of Chris Rhoden Sr. as charged in count 2, then you will not consider this issue. Firearm, that is defined the same way as you've previously been instructed. The determination of the capability of the firearm, whether it's capable of expelling or propelling any one or more projectiles by an action of explosive or combustible propellant, that determination is made in the same way. Deadly weapon is defined in the same way. On or about his person and control is defined in the same way. And possession is defined in the same way. Again, with respect to to this specification, ownership is not necessary. A person may possess or control property belonging to another. Now, as to specification 2, to the second count, if your verdict is guilty of aggravated murder of Chris Rhoden Sr., as charged in count 2 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as charged in specification 2 to the second count, and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Chris Rhoden Sr. as charged in count 2, then you will not consider this issue. With respect to that specification, firearm is defined the same. The determination of whether the firearm is capable of expelling or propelling one or more projectiles by an action of explosive or combustible propellant is determined the same way as you've previously been instructed. Deadly weapon, on or about his person or control, and possession are all defined the same way. Again, ownership is not necessary. A person may possess or control property belonging to another. Now, the third specification as to the second count. If your verdict is guilty of aggravated murder of Chris Rhoden Sr. as charged in count 2 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or suppressor on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 3 to the second count. If you find the defendant not guilty of aggravated murder of Chris Rhoden Sr. as charged in count 2, then you will not consider this issue. Firearm is defined the same way. Whether the firearm is capable of expelling or propelling one or more projectiles by an action of explosive or combustible propellant is determined the same way. Deadly weapon is defined the same way. On or about his person or control on or about his person or under his control, is defined the same way and found the same way. Possession is defined the same way. Ownership is not necessary. A person may possess or control property belonging to another. And firearm muffler or firearm suppressor is defined the same way as to this specification 3 to count 2 as it was defined for specification 3 to count 1. So I won't be reading that one again. Now, as to count 3, the charge of aggravated murder of Gary Rhoden. The defendant is charged in count 3 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 3, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016 in Pike County, Ohio, or as a part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Gary Rhoden. Purposely is defined the same in count 3 as it was in count 1 and count 2, with the exception that it must be established beyond a reasonable doubt in count 3 that there was present in the mind of the defendant a specific intention to cause the death of Gary Rhoden. How purpose is determined is defined and explained the same way in count 3. Deadly weapon is defined the same in count 3. Again, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. The definition of prior calculation and design and the definition of causation are the same. The element of causation in its definition are the same in count 3. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Gary Rhoden as charged in count 3 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of aggravated murder as charged in count 3, then your verdict must be not guilty according to your findings. Now, we have the same 3 specifications, all right, with respect to count 3. If your verdict is guilty of aggravated murder of Gary Rhoden as charged in count 3 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the 3rd count. If you find the defendant not guilty of aggravated murder of Gary Rhoden as charged in count 3, then you will not consider this issue. Firearm is defined the same. The element of capability of expelling or propelling one or more projectiles by an explosive or combustible propellant is explained the same way with respect to specification 1 to count 3. Deadly weapon is defined the same. On or about his person or under his control is defined the same way, and possession is defined the same way. Ownership is not necessary. A person may possess or control property belonging to another. Now we have the second specification, specification 2 to the 3rd count. If your verdict is guilty of aggravated murder of Gary Rhoden as charged in count 3 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the 3rd count and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Gary Rhoden as charged in count 3, then you will not consider this issue. Firearm has the same definition. The determination of the capability of expelling or propelling one or more projectiles by an action of explosive or combustible propellant is explained the same way. Deadly weapon is defined the same. On or about his person or under his control and possession are all defined the same way. Again, ownership is not necessary. A person may possess or control property belonging to another. And then we have the 3rd specification as to the 3rd count. If your verdict was guilty of aggravated murder of Gary Rhoden as charged in count 3 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 3 to the 3rd count. If you find the defendant not guilty of aggravated murder of Gary Rhoden as charged in count 3, you will not consider this issue. For the purpose of specification 3 to the 3rd count, firearm is defined the same. The language explaining the element of capable of expelling or propelling is the same. Deadly weapon is defined the same. On or about his person or under his control is defined the same. Possession is defined the same. Again, ownership is not necessary. A person may possess or control property belonging to another. Muffler, a firearm muffler or firearm suppressor is defined the same way as you've previously been informed. Now, the 4th count of the indictment is contains the charge of aggravated murder of Clarence Franklin Rhoden. The defendant is charged in count 4 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 4, you must find beyond a reasonable doubt that on or about the 22nd day of April, 2016, in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Clarence Franklin Rhoden. Purposely is defined the same in count 4 as in the other counts, with the exception that in count 4, it must be established beyond a reasonable doubt in count 4 that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Clarence Franklin Rhoden. How purpose is determined is explained in the same way in this instruction also. The definition of deadly weapon is the same as in the prior counts. Motive, again, is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. The definition of prior calculation and design and causation are the same with respect to this count. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Clarence Franklin Rhoden, as charged in count 4 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 4, then your verdict must be not guilty according to your findings. We have the 3 specifications also with respect to count 4. If your verdict is guilty of aggravated murder of Clarence Franklin Rhoden as charged in count 4 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the 4th count. If you find the defendant not guilty of aggravated murder of Clarence Franklin Rhoden as charged in count 4, then you will not consider this issue. Firearm is defined the same as in prior specifications. The determination of whether the firearm is capable of expelling or propelling one or more projectiles, that is defined the same. The requirement is the same in this count as in the other counts. Deadly weapon is defined the same. On or about his person or control is defined the same as his possession. Ownership, again, is not necessary. A person may possess or control property belonging to another. Specification 2 to the 4th count. If your verdict is guilty of aggravated murder of Clarence Franklin Rhoden as charged in count 4 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the 4th count, and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Clarence Franklin Rhoden as charged in count 4, then you will not consider this issue. For purposes of this specification, firearm is defined the same, capable of expelling or propelling, is explained in the same way. Deadly weapon is defined the same. On or about his person or under his control is defined the same way as in prior specifications. Possession is defined the same also. Again, ownership is not necessary. A person may possess or control property belonging to another. Specification 3 to the 4th count. If your verdict is guilty of aggravated murder of Clarence Franklin Rhoden as charged in count 4 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 3 to the 4th count. If you find the defendant not guilty of aggravated murder of Clarence Franklin Rhoden as charged in count 4, then you will not consider this issue. For purposes of this specification, firearm is defined the same. The capability of expelling or propelling is explained in the same way. Deadly weapon, on or about his person or under his control, and possession are all defined in the same way as in the other specifications. Ownership, again, is not necessary. A person may possess or control property belonging to another. The term firearm muffler or firearm suppressor is defined the same way in this specification as previously explained. Now, the defendant is charged in count 5 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 5, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016 in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Hannah Hazel Gilley. Purposely is defined the same way in count 5 as in the other counts, with the exception that in this count it must be established beyond a reasonable doubt that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Hannah Hazel Gilley. How purpose is determined is explained the same way as in prior counts. The term deadly weapon is defined the same as in prior counts. Again, motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Prior calculation and design and causation are all defined in the same way in this count as they were in prior counts. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Hannah Hazel Gilley, as charged in count 5 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 5, then your verdict must be not guilty according to your findings. We have the same 3 specifications. If your verdict is guilty of aggravated murder of Hannah Hazel Gilley as charged in count 5 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as charged in specification 1 to the 5th count. If you find the defendant not guilty of aggravated murder of Hannah Hazel Gilley as charged in count 5, then you will not consider this issue. For purposes of this specification, firearm and capable of expelling or propelling are defined and explained the same way. The term deadly weapon, the term on or about his person or under his control, and the term possession are all defined in the same way as in previous specifications. And ownership also is not necessary. A person may possess or control property belonging to another. Specification 2, it says that if your verdict is guilty of aggravated murder of Hannah Hazel Gilley as charged in count 5 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the 5th count, and displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Hannah Hazel Gilley as charged in count 5, then you will not consider this issue. For purposes of this specification, firearm capable of expelling or propelling, deadly weapon on or about his person or under his control, and possession. Those terms are all defined and explained in the same way as in prior specifications. And also, for this specification, ownership is not necessary. A person may possess or control property belonging to another. As to specification 3, this is the instruction, if your verdict is guilty of aggravated murder of Hannah Hazel Gilley as charged in count 5 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or suppressor on his person or under his control while committing the offense of aggravated murder as alleged in specification 3 to the 5th count. If you find the defendant not guilty of aggravated murder of Hannah Hazel Gilley as charged in count 5, then you will not consider this issue. And for purposes of specification 3 to the 5th count, the term firearm capable of expelling or propelling, deadly weapon on or about his person or under his control, and possession are all defined and explained as they were in the 3rd specification for the other counts. Ownership is not necessary. A person may possess or control property belonging to another. The term firearm muffler or firearm suppressor is defined in this 3rd count the same as it was in the 3rd count to the other, the 3rd specification, in this specification, the same as it was to specification 3 to the other counts. Instruction as to count 6. Count 6 is the charge of aggravated murder of Dana Rhoden. The defendant is charged in count 6 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 6, You must find beyond a reasonable doubt that on or about the 22nd day of April, 2016 in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Dana Rhoden. Purposely is defined the same in count 6 as it was the other 5 counts, with the exception that for this count it must be established beyond a reasonable doubt that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Dana Rhoden. How purposes is determined is explained in the same way with respect to this count as in the prior counts. The definition of a deadly weapon, prior calculation and design, and causation are all the same with respect to this count as in the prior counts. Also, with respect to this count, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Dana Rhoden, as charged in count 6 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 6, then your verdict must be not guilty according to your findings. There are the same 3 specifications. If your verdict is guilty of the aggravated murder of Dana Rhoden, as charged in count 6 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the 6th count. If you find the defendant not guilty of aggravated murder of Dana Rhoden as charged in count 6, then you will not consider this issue. For the purposes of specification 1 of the 6th count, firearm, the capability of expelling or propelling, deadly weapon, that term, the term on or about his person or under his control, and the term possession. All of those are defined and explained in the same way as in specification 1 to the other counts. Ownership is not necessary. A person may possess or control property belonging to another. Specification 2, if your verdict is guilty of aggravated murder of Dana Rhoden as charged in count 6 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the 6th count, and displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Dana Rhoden as charged in count 6, then you will not consider this issue. For the purposes of specification 2, the term firearm, the term capable of expelling or propelling, the term deadly weapon, the term on or about his person or under his control, the term possession are all defined and explained in the same way as you previously instructed. Again, ownership is not necessary. A person may possess or control property belonging to another. Specification 3 to the 6th count, if your verdict is guilty of aggravated murder of Dana Rhoden as charged in count 6 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated murder as charged or as alleged in specification 3 to the 6th count. If you find the defendant not guilty of aggravated murder of Dana Rhoden as charged in count 6, then you will not consider this issue. With respect to specification 3 to the 6th count, the term firearm, the requirement of the capability of expelling or propelling and how that's determined, the term deadly weapon, the term on or about his person or under his control, and the term possession are all defined and explained in the same way as in the 3rd specification to the other counts. Ownership is not necessary. A person may possess or control property belonging to another. The term firearm muffler or firearm suppressor is defined the same as in specification 3 to the other counts. The charge in count 7 is a charge of aggravated murder of Hannah Mae Rhoden. The defendant is charged in count 7 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 7, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016 in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Hannah Mae Rhoden. For purposes of this count, count 7, purposely is defined the same way as in the other 6 counts, with the exception that in this count it must be established beyond a reasonable doubt that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Hannah Mae Rhoden. How purpose is determined is defined in the same way in this count as in prior counts. The terms deadly weapon, prior calculation and design, and causation are defined in the same way in this count as in prior counts. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. If you find the state proved beyond a reasonable doubt all of the essential elements of aggravated murder of Hannah Mae Rhoden as charged in count 7 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 7, then your verdict must be not guilty according to your findings. Specification 1, if your verdict is guilty of aggravated murder of Hannah Mae Rhoden as charged in count 7 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the 7th count. If you find the defendant not guilty of aggravated murder of Hannah Mae Rhoden as charged in count 7, then you will not consider this issue. For purposes of specification 1 to the 7th count, the term firearm, the definition and requirement of the capability of expelling or propelling, definition of a deadly weapon, the definition of on or about his person or under his control, and the definition of possession are all the same as they were in specification 1 to the earlier counts. Ownership is not necessary. A person may possess or control property belonging to another. Specification 2, if your verdict is guilty of aggravated murder of Hannah Mae Rhoden as charged in count 7 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the 7th count and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Hannah Mae Rhoden as charged in count 7, then you will not consider this issue. And for purposes of specification 2 to the 7th count, the term firearm capable of expelling or propelling deadly weapon on or about his person or under his control and possession are all defined the same as in specification 2 to the other counts. Ownership is not necessary. A person may possess or control property belonging to another. Specification 3, if your verdict is guilty of aggravated murder of Hannah Mae Rhoden as charged in count 7 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated murder as alleged in count 7, as alleged in specification 3 to count 7. If you find the defendant not guilty of aggravated murder of Hannah Mae Rhoden as charged in count 7, then you will not consider this issue. And for purposes of specification 3 to count 7, the term firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control and possession are all defined and explained the same as in specification 3 to the other counts. Ownership is not necessary. A person may possess or control property belonging to another. The term firearm muffler or firearm suppressor is defined in specification 3 to the 7th count the same way it was in specification 3 to the other counts. The defendant is charged in count 8 of the indictment with aggravated murder. Before you can find the defendant guilty of aggravated murder as charged in count 8, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016 in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely and with prior calculation and design caused the death of Christopher Rhoden, Jr. For purposes of count 8, the term purposely is defined the same, with the exception that it must be established beyond a reasonable doubt in count 8 that at the time in question there was present in the mind of the defendant a specific intention to cause the death of Christopher Rhoden, Jr. How purpose is determined is defined the same way in count 8. The terms deadly weapon, prior calculation and design and causation are all defined and explained in the same way in count 8 as in prior counts. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated murder of Christopher Rhoden, Jr. as charged in count 8 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder as charged in count 8, then your verdict must be not guilty according to your findings. If your verdict is guilty of aggravated murder of Christopher Rhoden, Jr. as charged in count 8 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 1 to the 8th count. If you find the defendant not guilty of aggravated murder of Christopher Rhoden, Jr. as charged in count 8, then you will not consider this issue. For purposes of specification 1 to the 8th count, the term firearm, the determination of capable of expelling or propelling, the term deadly weapon, the term on or about his person or under his control, and the term possession are all defined and explained the same as in specification 1 to the other 7 counts. Ownership is not necessary. A person may possess or control property belonging to another. Specification 2, if your verdict is guilty of aggravated murder of Christopher Rhoden, Jr. as charged in count 8 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 2 to the 8th count, and displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate the said offense of aggravated murder. If you find the defendant not guilty of aggravated murder of Christopher Rhoden, Jr. as charged in count 8, then you will not consider this issue. And with respect to count 2 of the 8th count, the term firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control, and possession are all defined and explained in the same way as specification 2 to the other 7 counts. Ownership is not necessary. A person may possess or control property belonging to another. Specification 3 to the 8th count, if your verdict is guilty of aggravated murder of Christopher Rhoden as charged in count 8 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that is equipped with a firearm muffler or suppressor on or about his person or under his control while committing the offense of aggravated murder as alleged in specification 3 to the 8th count. If you find the defendant not guilty of aggravated murder of Christopher Rhoden, Jr. as charged in count 8, then you will not consider this issue. For purposes of specification 3 to the 8th count, the term firearm, the requirement and the explanation of capable of expelling or propelling, The term deadly weapon, the term on or about his person or under his control, and the term possession are all defined, and the term firearm muffler or firearm suppressor. All of those are defined the same in Specification 3 to the 8th count as in Specification 3 to the other counts. And with respect to that specification, ownership is not necessary. A person may possess or control property belonging to another. So those are the first 8 counts. You can see how similar they are, but they have to be separately considered. We have separate alleged victims in each of those counts. You have separate verdict forms for each of those counts. Count 9. Let me read count 9 to you. This is a charge it alleges a charge of conspiracy. The charge states that the defendant, or the instruction states that the defendant is charged in count 9 of the indictment with conspiracy. Before you can find the defendant guilty of conspiracy as charged in count 9, you must find beyond a reasonable doubt that on or about the first day of January 2016, let me start that again. We have a different date in here. The defendant is charged in count 9 of the indictment with conspiracy. Before you can find the defendant guilty of conspiracy as charged in count 9, you must find beyond a reasonable doubt that on or about the first day of January 2016 through the 12th day of November 2018, and in Pike County, Ohio, or as part of the course of criminal conduct involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, with purpose to commit, promote, or facilitate the commission of the offense of aggravated murder, or aggravated burglary with another person or persons, planned or aided in planning the commission of such offense, or agreed with another person or persons that one or more of them would engage in conduct which facilitated the commission of one or more of such offenses. Purpose is an essential element of the offense of conspiracy. A person acts purposely when it is his specific intention to cause a certain result or to engage in conduct of a certain nature. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to commit, promote, or facilitate the commission of the offense of aggravated murder, or aggravated burglary. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act or brings about a result is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all the other facts and circumstances and evidence. If a wound is inflicted upon a person with a deadly weapon or in a manner calculated to destroy life, the purpose to cause death may be, but is not required to be, inferred from the use of the weapon. The inference, if made, is not conclusive. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Now, I've already defined for you several times the offense of aggravated murder. I will, later in these instructions, define aggravated burglary for you. Murder means to purposely cause the death of another. I've previously defined for you the terms purposely and causation, all right? So those won't be redefined, but they do apply in here. You to refer to these instructions for the definition of purposely and causation. A conspiracy is the planning or aiding in the planning of the commission of an offense with one or more other persons, or agreeing with one or more other persons that one or more of them will engage in conduct with a purpose to commit, promote, or facilitate the commission of a specific offense. A person cannot be convicted of conspiracy unless a substantial overt act in furtherance of the conspiracy is proved to have been done by the defendant or by a person with whom the defendant conspired, and that such act was performed subsequent to the defendant's entrance into the conspiracy. An overt act is substantial when it is of such character as to manifest a purpose on the part of the actor that the object of the conspiracy should be completed. Now, as you were previously instructed, Edward Jacob Wagner and Angela Jo Wagner, each of whose testimony you have heard, are said to be accomplices. An accomplice is one who purposely assists or joins another in the commission of a crime. Whether Edward Jacob Wagner or Angela Jo Wagner was an accomplice, and the weight to be given the testimony of each such person are matters for you to determine from all the facts and circumstances and evidence. The testimony of an accomplice that is supported by other evidence does not become inadmissible because of the accomplice's complicity, moral turpitude, or self-interest. But the admitted or claimed complicity of a person may affect the witness's credibility and make the witness's testimony subject to grave suspicion and require it to be weighed with great caution. It is for you as jurors, in the light of all the facts presented to you from the witness stand, to evaluate such testimony and to determine its quality and worth or its lack of quality and worth. An accomplice may have special motives for testifying, and you should carefully examine an accomplice's testimony and use it with great caution and view it with grave suspicion. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of conspiracy as charged in count 9 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of conspiracy as charged in count 9, then your verdict must be not guilty according to your findings. Now, the defendant is charged in count 10 with aggravated burglary. And let me say also that there are 4 counts of aggravated burglary. And some of the elements are the same. And so I'm going to try to do with respect to the charges of aggravated burglary what I did with respect to the charges of aggravated murder, and where there are repetitious definitions and explanations. I'm going to try to incorporate those rather than read them verbatim. So let me just start. The defendant is charged in count 10 with aggravated burglary. Now, before you can find the defendant guilty of aggravated burglary as charged in count 10, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, with purpose to commit the offense of aggravated murder or tampering with evidence, trespassed by force, stealth, or deception in an occupied structure, to wit, 1084 Left Fork Road, Rhoden, Ohio, when another person other than an accomplice of the defendant was present in that structure, and either that the defendant inflicted physical harm on that other person, namely Kenneth Rhoden, or that at the time and place in question the defendant had a deadly weapon or dangerous ordinance on or about his person or under his control. Purpose to commit aggravated murder or tampering with evidence is an essential element of the crime of aggravated burglary as charged in count 10. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to commit the offense of aggravated murder of Kenneth Rhoden, or to commit the offense of tampering with evidence. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means used, and all other facts and circumstances in evidence. If a wound is inflicted upon a person with a deadly weapon in a manner calculated to destroy life, the purpose to cause the death may be, but is not required to be, inferred from the use of the weapon. The inference, if made, is not conclusive. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. I've previously instructed you concerning the elements of the offense of aggravated murder and have defined those elements for you. You must apply those definitions and the words or phrases used to explain the elements of aggravated murder in determining whether the defendant had a purpose to commit that offense as an element of aggravated burglary. I will later instruct you as to the elements of tampering with evidence, and that's as charged in counts 15, 16, and 17 of the indictment. And will later define those elements for you. You must apply those definitions and the words or phrases used to explain the elements of tampering with evidence in determining whether the defendant had a purpose to commit that offense as an element of aggravated burglary. Now, trespass is an element of the offense of aggravated burglary. I'll therefore now instruct you concerning the elements of criminal trespass. Before you can find that the defendant trespassed, you must find beyond a reasonable doubt that on or about the date and time in question, the defendant, without privilege to do so, knowingly entered or remained on the land or premises of another. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant, without privilege to do so, entered or remained on the land or premises of another. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. Land or premises includes any land, building, structure, or place belonging to, controlled by, or in the custody of another, and any separate enclosure or room or portion thereof. Privilege means an immunity, license, or right conferred by law, bestowed by express or implied grant, or arising out of status, position, office, or relationship, or growing out of necessity. Force means any violence, compulsion, effort, or constraint exerted or used by any means upon or against a person or thing to gain entrance. Stealth means any secret or sly act to avoid discovery or to gain entrance into or to remain within a structure of another without permission. Deception means knowingly deceiving another or causing another to be deceived by any false or misleading representations, by withholding information, by preventing another from acquiring information, or by any other or by any other conduct, act, or omission that creates, confirms, or perpetuates a false impression in another, including a false impression as to law, value, state of mind, or other objective or subjective fact. Occupied structure. Occupied structure means any house, building, outbuilding, trailer, or other structure, vehicle, or shelter, or any portion thereof, which is maintained as a permanent or temporary dwelling, even though it is temporarily unoccupied, and whether or not any person is actually present, or which at the time is occupied as the permanent or temporary habitation of any person, whether or not any person is actually present, or which at the time is specially adapted for the overnight accommodation of any person, whether or not any person is actually present, or in which at the time any person is present or likely to be present. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon, or possessed, carried, or used as a weapon. A deadly weapon is any instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death. The second characteristic is in the alternative. Either the instrument, device, or thing was designed or specially adapted for use as a weapon, or it was possessed, carried, or used as a weapon in this case. These are questions of fact for you to decide. Now, the definition of dangerous ordinance includes any firearm, muffler, or suppressor, and any combination of parts that is intended by the owner for use in converting any firearm or other device into a dangerous ordinance. Firearm, muffler, or suppressor, I'll define this again, although we have previously done so. That means any device for silencing, muffling, or diminishing the report of a portable rifle, including any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer or firearm muffler, and any part intended only for use in such assembly or fabrication. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated burglary as charged in count 10 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated burglary as charged in count 10, then your verdict must be not guilty according to your findings. Now, there are specifications to count 10. If your verdict is guilty of aggravated burglary as charged in count 10 of the indictment, then you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 1 to the 10th count. If you find the defendant not guilty of aggravated burglary as charged in count 10, then you will not consider this issue. Now, for purposes of this specification 1 to the 10th count, the term firearm, the term capable of expelling and propelling, deadly weapon, on or about his person or under his control, and possession are all defined and explained in the same way as we explained as to specification 1 to the first 8 counts. So I'll just incorporate that by reference and won't read those again. Also, the ownership is not necessary. A person may possess or control property belonging to another. That's also part of specification 1. Specification 2 to the 10th count is the same specification as specification 2 to the first 8 counts. It states there that if your verdict is guilty of aggravated burglary, as charged in count 10 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 2 to the 10th count, and displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate the said offense of aggravated burglary. If you find the defendant not guilty of aggravated burglary as charged in count 10, then you will not consider this issue. And for purposes of this specification, the term firearm, the requirement and explanation of capable of expelling or propelling, the terms deadly weapon, on or about his person or under his control and possession, are all defined and explained as they were in the other specification 2 to the other first 8 counts. And so we will not read those again. Ownership, again, is not necessary. A person may possess or control property of another, property belonging to another. Specification 3, if your verdict is guilty of aggravated burglary as charged in count 10 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 3 to the 10th count. If you find the defendant not guilty of aggravated burglary as charged in count 10, then you will not consider this issue. And for purposes of specification 3 to the 10th count, the terms firearm capable of expelling or propelling, deadly weapon on or about his person or under his control, and possession are all defined and explained as they were in specification 3 to the first 8 counts. Ownership is not necessary. A person may possess or control property belonging to another, and the term firearm muffler or firearm suppressor is defined the same way as it was previously instructed. Count 11 is a charge of aggravated burglary at 4199 Union Hill Road, Pike County, Ohio. That charge states that, first of all, the defendant is charged in count 11 with aggravated burglary. Before you can find the defendant guilty of aggravated burglary as charged in count 11, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense and or element of an offense that occurred in Pike County, Ohio, the defendant with purpose to commit the offense of aggravated burglary or tampering with evidence, trespass, let me say it again. The defendant with purpose to commit the offense of aggravated murder or tampering with evidence, trespassed by force, stealth, or deception in an occupied structure, to wit, 4199 Union Hill Road, Pike County, Ohio, when another person other than an accomplice of the defendant was present in that structure, and either the defendant inflicted physical harm on that other person, namely Clarence Franklin Rhoden and or Hannah Hazel Gilly, or that at the time and place in question the defendant had a deadly weapon or dangerous ordinance on his person or under his control. Now, for purposes of count 11, which again is the charge of aggravated burglary at 4199 Union Hill Road, Pike, Ohio, the term purpose is as previously defined in count 10, with the exception that in count 11 it must be established beyond a reasonable doubt that at the date that at the time in question there was present in the mind of the defendant a specific intention to commit the offense of aggravated murder of Clarence Franklin Rhoden and or Hannah Hazel Gilly, or to commit the offense of tampering with evidence. The method of determining, or how you determine the presence or absence of purpose, is as previously defined in count 10. The term deadly weapon is as previously, as you were previously instructed. Again, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. I'll refer you also to the fact that I've previously instructed you concerning the elements of aggravated murder, and have defined those elements for you. You must apply those definitions and the words and phrases used to explain the elements of aggravated murder in determining whether the defendant had a purpose to commit that offense as an element of aggravated burglary in the 11th count. Tampering with evidence, I will later instruct you concerning the elements of the offense of tampering with evidence, and that's as charged in count 15, 16, and 17 of the indictment, and we'll define those elements for you, and you must apply those definitions and the words and phrases used to explain the elements of tampering with evidence in order to determine whether the defendant had a purpose to commit that offense as an element of aggravated burglary at 4199 Union Hill Road, Pike County, Ohio. Trespass is an element of the offense of aggravated burglary as charged in count 11, and it's defined the same way for purposes of count 11 as it was defined in count 10. Knowingly and how you determine whether one acted knowingly are also defined and explained the same for count 11 as they were in count 10. Motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. The terms land or premises, the term privilege, the term force, the term stealth, the term deception, and the term occupied structure. The term physical harm, the term deadly weapon, the explanation of the capability of a deadly weapon, and the explanation of what a deadly weapon is and its characteristics that it must have in order to be constituted a deadly weapon. The term dangerous ordnance and the term firearm muffler or firearm suppressor. All of those terms are defined and explained the same way in the instruction as to count 11 on the charge of aggravated burglary as charged in count 11 as they were explained to you in detail in charging you and instructing you concerning the charge of aggravated burglary in count 10. So I won't reread all of those, but they do all apply and have the same definitions and explanations. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated burglary as charged in count 11 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated burglary as charged in count 11, then your verdict must be not guilty according to your findings. All right, we have specification 1. If your verdict is guilty of aggravated burglary as charged in count 11 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 1 to the 11th count. If you find the defendant not guilty of aggravated burglary as charged in count 11, then you will not consider this issue. And for purposes of specification 1 to the 11th count, the term firearm capable of expelling and propelling, deadly weapon, on or about his person or under his control and possession are all defined and explained as you've previously been instructed. Ownership is not necessary. A person may possess or control property belonging to another. If your verdict is guilty of aggravated burglary as charged in count 11 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 2 to the 11th count, and displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate the offense of aggravated burglary. If you find the defendant not guilty of aggravated burglary as charged in count 11, you will not consider this issue. And for purposes of count 2 as to the, specification 2 as to the 11th count, these terms are all defined the same as they were in specification 2 to the other counts previously given. Firearm capable of expelling or propelling, deadly weapon on or about his person or under his control and possession. They're all defined and explained in the same way. Ownership is not necessary. A person may possess or control property belonging to another. Specification 3, if your verdict is guilty of aggravated burglary as charged in count 11 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 3 to the 11th count. If you find the defendant not guilty of aggravated burglary as charged in count 11, then you will not consider this issue, and for purposes of specification 3 to the 11th count, the terms firearm capable of expelling or propelling, deadly weapon on or about his person or under his control, and possession are all defined and explained the same way as they were with respect to specification 3 to the other counts previously given. Also, the term firearm muffler and firearm suppressor is defined the same. Ownership is not necessary. A person may possess or control property belonging to another. Count 12 involves the charge of aggravated burglary at 4077 Union Hill Road. The defendant is charged in count 12 with aggravated burglary. Before you can find the defendant guilty of aggravated burglary as charged in count 12, you must find beyond a reasonable doubt that on or about the 22nd day of April, 2016, and in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, with purpose to commit the offense of aggravated murder or tampering with evidence, trespassed by force, stealth, or deception in an occupied structure, to wit 4077 Union Hill Road, Piketon, Ohio, when another person other than an accomplice of the defendant was present in that structure, and either the defendant inflicted physical harm on that other person, namely Christopher Rhoden Jr. and or Gary Rhoden, or that at the time and place in question the defendant had a deadly weapon or dangerous ordinance on or about his person or under his control.
Yeah, can we break in real quick? That's actually Christopher Rhoden.
Did I read something wrong?
Christopher Rhoden Sr. and or Gary.
Did I say junior?
Yes, sir.
I'm sorry. Thank you for stopping me with that. So it must be found as an element, in addition to the trespass by force, stealth, or deception in an occupied structure, to wit 4077 Union Hill Road, Piketon, Ohio, when another person other than an accomplice of the defendant was present in that structure, and either that the defendant inflicted physical harm on that other person, namely Christopher Rhoden Sr. and or Gary Rhoden, or that at the time and place in question the defendant had a deadly weapon or dangerous ordinance on or about his person or under his control. Now, the term purpose is defined the same as an element of the 12th count as it was for count 11, with the exception that in count 12 it must be established beyond a reasonable doubt that at the time in question there was present in the mind of the defendant a specific intention to commit the offense of aggravated murder of Christopher Rhoden Sr. and or Gary Rhoden. or to commit the offense of tampering with evidence. How purpose is determined also is defined the same in, with respect to count 12 as it was with count 11. The term deadly weapon is defined the same. Again, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. As I previously told you, but will tell you again, I have instructed you already several times concerning the elements of aggravated murder, and I've defined the terms and elements for you. You must apply those definitions and the words and phrases used to explain the elements of aggravated murder in determining whether the defendant had a purpose to commit that offense as an element of the charge of aggravated burglary in count 12. I will define for you later the elements of the offense of tampering with evidence as charged in count 15, 16, and 17 of the indictment, and you will define those terms for you, and you must apply those definitions, words, and phrases used to explain the elements of tampering with evidence in determining whether the defendant had a purpose to commit that offense as an element of the charge of aggravated burglary in count 12. Trespass is an element of the offense of aggravated burglary as charged in count 12. It's defined the same way for purposes of count 12 as it was for count 11. Knowingly, the term knowingly is defined the same way. How the presence or absence of knowledge, or the element of knowledge is determined is defined the same way for count 12 as it was for count 11. Motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. For purposes of count 12, the following definitions and explanations are the same as they were in count 11. Land or premises, privilege, force, stealth, deception, and occupied structure. Physical harm, deadly weapon, the capability of a deadly weapon, the characteristics, the two characteristics are required in order to determine whether an instrument is a deadly weapon. Dangerous ordnance and firearm muffler or firearm suppressor. All of those are defined and explained in the same way with respect to count 12 as they were with count 11, so I won't be reading those in full. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated burglary, as charged in count 12 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated burglary as charged in count 12, then your verdict must be not guilty according to your findings. We have the three specifications with respect to count 12. If your verdict is guilty of aggravated burglary as charged in count 12 of the indictment, you will separately decide whether the state proved beyond reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification to the 12th count. If you find the defendant not guilty of aggravated burglary as charged in count 12, then you will not consider this issue, and for purposes of specification 1 to the 12th count, the terms firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control and possession, are all defined and explained the same way as to specification 1 to count 11. And so we won't be reading those in full. Ownership is not necessary. A person may possess or control property of another. If your verdict is guilty of aggravated burglary as charged in count 12 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 2 to the 12th count, and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the said offense of aggravated burglary. If you find the defendant not guilty of aggravated burglary as charged in count 12, you will not consider this issue. And for purposes of specification 2 to the 12th count, The terms firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control and possession are all defined the same way as they were with respect to specification 2 to the 11th count, so we won't be repeating those, to both the 10th and the 11th count. Ownership is not necessary. A person may possess or control property belonging to another. As to specification 3 to the 12th count, if your verdict is guilty of aggravated burglary as charged in count 12 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 3 to the 12th count. If you find the defendant not guilty of aggravated burglary as charged in count 12, you will not consider this issue, and for purposes of the third specification to the 12th count, these terms all have the same definition and explanation as the specification 3 to the 10th and 11th count, so I won't be reading these over again, but let me just mention the term firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control, possession, and firearm muffler or firearm suppressor. Again, they're all explained and defined as in specification 3 to count 10 and 11. Ownership is not necessary. A person may possess or control property belonging to another. Count 12 involves the charge of aggravated burglary at 3122 Union Hill Road, Piketon, Ohio. The defendant is charged in count 12 with aggravated burglary. Before you can find the defendant guilty of aggravated burglary as charged in count 12, you must find beyond a reasonable doubt that on or about the 22nd day of April 2016 and in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant with purpose to commit the offense of aggravated murder or tampering with evidence, trespassed by force, stealth, or deception in an occupied structure, to wit, 3122 Union Hill Road, Piketon, Ohio, when another person other than an accomplice of the defendant was present in that structure, and either the defendant inflicted physical harm on that other person, namely Dana Rhoden and or Hannah Mae Rhoden and or Christopher Rhoden Jr., or that at the time and place in question the defendant had a deadly weapon or dangerous ordinance on or about his person or under his control. For the purpose of count 13, the definition of purpose as an element of aggravated burglary is the same as it was for counts 10, 11, and 12, with the exception that in count 13, it must be established beyond a reasonable doubt that at the time in question there was present in the mind of the defendant a specific intention to commit the offense of aggravated murder of Dana Rhoden and or Hannah Mae Rhoden and or Christopher Rhoden Jr., or to commit the offense of tampering with evidence. How purpose is determined is also the same as in for this count, for count 13 as it was for 10, 11, and 12. The definition of deadly weapon is the same. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Also, for purposes of count 13, I just remind you that I previously defined for you and instructed you concerning the elements of aggravated murder, and defined those elements for you, and you are to apply and must apply the definitions and words and phrases used to explain the elements of aggravated murder in determining whether the defendant had a purpose to commit that offense as an element of aggravated burglary as charged in count 13. I will later instruct you concerning the elements of the offense of tampering with evidence as that offense is charged in count 15, count 16, count 17 of the indictment will define those elements for you, and you must apply those definitions and words and phrases used to explain the elements of tampering evidence in determining whether the defendant had a purpose to commit that offense as an element of the offense of aggravated burglary as charged in count 13 of the indictment. All right, with respect to count 13, trespass is an element of the offense of aggravated burglary as charged in count 13. Trespass is defined the same way for count 13 as it was for counts 10, 11, and 12. The term knowingly and how the element of knowledge is to be determined are also defined and explained the same for count 13 as they were for count 10, 11, and 12. Motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. For purposes of count 13, the following terms are also defined and explained the same way as they were for counts 10, 11, and 12. Those terms are land or premises, privilege, force, stealth, deception, occupied structure, physical harm to persons, deadly weapon, capability of the deadly weapon, two characteristics required in order to have a deadly weapon, dangerous ordnance, and firearm muffler or firearm suppressor. The definition and explanation of all those terms are the same for count 13 as they were for counts 10, 11, and 12. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of aggravated burglary, as charged in count 13 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated burglary as charged in count 13, then your verdict must be not guilty according to your findings. If your verdict is guilty of aggravated burglary as charged in count 13 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as charged, as alleged in specification 1 to the 13th count. If you find the defendant not guilty of aggravated burglary as charged in count 13, then you will not consider this issue. For the purposes of specification 1 to the 13th count, the terms firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control, and possession are all defined and explained the same as they were to specification 1 as to counts 10, 11, and 12. Ownership is not necessary. A person may possess or control property belonging to another. If your verdict is guilty of aggravated burglary as charged in count 13 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 2 to the 13th count and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the said offense of aggravated burglary. If you find the defendant not guilty of aggravated burglary as charged in count 13, then you will not decide this issue. And for purposes of specification 2 to the 13th count, the terms firearm, capable of expelling or propelling, deadly weapon, on or about his person or under his control, and possession are all defined and explained the same as they were for specification 2 to counts 10, 11, and 12. Ownership is not necessary. A person may possess or control property belonging to another. As to specification 3 to the 13th count, if your verdict is guilty of aggravated burglary as charged in count 13 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm that was equipped with a firearm muffler or firearm suppressor on or about his person or under his control while committing the offense of aggravated burglary as alleged in specification 3 to the 13th count. If you find the defendant not guilty of aggravated burglary as charged in count 13, then you will not consider this issue. and for purposes of specification 3 to the 13th count, the terms firearm capable of expelling or propelling, deadly weapon on or about his person or under his control, possession, and firearm muffler or firearm suppressor are all defined and explained the same as they were to specification 3 to counts 10, 11, and 12. Ownership is not necessary. A person may possess or control property belonging to another. So those are the 4 counts of aggravated burglary, and they must be separately considered. I have a hand up. All right.
I was just going to suggest a break, Your Honor.
What was it?
I was going to suggest a break.
Okay, yes. Let's do that. We will break for 15 minutes. While you're on break, do not discuss this case among yourselves or with anyone else. Do not permit anyone to discuss this case with you or in your presence. Do not express an opinion concerning the case. Do not do any research concerning the facts or the law of the case from any source at all. Do not read, view, or listen to any reports or accounts of the case from any source at all, and have no contact with participants in the case, including parties, counsel, or witnesses. So it will be, I suppose, about 15 till 4. We're in recess until then. Assemble at the jury room. You'll be brought directly back up here for the conclusion. the juror. I don't want her number, get her number too. I forgot what her number is.
Yeah. No, take your time, whatever. We'll go on your schedule. Oh, boy.
Yeah, we're ready for the jury, aren't we? Yeah.
Yes.
We are, yeah. What is it?
Thank you.
You may be seated. Well, see, we have to get our juror on the phone. Jason's with them.
Jason's office, Your Honor. They know she's not coming up.
Well, he was going to connect her though, so that we could talk, but I don't know what he's doing right now is, I don't know who's going to put it on the
I
video.
thought he was going to do video.
I thought he was going to bring up maybe a live feed through the computer.
Oh, okay.
So I thought that's.
Okay.
So I guess what we would need from him is kind of a thumbs up, some kind of indication that he's ready to go. But I thought we were going to do the video.
Yeah, Jason, how are you going to hook her up now? Can she hear that too? Or? Okay, so she's on right now. Okay, that's fine. All right. All right, let the record show that the jurors are back in the jury box, and 4 of our 5 alternates are also back. Juror B38 had been having difficulties ambulating and indicated that she requested that she be permitted to watch and listen to the remainder of these charges. So she is at another location right now viewing this and also hearing it. It's my understanding, so I'm going to proceed with these instructions. The defendant's present with his attorneys. The state's 3 attorneys are here, as is Agent Scheider. Are we ready to proceed then? All right. Count 14 is a charge of unlawful possession of dangerous ordnance. The defendant is charged in count 14 with unlawful possession of dangerous ordnance. Before you can find the defendant guilty of unlawful possession of dangerous ordnance that's charged in count 14, you must find beyond reasonable doubt that on or about the first day of January 2016 through the 22nd day of April 2016, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of the offense that occurred in Pike County, Ohio, the defendant knowingly acquired, had, carried, or used a dangerous ordinance. A person acts knowingly regardless of his purpose when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry, or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant acquired, had, carried, or used a dangerous ordinance. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon knowledge. Had means possessed. We've previously defined possession, so I won't define that again. The definition is the same as you've previously been instructed. Dangerous ordnance. The definition of dangerous ordnance includes any firearm, muffler, or suppressor, and any combination of parts that is intended by the owner for use in converting any firearm or other device into a dangerous ordnance. Firearm muffler or firearm suppressor is defined as you have previously been informed. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of unlawful possession of dangerous ordnance as charged in count 14 of the indictment, Your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of unlawful possession of dangerous ordnance as charged in count 14, then your verdict must be not guilty according to your findings. There are two specifications to the 14th count. If your verdict is guilty of unlawful possession of dangerous ordnance as charged in count 14 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of unlawful possession of dangerous ordnance as alleged in specification 1 to the 14th count. If you find the defendant not guilty of unlawful possession of dangerous ordnance as charged in count 14, then you will not consider this issue. Firearm is defined as you've previously been informed. Capable of expelling or propelling is you've previously been informed of the definition of that. Deadly weapon on or about his person or under his control and possession are all as previously defined. So the court will just incorporate those by referring to them now, but you can, but they are the same as previously, previously informed. Ownership is not necessary. A person may possess or control property belonging to another. If your verdict is guilty of unlawful possession of dangerous ordnance as charged in count 14 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of unlawful possession of dangerous ordnance as alleged in specification 2 to the 14th count, and displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the offense of unlawful possession of dangerous ordnance. If you find the defendant not guilty of unlawful possession of dangerous ordnance as charged in count 14, then you will not consider this issue. For purposes of the specification 2 to the 14th count, the definitions of firearm capable of expelling or propelling, deadly weapon on or about his person or under his control, and possession are the same as that you were previously instructed. So those are the same. Ownership is not necessary. A person may possess or control property belonging to another. The defendant is charged in count 15 of the indictment with tampering with evidence. Before you can find the defendant guilty of tampering with evidence as charged in count 15, you must find beyond a reasonable doubt that on or about the 22nd day of April 2022 and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or element of an offense that occurred in Pike County, Ohio, the defendant, knowing that an official proceeding or investigation was in progress or was about to be instituted or likely to be instituted, altered, destroyed, concealed, or removed records, documents, or things, to wit, phones and or cameras and or other items belonging to Kenneth Rhoden and or Chris Rhoden Sr. and or Gary Rhoden and or Clarence Franklin Rhoden and or Hannah Hazel Gilley and or Dana Rhoden and or Hannah Mae Rhoden and or Christopher Rhoden Jr. with purpose to impair the value or availability of such phones and or cameras and or other items as evidence in the proceeding or investigation. Purposely, or let me just say, define purposely, purpose to impair the value or availability of a record, document, or thing as evidence in an official proceeding or investigation is an essential element of the crime of tampering with evidence as charged in count 15. A person acts purposely when it is the person's specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to impair the value or availability of phones and or cameras and or other items belonging to Kenneth Rhoden and or Chris Rhoden Sr. and or Gary Rhoden and/or Clarence Franklin Rhoden, and/or Hannah Hazel Gilley, and/or Dana Rhoden, and/or Hannah Mae Rhoden, and/or Christopher Rhoden Jr. as evidence in an official proceeding. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances and evidence. Knowing that an official proceeding or investigation is in progress or is likely to be, or is about to be, or likely to be instituted, is an essential element of the offense of tampering with evidence. A person acts knowingly, regardless of his purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of the offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry, or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that an official proceeding or investigation was in progress or was about to be or likely to be instituted. Official proceeding means any proceeding before a judicial or other government agency or official authorized to take evidence under oath, and includes any proceeding before a referee, hearing examiner, commissioner, notary, or other person taking testimony or a deposition in connection with an official proceeding. Public official means any elected or appointed officer or employee or agent of the state or any political subdivision thereof, whether in a temporary or permanent capacity, and including, without limitation, judges and law enforcement officers. If you find that the state proved, beyond a reasonable doubt, all of the essential elements of the offense of tampering with evidence as charged in count 15 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of tampering with evidence as charged in count 15, then your verdict must be not guilty according to your findings. Count 16 also charges tampering with evidence. The defendant is charged in count 16 of the indictment with tampering with evidence. Before you can find the defendant guilty of tampering with evidence as charged in count 16, you must find beyond a reasonable doubt that on or about April 3rd, 2016, and in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, knowing that an official proceeding or investigation was in progress or was about to be instituted or likely to be instituted, made, presented, or used a record, document, or thing, to wit, custody documents, knowing it was false and with purpose to mislead a public official who was or may have been engaged in the proceeding or investigation, or knowing it was false and with purpose to corrupt the outcome of the proceeding or investigation. Now, for purposes of the count 16, the term purposely is defined exactly as it was in count 15. How purpose is determined is also defined in the same way and explained in the same way. Knowing that an official proceeding or investigation is in progress or is about to be or likely to be instituted is also an essential element of the offense of tampering with evidence as charged in count 16, and knowingly is defined the same way as it was in count 15, and how knowledge is determined, or how the element of knowingly is determined is defined the same way. Official proceeding is defined the same way for 16 as it was in 15, as is the term public official defined the same way. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of tampering with evidence as charged in count 16 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of tampering with evidence as charged in count 16, then your verdict must be not guilty according to your findings. Counsel will approach you in just a minute. All right, I apologize, ladies and gentlemen, the copier, or the copy that I have here had some pages omitted in it, and glad I caught it, but I called it. The ones you get will have everything in it, and I've got one now that does also. Let me begin with 16 here again. The defendant is charged in count 16 of the indictment of tampering with evidence. Before you can find the defendant guilty of tampering with evidence in charged in count 16, you must find beyond a reasonable doubt that on or about April 3rd, 2016, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of offense that occurred in Pike County, Ohio, the defendant, knowing that an official proceeding or investigation was in progress or was about to be instituted or likely to be instituted, made, presented, or used a record, document, or thing, to wit, custody documents, knowing it was false with purpose to mislead a public official who was or may have been engaged in the proceeding or investigation, or knowing it was false with purpose to corrupt the outcome of the proceeding or investigation. Now, for purposes of count 16, The term purposely is defined the same way that it was in count 15, and the method of finding purpose is also defined the same way, how that's determined. Knowingly is also defined the same as it was in count 15. And how that's determined, how that element is determined is defined the same as in number 15. Official proceeding is defined the same way in 16 as in 15. Public official is defined the same way as well. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of tampering with evidence as charged in count 16 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of tampering with evidence as charged in count 16, then your verdict must be not guilty according to your findings. Now, count 17 charges a third charge of tampering with evidence. Count 17 reads as follows. The defendant is charged in count 17 of the indictment with tampering with evidence. Before you can find the defendant guilty of tampering with evidence as charged in count 17, you must find beyond a reasonable doubt that on or about January 1, 2016 through May 9, 2017, and in Pike County, Ohio, or as part of the course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, knowing that an official proceeding or investigation was in progress or was about to be instituted or likely to be instituted, altered, destroyed, concealed, or removed records, documents, or things, to wit, silencer and or shell casings and or parts of a home security system and or other items with purpose to impair the value or availability of such silencer and or shell casings and or parts of a home security system and or other items as evidence in the proceeding or investigation. Now, for purposes of count 17, the term purposely is defined exactly as it was for count 15 and 16. The method of determining how to determine whether that element exists is also defined and explained the same way as in counts 15 and 16. Knowingly and how knowledge, how that element is determined, is defined and explained exactly for purposes of count 17, exactly as it was for 15 and 16. Official proceeding is also defined the same way for count 17 as is public official. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of tampering with evidence as charged in count 17 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of tampering with evidence as charged in count 17, then your verdict must be not guilty according to your findings. Count 18 charges the offense of forgery. The defendant is charged in count 18 of the indictment with forgery. Now, before you can find the defendant guilty of forgery as charged in count 18, you must find beyond a reasonable doubt that on or about April 3, 2016, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, with a purpose to defraud, or knowing that he was facilitating the fraud, forged any writing, to wit, custody documents of Anna Mae Rhoden, without such person's authority, and or forged any writing, to wit, custody documents, so that it purported to be genuine when it was actually spurious, or purported to be the act of another, to wit, Anna Mae Rhoden, who did not authorize that act, and/or forged any writing, to wit, custody documents, so that it purported to have been executed at a time or place with terms, or at a time or place, or with terms different from what in fact was the case, or to have been a copy of an original when no such original existed. Purpose. Make sure that we have the same definition here. I think we do. Well, let me just read this because it looks a little different to me for some reason. Purpose, as used in this charge, purpose to defraud, I should say, or alternatively, knowing that one is facilitating the fraud. Purpose to defraud, or alternatively, knowing that one is facilitating a fraud, is an essential element of the crime of forgery as charged in count 18. A person acts purposely when it is the person's specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to defraud, or alternatively, that it must be established in this case that at the time in question the defendant knew that he was facilitating a fraud. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances in evidence. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of the offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry, or acts with a conscious purpose to avoid learning the fact. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant was facilitating a fraud. Defraud means to knowingly obtain by deception some benefit for oneself or another, or to knowingly cause by deception some detriment to another. The definition of the noun fraud is identical to the definition of the verb defraud. In other words, fraud and defraud, or defraud and fraud, mean the same thing. Deception means knowingly deceiving another or causing another to be deceived by any false or misleading representation, by withholding information, by preventing another from acquiring information, or by any other conduct, act, or omission that creates, confirms, or perpetuates a false impression in another, including a false impression as to the law, value, state of mind, or other objective or subjective fact. Facilitating means helping, promoting, assisting, or aiding. Forge means to fabricate or create in whole or in part by any means any spurious or false writing, or to make, execute, alter, complete, reproduce, or otherwise purport to claim to authenticate any writing when the writing in fact is not authenticated by that conduct. Writing means any computer software, document, letter, memorandum, note, paper, plate, data, film, or other thing having in or upon it any written, typewritten, or printed matter, and any token, stamp, seal, credit card, badge, trademark, label, or other symbol of value, right, privilege, license, or identification. Execute means to sign a document. If you find that the state proved beyond a reasonable doubt all of the essential elements of forgery as charged in count 18 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of forgery as charged in count 18, then your verdict must be not guilty according to your findings. The defendant is charged in count 19 of the indictment with unauthorized use of property. Before you can find the defendant guilty of unauthorized use of property as charged in count 19, you must find beyond a reasonable doubt that on or about July 1, 2014 through May 9, 2017, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, in any manner and by any means, including but not limited to computer hacking, knowingly gained access to, attempted to gain access to, or caused access to be gained to any computer and or computer system and or computer network and or telecommunications device and or telecommunications service and or information service, to wit, social media accounts, without the consent or beyond the scope of the express or implied consent of the owner of the computer and or computer system and or computer network and or telecommunications device and or telecommunications service and or information service, to wit, Tabitha Clater and or Patricia Tess Ruggles, or other person authorized to give consent. Knowingly is an essential element of the crime of unauthorized use of property as charged in count 19 of the indictment. Well, I'm going to read the definition of knowingly. It's just because I'm not sure it's exactly the same here. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of the offense, such knowledge is established if a person subjectively believes there is a high probability of its existence and fails to make inquiry or acts with such purpose, or acts with a conscious purpose, I should say, to avoid learning the fact. Now, because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant gained access to, attempted to gain access to, or caused access to be gained to any computer and or computer system and or computer network and or telecommunications device and or telecommunications service and or information service, to wit, social media accounts, without the consent or beyond the express or implied consent of the owner of the computer and or computer system and or computer network and or telecommunications device and or telecommunications service and or information service, or other person authorized to give consent. Consent may be either express or implied. Express consent is determined by the written or spoken words of the persons involved. Implied consent is determined by the facts and circumstances that surround those involved, including their words and acts, from which you may infer that consent was given to the defendant. Property means any property, real or personal, tangible or intangible, and any interest or license in that property. Property includes, but is not limited to, cable television service, other telecommunications service, telecommunications devices, information service, computers, data, computer software, financial instruments associated with computers, other documents associated with computers, or copies of the documents. Owner means any person other than the defendant who is the owner of or who has possession or control of or any license or interest in property or services, even though the ownership, possession, control, license, or interest is unlawful. Gain access means to approach, instruct, communicate with, store data in, retrieve data from, or otherwise make use of any resource of a computer, computer system, or computer network. Computer means any electronic device that performs logical, arithmetic, and memory functions by the manipulation of electronic or magnetic impulses. Computer includes, but is not limited to, all input, output, processing, storage, computer program, or communication facilities that are connected or related in a computer system or network to an electronic device of that nature. Computer system means a computer and related devices, whether connected or unconnected, including but not limited to data input, output, and storage devices, data communications links, and computer programs and data that make the system capable of performing specified special purpose data processing tasks. Computer network means a set of related and remotely connected computers and communication facilities that includes more than one computer system that has the capability to transmit among the connected computers and communication facilities through the use of computer facilities. Telecommunication means the origination, emission, dissemination, transmission, or reception of data, images, signals, sounds, or other intelligence or equivalents of intelligence of any nature over any communication system by any method, including but not limited to a fiber optic, electronic, magnetic, optical, digital, or analog method. Telecommunications device means any instrument, equipment, machine, or other device that facilitates telecommunication, including but not limited to a computer, computer network, computer chip, computer circuit, scanner, telephone, cellular telephone, pager, personal communications device, transponder, receiver, radio, modem, or device that enables the use of a modem. Telecommunications service means providing, allowing, facilitating, or generating any form of telecommunication through the use of a telecommunications device over a telecommunications system. Information service means the offering of a capability for generating, acquiring, storing, transforming, processing, retrieving, utilizing, or making available information via telecommunications, including but not limited to electronic publishing, but does not include any use of a capability of the type just described for the management, control, or operation of a telecommunications system or the management of a telecommunications service. If you find that the state proved beyond a reasonable doubt all of the essential elements of an authorized use of property as charged in Count 19 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of an authorized use of property as charged in Count 19, then your verdict must be not guilty according to your findings. The defendant is charged in Count 20 with interception of wire, oral, or electronic communications. Before you can find the defendant guilty of interception of wire, oral, or electronic communications as charged in count 20, you must find beyond a reasonable doubt that on or about July 1, 2014 through May 9, 2017, and in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant purposely intercepted, attempted to intercept, or procured another to intercept or attempt to intercept an electronic communication. Purpose to intercept, attempt to intercept, or procure another to intercept or attempt to intercept an electronic communication is an essential element of the crime of interception of wire, oral, or electronic communication. A person acts purposely when it is the person's specific intention to cause a certain result or to engage in conduct of a certain nature. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to intercept, attempt to intercept, or procure another to intercept or attempt to intercept an electronic communication. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result or engage in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances in evidence. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Intercept means the oral or other acquisition of the contents of any electronic communication through the use of an interception device. Oral means relating to the ear or sense of hearing. Electronic communication means a transfer of a sign, signal, writing, image, sound, datum, or intelligence of any nature that is transmitted in whole or in part by a wire, radio, electromagnetic, photoelectric, or photo-optical system. Electronic communication does not include a wire or oral communication, a communication made through a tone-only paging device, or a communication from an electronic or mechanical tracking service that permits the tracking of the movement of a person or object. Interception device means an electronic, mechanical, or other device or apparatus that can be used to intercept a wire, oral, or electronic communication. Interception device does not mean any of the following: a telephone or telegraph instrument, equipment, or facility, or any of its components, if the instrument, equipment, facility, or component is any of the following: furnished to the subscriber or user by a provider of wire or electronic communication service in the ordinary course of its business, and being used by the subscriber or user in any or user in the ordinary course of its business. Furnished by a subscriber or user for connection to the facilities of the provider of a wire or electronic communication service and used in the ordinary course of the subscriber's or user's business, or being used by a provider of wire or electronic communication service in the ordinary course of its business, or by an investigative or law enforcement officer in the ordinary course of the officer's duties that do not involve the interception of wire, oral, or electronic communications. And I'm going back, it also says that interception device does not include any of the following. That's number one. Number two is a hearing aid or similar device being used to correct subnormal hearing to not better than normal. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of interception of wire, oral, or electronic communications as charged in count 20 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of interception of wire, oral, or electronic communications as charged in count 20, then your verdict must be not guilty according to your findings. The defendant is charged in count 21 with obstructing justice. Before you can find the defendant guilty of obstructing justice as charged in count 21, you must find beyond a reasonable doubt that on or about April 22nd, 2016 through November 12, 2018, and in Pike County, Ohio, or as part of a course of criminal conduct involving an offense or an element of an offense that occurred in Pike County, Ohio, the defendant, with purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another, to wit, Angela Jo Wagner and or George Washington Wagner III and or Edward Jacob Wagner for a crime, to wit, aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unauthorized use of property, interception of wire, oral, or electronic communications, and or engaging in a pattern of corrupt activity, and or to assist another, to wit, Angela Jo Wagner and or George Washington Wagner III and or Edward Jacob Wagner, to benefit from the commission of a crime, to wit, aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unlawful use of property, interception of wire, oral, or electronic communications, and or engaging in a pattern of corrupt activity, destroyed or concealed physical evidence of the crime, or induced a person to withhold testimony or information, or to elude legal process summoning the person to testify or supply evidence, and or communicated false information to any person. Purpose to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for a crime, or to assist another to benefit from the commission of a crime, is an essential element of the crime of obstructing justice as charged in count 21 of the indictment. A person acts purposely when it is the person's specific intention to cause a certain result or to engage in conduct of a certain nature. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to hinder the discovery, apprehension, prosecution, conviction, or punishment of another for a crime, or to assist another to benefit from the commission of the crime. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result or engage in a specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances in evidence. The state is not required to prove that the other person aided by the defendant was apprehended for, charged with, or convicted of, or pleaded guilty to the crime that that other person committed. To find that the offense of aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unauthorized use of property, interception of wire, oral, or electronic communication, and or engaging in a pattern of corrupt activity were committed by another, namely Angela Jo Wagner, George Washington Wagner III, and or Edward Jacob Wagner, you must find beyond a reasonable doubt that all of the elements of each of those, you must find beyond a reasonable doubt all of those elements of each of those crimes. Now, I have previously instructed you as to the elements of aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unauthorized use of property, and interception of wire, oral, or electronic communications. I will instruct you as to the elements of engaging in a pattern of corrupt activity. You are instructed that you must apply these definitions and the words and phrases used to explain the elements of each of those crimes in determining whether the one or more of such crimes were committed by Angela Jo Wagner, George Washington Wagner III, and or Edward Jacob Wagner. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of obstructing justice as charged in count 21 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of obstructing justice as charged in count 21, then your verdict must be not guilty according to your findings. If you find the defendant guilty of obstructing justice as charged in count 21 of the indictment, you must go on to make an additional finding. You must make a determination whether at least one of the crimes for which the defendant intended to hinder the apprehension, prosecution, conviction, or punishment, or at least one of the crimes for which the defendant intended to assist another to benefit from the commission of, is a felony. The following offenses are felonies as defined by the Ohio Revised Code as they are charged in the indictment: aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unauthorized use of property, interception of wire, oral, or electronic communications, and engaging in a pattern of corrupt activity. The defendant is charged in count 22 of the indictment with engaging in a pattern of corrupt activity. Before you can find the defendant guilty of engaging in a pattern of corrupt activity as charged in count 22, you must find beyond a reasonable doubt that the defendant, from on or about January 1, 2016 through November 12, 2018, in Pike County, Ohio, or as part of a course of criminal conduct of the defendant involving an offense or an element of an offense that occurred in Pike County, Ohio, while associated with an enterprise, conducted or participated in, directly or indirectly, the affairs of the enterprise through a pattern of corrupt activity. Enterprise includes any individual, partnership, limited partnership, or other legal entity, or any organization, association, or group of persons associated in fact, although not a legal entity. Enterprise includes illicit as well as licit enterprises. Conducted means to direct. Participate means to take part in, and is not limited to those who have directed the pattern of corrupt activity. Participate encompasses those who have performed activities necessary or helpful to the operation of the enterprise, whether directly or indirectly, without an element of control. The term pattern of corrupt activity means two or more incidents of corrupt activity that are related to the affairs of the same enterprise, are not isolated, and are not so closely related to each other and connected in time and place that they constitute a single event. The finding of a pattern of corrupt activity requires proof of at least 2 incidents of corrupt activity, one of which must have occurred after January 1, 2018.
Your Honor,
Yes.
1986.
I'm sorry.
You read the date wrong on that.
Oh, I read, what did I read wrong?
It should be 1986. You said 2018. It's at the very last, right before corrupt activity.
It was an under pattern of corrupt activity.
I
Look,
can
I can
approach?
read the whole thing again if you.
Top of page 141, Your Honor.
Yes, pattern of corrupt activity is the one, Your Honor.
At least 2 incidents of corrupt activity, one of which must have occurred after January 1.
Yep.
What did I say?
You said
1986.
2018.
Did I give the
is what
wrong
you
year?
said.
I'm sorry. Let me just read that again. Pattern of corrupt activity means 2 or more incidents of corrupt activity that are related to the affairs of the same enterprise, are not isolated, and are not so closely related to each other and connected in time and place that they constitute a single event. A finding of pattern of corrupt activity requires proof of at least 2 incidents of corrupt activity, one of which must have occurred after January 1, 1986. I apologize for reading that wrong. Corrupt activity means engaging in, attempting to engage in, conspiring to engage in, or soliciting, coercing, or intimidating another person to engage in any of the following: aggravated murder, aggravated burglary, unlawful possession of a dangerous ordinance, tampering with evidence, forgery, or obstructing justice. Solicit means to seek, to ask, to influence, to invite, to tempt, to lead on, to bring pressure to bear. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of engaging in a pattern of corrupt activity, as charged in count 22 of the indictment, your verdict must be guilty according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of engaging in a pattern of corrupt activity, as charged in count 22, then your verdict must be not guilty according to your findings. If your verdict is guilty of engaging in a pattern of corrupt activity, as charged in count 22 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of engaging in a pattern of corrupt activity, as alleged in specification 1 to the 22nd count. If you find the defendant not guilty of engaging in a pattern of corrupt activity, as charged in count 22, then you will not consider this issue. All right, for purposes of specification 1 to count 22, firearm capable of expelling or propelling deadly weapon and on or about his person or under his control and possession are all defined as you've previously been instructed. Ownership is not necessary. A person may possess or control property belonging to another. If your verdict is guilty of engaging in a pattern of corrupt activity as charged in count 22 of the indictment, you will separately decide whether the state proved beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of engaging in a pattern of corrupt activity as alleged in specification 2 to the 22nd count, and displayed the firearm, indicated that he possessed the firearm, or used the firearm to facilitate the said offense of engaging in a pattern of corrupt activity. If you find the defendant not guilty of engaging in a pattern of corrupt activity, as charged in count 22, then you will not consider this issue. And for the purpose of specification 2 to the 22nd count, the term firearm capable of expelling or propelling deadly weapon on or about his person or under his control and possession are all defined and explained as you've previously been instructed. Again, ownership is not necessary. A person may possess or control property belonging to another. If your verdict is guilty of engaging in a pattern of corrupt activity as charged in count 22 of the indictment, you will separately decide whether committing the offense of engaging in a pattern of corrupt activity as alleged in specification 3 to the 22nd count. If you find the defendant not guilty of engaging in a pattern of corrupt activity as charged in count 22, then you will not consider this issue. And for the purposes of specification 3 to count 22, the terms firearm, capable of expelling or propelling, deadly weapon on or about his person or under his control, possession, and firearm muffler or suppressor are all defined and explained as they were as you've previously been instructed, so I won't repeat those. Ownership is not necessary. A person may possess or control property belonging to another. Now, the state of Ohio has presented a theory that the defendant acted in complicity with the principal offenders in the commission of each of the counts and specifications in the indictment. A person who is complicit with another in the commission of a crime, in the commission of a criminal offense, is regarded as guilty as if he personally performed every act constituting the offense. Is regarded as guilty as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act constituting the offense, or was not physically present at the time the offense was committed. Before you can find the defendant guilty of complicity in the commission of any of the offenses or specifications in the indictment, you must find, beyond a reasonable doubt, that on or about the dates specified in that respective counter specification in the indictment and in Pike County, Ohio, or as part of a course of criminal conduct involving an offense or element of an offense that occurred in Pike County, Ohio, the defendant, acting with the same applicable culpable mental state required for the commission of the respective offense or specification, solicited or procured another to commit the offense, aided or abetted another in the commission of the offense, or conspired with another to commit the offense. Now, I've previously defined for you the terms purposely and knowingly. Those definitions are the same as you were previously given. Solicit means to seek, to ask, to influence, to invite, to tempt, to lead on, to bring pressure to bear. Procure means to get, obtain, induce, bring about, or motivate. Aided or abetted, let me define that. Before you can find that the defendant guilty of complicity by aiding and abetting, you must find beyond a reasonable doubt that the defendant supported, assisted, encouraged, cooperated with, advised, or incited the principal offender in the commission of the offense, and that the defendant shared the criminal intent of the principal offender. Such intent may be inferred from the circumstances surrounding the offense, including, but not limited to, presence, companionship, and conduct before and after the offense was committed. The mere presence of the defendant at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider and abetter. Conspired means to plan or aid in the planning of the commission of an offense with one or more other persons, or agreeing with one or more other persons that one or more of them will engage in conduct with a purpose to commit, promote, or facilitate the commission of the specific offense. I've already defined for you each of the offenses involved in the indictment. and the specifications also as to those offenses, principal offenses, which had specifications to them. And I've already defined those terms and explained those terms to you. You are to apply those definitions and those terms as previously explained to you. It is no defense to the charge of complicity that no person with whom the defendant was allegedly in complicity has been convicted as a principal offender. The state need not establish the principal's identity, but need only to prove that a principal committed the offense. The defendant cannot be found guilty of complicity unless the respective offense was actually committed. You have, as you've previously been instructed, Edward Jacob Wagner and Angela Jo Wagner, each of whose testimony you have heard, are said to be accomplices. An accomplice is one who purposely assists or joins another in the commission of a crime. Whether Edward Jacob Wagner or Angela Jo Wagner was an accomplice and the weight to give the testimony of each such person are matters for you to determine from all the facts and circumstances and evidence. The testimony of an accomplice that is supported by other evidence does not become inadmissible because of the accomplice's complicity, moral turpitude, or self-interest. But the admitted or claimed complicity of a witness may affect the witness's credibility and make the witness's testimony subject to grave suspicion and require it to be weighed with great caution. It is for you, as jurors, in light of all the facts presented to you from the witness stand, to evaluate such testimony and to determine its quality and worth or its lack of quality and worth. An accomplice may have special motives for testifying, and you should carefully examine an accomplice's testimony and use it with great caution and view it with grave suspicion. If you find the state proved beyond a reasonable doubt that all the essential elements of complicity to commit any offense or specification in the indictment, let me start that again. If you find that the state proved beyond a reasonable doubt all the essential elements of complicity to commit an offense or specification in the indictment, your verdict must be guilty as to that count or specification according to your findings. If you find the state failed to prove beyond a reasonable doubt that the defendant is guilty either as a principal offender or as complicit in any of the given counts or specifications, then your indictment must be not guilty as to that count or specification according to your findings. Consider all the counts separately. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and specification and the evidence applicable to each count and specification separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count or specification. The defendant may be found guilty or not guilty of any one or all of the offenses charged. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of whether the defendant is guilty or not guilty. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, and to apply the instructions of the court to your findings and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence, impartiality, and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of trial the court said or did anything that you consider as an indication of the court's view of the facts, you are instructed to disregard it. You will be given a copy of these instructions. In fact, we'll probably give you several copies. of these instructions. You may not need as many as we give you. If you need more, you can write out to the bailiff that you need more, and we'll provide them, but we'll probably give you at least everything that you need, all the copies that you need. If during your deliberations you are in doubt about a portion of these instructions, and I think I said this before, you may request such information. The foreperson that you elect among yourselves, the foreperson must put your question in writing, indicating specifically what is requested. Such communication must be delivered to one of the court employees who is assigned to supervise the jury. The foreperson is to follow the instructions given by the supervising court employee for summoning the employee, and it'll be either a knock on the door or something of that nature. There may be a phone number they give you to dial an intercom, or dialing a phone number, something like that. But they'll tell you how to let them know that you need to deliver a message. When the court employee then answers the summons, you will inform the court employee of what it is that you need. If it's a question that the court's employee, it will have to be written, and the court's employee will bring it to the attention of the court. And as I said before, some questions cannot be answered. If it cannot be, I'll tell you it cannot be. And but if it can be, it will be in all probability. You are to rely on your collective memory when considering the testimony of the witnesses. Now, your initial conduct on entering the jury room is a matter of importance. Your initial conduct on entering the jury room is a matter of importance. It is not wise immediately to express a determination and to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Rather, you should consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Now, the alternate jurors, the four over here and the one who's downstairs, are instructed to remain. The instructions say to remain at the courthouse. Obviously, here's what we're going to do. We're going to give each of you some input here on what you want to do today, whether you want to continue to deliberate any more today or whether you want to come back tomorrow. Once this case is turned over to you, and that's immediately, we're going to let you sort of set your own schedule. In other words, you can work as late as you want, within reason, of course, and then tomorrow, if things aren't decided today, or if you don't deliberate at all today, I will note it's after 5 o'clock right now. That's your choice. But we need to have a time then that you're going to be coming back tomorrow and to begin your deliberations. We need to know that. That's you 12. Now, the other 5, the 4 here and the 1 downstairs, will be here the same hours that the deliberating jury members are here. You'll be here for the same hours, but there's a totally different instruction to each of you. You 12, once this case is turned over, and as I say, that's immediate. When you're at the courthouse, in the deliberation room, in the jury room, you will be discussing the case with each other. As I've just mentioned, you will be doing it. But your deliberation should only be done, your discussion of this case should only be done in the jury room. When you're away from the jury room, the instructions that I've been giving you about not to discuss this case among yourselves or with anyone else, not to permit this case to be discussed with you or in your presence, not to express any opinions concerning the case, not to do any research, not to read, view, or listen to any reports, accounts, or anything like that. Those those instructions apply to you fully when you're away from the deliberation room, when you're away from the jury room. It's only when you are all there together that you should be discussing this case. Now, to you five, the alternates are not to discuss this case at all. You are under the admonition not to discuss this case, but we want you here to make sure that if an alternate is needed, we can put that alternate with, to replace anybody if there's something happen to any of the other jurors before we have a decision reached. At that point, that juror would become a deliberating juror, and the deliberations would have to begin again, including that juror, okay? That's the way we deal with it, totally different instructions as far as discussion of the case. So the alternates, let me say, will not be present in the jury room with the other jurors during deliberation. You'll be kept somewhere else under the supervision of the court employee. You, the alternates, are not to discuss this case among yourselves or with anyone else, or tell anyone how you would have voted until after the jury verdict is returned. After that verdict is returned, then the alternates may, of course, discuss the case with anyone, but are not required to do so. The court will place in the possession of the jury, or at least in your constructive possession, the exhibits admitted into the evidence, and I will also place in your possession verdict forms and and copies of these instructions. When I say the exhibits will be in your constructive possession, we can't put them all in there at one time. I'll explain that here in a moment. The foreperson, you'll elect a foreperson. That person will retain possession of the records until including the verdict forms, and return them to the courtroom whenever you're called back in after the verdict is reached. The foreperson is responsible to see that the discussions are orderly and that each juror has an opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. In other words, the foreperson's view of things is not any weightier, has no more weight than the viewpoint of any other juror. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. After you retire to the jury room, select a foreperson from among your number. With respect to each count of the indictment, whenever all 12 jurors agree upon a verdict, you will sign the verdict form that conforms to your verdict in ink. When the verdicts have been reached on all the counts, on all counts, and upon any of the applicable specifications to those counts, you're to advise one of the court's employees who will be supervising you in the manner that they tell you to, let them know when the verdict is reached as to all counts and specifications. If you need anything at all during the course of your deliberations, you use the same procedure. You summon the court employee and tell them what you need, and really do it in writing. That way there can be no, whatever it is you need. I mean, I guess if you have to go to the bathroom, you can tell them you have to go to the bathroom. But if it's a question concerning the case or anything about the verdict forms or anything about the evidence or anything like that, anything about the case, you should put your request in writing. That's the instruction. After you retire to deliberate, you're not to use any telephone, including cell phones, without first requesting permission of the court to do so. You are, now that's when you're at the deliberation at the courthouse. When you go home at the end of the day, if you go home at the end of the day, of course, I'm not telling you you can't discuss the case. I am telling you that, but I'm not telling you can't use your phones when you're home. But when you're here at the courthouse, whether you're in the deliberation room or otherwise, you should obtain the permission of the court before making phone calls. You're instructed not to use the internet or any electronic media, including email or text messaging without the prior consent of the court. Again, that's during the course of your deliberations here at the courthouse. I also want to say you're not to conduct experiments in the deliberation room either, or to do any type of research or listen to any reports or accounts, of course, of the case. Let me, for just a moment here, go over quickly, and I don't think I have to look at them all, but I want you to, again, to kind of understand here, you'll be given 22 verdict forms. Actually, you'll be given, I guess it's 44 verdict forms, but it's the 22 counts, 2 verdict forms per count. I've gone over the first 8 with you. I went over 1, but the first 8 counts have the same appearance. You have a not guilty verdict form. If that's your verdict, then you would fill that out, you sign it, basically, all you have to do with that one. And that one, that ends that particular count. You don't have to go any farther than that. If your verdict is guilty on any one or more of the first 8, then you have to go down to those special findings. And the first one is did or did not. The state did or did not prove beyond a reasonable doubt that the defendant had a firearm on or about his person, etc. You just look at that. If you put do not, if you fill in do not, then the next 2 findings are superfluous and you don't need to do those. If you put did prove beyond a reasonable doubt that the firearm existed, then you have to go down to, or that he had possession of a firearm, then you have to go down to 2 and 3, which I won't try to quote them, but they're special findings about the firearm itself. One is our muffler or suppressor, whether it was equipped with that. The other one has, I believe it says, displayed or used it to facilitate the offense, or displayed the firearm, indicated he possessed the firearm, or used the firearm to facilitate the offense. But you only get down to the whether it was equipped with a muffler or suppressor, or whether it was displayed, or the defendant indicated he displayed it, or indicated he had possessed it, or used it to facilitate the offense. You only get down to that, of course, if he had a firearm. So if you put no up here, did not, then you don't go down to the next 2. The first 8 counts that's the way those are written. Some of the other counts have no specifications to them at all. For example, number 9 has no specifications. It simply is a verdict of one verdict form of find beyond a reasonable doubt the defendant is guilty. One finds that the defendant is not guilty, and some of them are like that. Then you get into some of the later accounts. For example, the last one, number 22, that I just read, has the same 3 specifications to it as counts 1 through 9 have. Look at the verdict forms, and I think you won't be intimidated by them if you read them. I think that they're pretty straightforward. But my thinking on that may be wrong, and if you do have a question about them, as I indicated, ask your questions. So if any of these forms get, I don't know, spoilated for any reason at all, I guess I should say, we can regenerate the form too. But if that happens, don't just wad it up and throw it away. Let us have it, because it might, we need to go over what the problem is with you if there is a problem with that. So does counsel have anything, do you want to make a suggestion or about any additions we need to include with our instructions to the jury? Yes. Let me ask, there's a couple ways I'd like to get your opinion on this. We're talking to 12 people, really. It's 12 voting jurors at this point. And the question is, do you want to go to the jury room today, or do you want to go home right now, or do you want to go home? The point is that you can deliberate as long as it's reasonable. I want you to be comfortable with when you start and how late you go.
One of the jurors has a conflict this evening. She has
Okay.
to pick up.
Okay. So is it the consensus of all of you that you would prefer to just to come back tomorrow if you had your preferences? It's a pretty late hour, but I want to do what you want to do. Come back tomorrow morning? Now, what time do you want to start tomorrow morning? You want to start at 8? Okay. Well, now, will council want them to come up here to count the notices, or just go directly to the
I think they can probably just go directly
jury room?
to the jury room.
Just go to the jury room?
Yes, at the appointed time.
All right, okay. That's if you wish to do that, that's fine. We'll have a court employee there to supervise you. Is that what all of you want to do? Let me put it this way. If that's bad for anybody, raise your hand so I'll know. Okay. Unanimity then. Begin at 8 tomorrow.
8:30.
What is it?
8:30.
8:30, okay. All right, 8:30 tomorrow. That's fine. And understand that this is the court doesn't participate, counsel doesn't participate in these deliberations whatsoever. You know, this case is yours to decide at this point. We will make sure that in there are some of these exhibits that they talked about being in there. We'll make sure that there will be the copies of the jury instructions in there, and the verdict forms will be in there. The court employee will open up for you and all of that, count notices, make sure we have 12 deliberating jurors. You don't begin until you're all 12 there. And if there's a problem with that, and for any reason, you need to bring that to the attention of the court. The court we'll still be doing court business up here, and we'll deal with any kind of problem like that. But do not begin the deliberations until you're all 12 together. I want to also mention that that your deliberating process is a secret process while it's going on. In other words, no one should inquire of any of you what you're doing or what you think about this or that about. They should not discuss this case with any of you. I don't predict that's going to happen, but if it does happen, you need to not say anything, but report to the court employee who will report to me that because this is your deliberations are between you 12 and you 12 only. And I'm available only if there's a question or a problem, which then you write what question or problem is. You don't have to be Ernest Hemingway or anything, but you can just put together what you think it is. And give that to the court employee, and that person will bring it to me, and we will try to handle it if it can, whether it's an explanation, definition, whatever, if it can be. Some things cannot be answered. Some things must just be done based on your collective memories and the evidence and everything where it is. But if you think there's something that you need from the court, write it out, give it to that person, they'll bring it to me. Now, you five, you four, and the one downstairs are coming in at 8:32, 8:30 also, and you'll be also received by a court employee, but you'll be put in a separate place from these, okay? And you're not to discuss this case among yourselves or indicate anything about your feelings about or opinions about anything about the case. You're under the same strict admonition as you were under during the course of the case. You 12, are not to discuss this case, as I said before, until you are all 12 in that room with nobody else in there and the door is closed, and then then that's your job, is to deliberate. But the first job, elect a foreperson, okay? And that foreperson will deliver the messages to the court employee and will let us know when you've reached a verdict or that kind of thing. It will take charge, really is responsible to make sure that the verdict forms are where they're supposed to be and all that. Do any of you have any questions about, yes?
Should we take our notebooks downstairs today or will we bring them to us tomorrow?
No, leave those here right now. Well, that's an interesting question. Should you take them down there now? Can we lock that up down here?
We can, yes.
Okay. Then yes, you can take those down to the jury room, and we will lock the jury room and unlock it tomorrow morning when you come back, so they'll be safe in there. What else do I need to think about here? I think that pretty much answers everything, and we'll have other stuff taken in there. We'll have the copies of the instructions, verdict forms, and I don't know whether we'll move any of the exhibits in there tonight or not. I guess it can be locked. Yeah, all right. So maybe it'll be tomorrow morning before the exhibits get to you. But they'll be down there early enough that your early start will be beneficial. And then you just need to tell us about your schedule. I mean, you're just deliberating until the case is decided, and your schedule is pretty much up to you. You're just going to tell us what you're doing. If you and so if you have any, I mean, not how you're discussing, but tell us your timetable. If you need to, we'll decide. We'll feed you down there, and so that you continue your deliberations. Once you report tomorrow morning, you're probably going to be here all day long. Okay. Any other questions about anything? All right.
Here's your Judge.
Question.
Yes.
What should the alternates do for our notebooks?
Say it again.
What should the alternates do with our notebooks?
Since your alternates, I would say you do with those what you have been doing with them. Leave them there, and I will have a court employee take charge of those so that they're secured for you. We won't read them or anything like that, but you shouldn't take them with you to. Well, let me think about that for a minute. I guess I don't want you discussing the case, and so they shouldn't be taken home. No, but I would say today leave them there. Once we get you in place tomorrow, I don't know. We may give them back to you at that point. But they'll be taken care of safely. These notebooks, as I said before, they're for use in the jury room during your deliberations for your purpose. The fact that somebody took notes doesn't mean their opinion or their remembrance of what they remember of the evidence is any more reliable than those who did not take notes. I explained that all to you before, and those notebooks will be destroyed after a verdict is reached. All right. So tonight, everybody, you're taking yours to the jury room. You're leaving yours on the table there until we know where we're going to place you and make sure where we put you tomorrow, and then on your seat there, and then we'll deal with those. Any other questions? All right. Remember again, do not discuss this case among yourselves or with anyone else. Do not permit the case to be discussed with you in your presence by anyone. Do not express an opinion concerning the case when you're away from the jury room. Do not read, view, or listen to any reports or accounts of the case. Do no research at all concerning the case from any source at all, and have no contact with any of the participants, including parties, counsel, or witnesses. Anything further from either party before? No. All right. All right, then we are adjourned. Terry, could you take them down? Okay. before we take the jury instructions down, did anybody see any typos or anything?
Yes, we did. I did.
Okay, do we want to change typos?
But I don't know if, yeah, the one is, I think, particularly important, but.
Page 100, Your Honor.
100?
Yes.
Let's see, I'm going to use this one for that.